Good morning, council's interested parties. We're here on the record in the matter of the state of Georgia versus Khalif Adams et al. In 22 SC 183572. Go ahead and take roll for the morning. Mr. Stillwell, Mr. Sharp, good morning.
Good morning.
All right. Mr. Williams, Mr. Steele, and Mr. Adams, and Ms. Renard. Good morning, council. All right. Mr. Kendrick, and let's see, Mr. Weinstein. All right. Mr. Huey and Mr. Matthews, Jr. Good morning, sir. Good morning. Mr. Nichols and Mr. Harvey, Mr. Garner, and Ms. Westmoreland. Good morning, all. And Mr. Ryan and Misty Williams. Good morning. All right. Mr. Floyd and Mr. Uhelski, good morning.
Good morning, Your Honor.
Okay, all right. Okay, council is consistent with our business for today. I have several things I need to take up with you all. And since Mr. Floyd, you are here, I assume that you're going to argue on behalf of the state the response to the plea and bar motion to dismiss General Demur. Is that correct?
Yes, Your Honor.
Okay, all right. I had some other stuff. Is Ms. Love and Ms. Hilton going to be back later on?
No, they will. We're kind of divided at this time, as you may know, across the way there in 1B. Ms. Love and Ms. Hilton are before senior judge see at this time. They're going to be back over here as soon as that's complete.
Okay, all right. Okay, fine.
For the record, Your Honor, they'll be needed for every other matter, I think, before this court decides this clean bar.
Okay, all right. Okay, Mr. Steele, are you prepared to, at this point in time, to take up your matter?
Always.
All right.
Good day.
You only got 15 minutes, I'm telling you.
It's a 15-minute issue, but if you stop me, then I will,
Well,
Tell me when, I'll make the record,
Okay.
and in your absence or whatever, but obviously I gotta do this perfect. And Your Honor, happy holidays to the court reporter, who has been unbelievable, prosecution team, Mr. Floyd, good to see you, and everybody here, and thank you, Mr. Adams, let me work with you on this case. And Mr. Williams. Your Honor, we did file, what you just said, the plea and bar motion to dismiss General Demur.
that was filed on the 11th of, I should say 2nd of November of this month, and the state's response was filed on the 9th of this month, which I both read and considered.
So, Your Honor, I have some cases to make it a little easier, hopefully, for everybody as we go along. Can I approach, Your Honor?
You may, sir.
So, Your Honor, in support of our plea and bar, this challenges every count of the indictment that Mr. Williams is in. Count 1, the RICO count that affects every person wrongly charged here. And then count 56, 57, 58, 59, 60, 61, and 62 regarding Mr. Williams. And I'm first going to give the Honorable Court an answer to your questions. But the first case I've given to the parties in this Honorable Court is Heath, H-E-A-T-H versus State. It's 394 Georgia Appeal 84, 825 Southeast 2D 474. It's 2019. I had the honor of representing Ms. Heath on appeal. I was not the trial lawyer. The Court of Appeals wrote, and it's on the first page, right-hand side, beginning of the opinion, Your Honor. After jury trial, Christine, which is K-R-I-S-T-I-N-E, Heath, was convicted of homicide by vehicle, first degree, homicide by vehicle, second degree, 5 counts of serious injury by vehicle, failure to
I read it, and that was the case involving a serious injury by vehicle, and the major issue turned on because defense counsel did not file this particular motion. They were ineffective, correct?
Yeah, and in it specifically on page 3.
So I'm having an issue with the timing.
Exactly. And jeopardy attached. That's why I didn't file it previously. That's what I've been taught by the courts. So once we had the jury, that's why I filed it, I think, the next day after jury selection. And what the court tells us is on page 3, right-hand side, first full paragraph, Heath argues that trial counsel was ineffective for failing to file a general demurrer because the indictment omitted material elements of the counts charging homicide by vehicle and serious injury by vehicle, which is what we're doing. There are elements that are material in this indictment on the counts I just said that are not pled. On page 4, Your Honor, of 10, on the left-hand side, 6th line, in that regard, to withstand a general demurrer, an indictment must recite the language of the statute that sets out all, I stress all, the elements of the offense or allege the facts necessary to establish violation of a criminal statute. If either of these requisites is met, then the accused cannot admit the allegations of the indictment and yet be not guilty of the crime charged. However, an indictment which omits an essential element of the predicate offense in a count charging a compound offense, such as vehicular homicide or serious injury by vehicle, can nonetheless satisfy the requirement of due process as long as the indictment charges the predicate offense completely in a separate count. An indictment alleging merely that the accused acts were in violation of a specified code section is defective. We won that appeal. The Honorable Court of Appeals of Georgia granted the relief I sought. The state of Georgia then sought and received cert from the Supreme Court of Georgia, and that's the next case, State versus Heath. That's why I flipped the title. And that's 308 Georgia 836, 2020 case. And on page 3 of 4 of the copies I've given this Honorable Court and the parties, the state was arguing that there was no surprise, that Ms. Heath knew exactly what she's charged with, as did her lawyer. And then at the very bottom of 3 of 6, Your Honor, 4 lines up on the right-hand side, for purposes of a general demurrer, however, it matters not that the defendant has notice of the charges. That is because a general demurrer challenges the substance of the indictment and asserts that the indictment is fatally defective and incapable of supporting a conviction. If a defendant can admit each and every fact alleged in the indictment and still be innocent of any crime, the charge is subject to general demurrer. and a general demurrer, as you just said, Your Honor. It's on the right-hand side, page 406, first full paragraph. 8th line down on the right-hand side, we first note that because a general demurrer challenges the validity of the indictment, a general demurrer may be raised after jeopardy has attached at any time during trial. So, as the court already noted, it is timely, and if you deny it, but the appellate court agrees, or the Honorable Supreme Court agrees, Mr. Williams and the others are placed in jeopardy, they cannot be retried. This ends the case. The next case, Your Honor, is Tate, T-A-T-E, hyphen Jesurum, J-E-S-U-R-U-M versus State. Your Honor, that's 368 Georgia Appeal 710, 2023 case. And in this case, the Court of Appeals of Georgia wrestled with whether a demurrer was good because the Supreme Court of Georgia on a drug offense, which affects Mr. Williams in his substantive accounts, and it affects other people, possession of drugs with intent to distribute. I know it affects Mr. Stillwell. I know it affects Mr. Nichols and others. The wrestle was the indictment, the grand jury did not allege knowingly. The Supreme Court of Georgia has said that a person, if I just possess cocaine and I'm charged with intent to distribute, it's not the intent to distribute, it's the knowing possession of cocaine. Because if I have something that I don't know is cocaine, then I am not guilty of that crime. It's not a strict liability crime. I have to know that I'm possessing cocaine. That became an element of the offense by the Supreme Court of Georgia. It's not in the statute. The majority opinion, 2 judges, the Honorable Judge Rickman, writing for the majority, 2 judges in Court of Appeals, said no, that indictment is good. Yes, the indictment did not charge knowingly. Yes, knowingly is a material element of the charge. Yes, the trial court must, and you're going to have to, if it goes that far, Your Honor, charge on the knowing or the mens rea requirement. But if the indictment says the word unlawful, unlawful has this great umbrella, and that means knowing, that means it was charged. The dissent is well written, well thought out. The Honorable Judge Dillard, D-I-L-L-A-R-D, and Judge Dillard wrote the dissent, Your Honor, and he's obviously one judge, so it's the dissent, and that starts on page 4 of 9, and he said, that's wrong. He said that, and it's on 4 of 9 on the right-hand side, 7 lines down to the right. But importantly, an indictment is to be strictly construed against the state when a general demurrer has been filed against it. On page 5, Your Honor, Judge Dillard goes through the history of an indictment. And on page 5 on the right-hand side, first full paragraph, Judge Dillard wrote, but the jurisprudential landscape has changed dramatically since Dye, which is D-Y-E, that's the case. And most of its progeny were decided. Indeed, as the Supreme Court of Georgia has explained, the omission of mens rea from an indictment renders a charging instrument void because it is an essential element of the crime. And in doing so, our Supreme Court noted that if an indictment fails to allege all the essential elements of the crime or crimes charged, including the required mens rea, it violates due process, is void, and cannot withstand a general demurrer.
That's the dissent, right?
Exactly, 2-1. And on the right-hand side, Your Honor, Judge Dillard notes on page 6 of 9, 1, 2, 3, 4, 7 lines from the top. Finally, our Supreme Court has also explained that the adjective, quote, unlawful, end quote, means not authorized by law, illegal. It does not mean this, you know, this all-encompassing mens rea of knowingly. And that's what Judge Dillard wrote in the next paragraph, fifth line. Unlawfully does not sufficiently act as a substitute for the essential element of knowledge or knowingly in charging documents. And this is a drug case, Your Honor, so it's going to be relevant here. And I'll get to the indictment in just a moment. So the issue here is whether the indictment is proper as to count 1, which is the RICO conspiracy count, as well as the other counts charging Mr. Williams. And I know everybody here adopts this motion for their own use. The next case, Your Honor, is XIULU, Ruan, RUAN versus United States. Your Honor, this is 142 Supreme Court, 2370. It's 213 Lawyers Edition 2D 706, 2002 case. And here, on the case that I've given, or the copy of the case I've given the sound recording the parties, on page 8, it's in Division 2A, as in Elisa and Alpha, on the majority opinion. And here, the Honorable Supreme Court of the United States, which we follow, wrote, first, as a general matter, our criminal law seeks to punish vicious will. Next paragraph on the right-hand side on page 8, last paragraph. Consequently, when we interpret criminal statutes, we normally start from the long-standing presumption traceable to common law that Congress intends to require a defendant to possess a culpable mental state. We have referred to this culpable mental state as scienter, S-C-I-E-N-T-E-R, which means the degree of knowledge necessary to make a person criminally responsible for his or her acts. Applying the presumption of scienter, we have read, and this is what I'm stressing, we have read into criminal statutes that are silent on the required mental state, meaning statutes that contain no mens rea provision whatsoever, that mens rea, which is necessary to separate wrongful conduct from otherwise innocent conduct. Unsurprisingly, given the meaning of scienter, the mens rea we have read into statutes is often that of knowledge or intent. When a statute is not silent as to mens rea, but instead includes a general scienter provision, the presumption applies with equal or greater force to the scope of that provision. We have accordingly held that the word such as knowingly modifies not only words directly following it, but also those other statutory terms that separate wrong from innocent acts. On page 12 of 25, Your Honor, in Division 3, at the very bottom of the left-hand side, in the center, the court wrote, compare, or United States versus RESENDIZ versus hyphen Ponce, PONCE, 549 U.S. 102, and then the 2007 case, criminal indictment must set forth all elements of the charged crimes. In this case, Your Honor, as Tate Jerson, in my irrelevant opinion, suffers because the Court of Appeals majority opinion, the two judges, did not read into the statute what the Supreme Court told us, that you have to have a knowing element for a drug offense. The next case is Elonis, E-L-O-N-I-S versus United States. It's 575 U.S. 723, 2015 case. Your Honor, on page 9 of 35 of the copy I've given this honorable court and the parties. In Division B on the right-hand side is in Barry and Bravo. The High Court wrote that the fact that the statute does not specify any required mental state, however, does not mean that none exists. We have repeatedly held mere omission from a criminal enactment of any mention of criminal intent should not be read as dispensing with it. This rule of construction reflects the basic principle that wrongdoing must be conscious to be criminal. On page 10, Your Honor, left-hand side, 8 lines up from the bottom paragraph, the court wrote, we therefore generally interpret criminal statutes to include broadly applicable scienter requirements, even where the statute by its terms does not contain them. And this is all called, Your Honor, the mens rea doctrine. So, getting to our case, Mr. Williams' case, and everyone is involved in this, if you look at the indictment, which is 22 SC 183572, State Georgia versus Mr. Adams et al., Your Honor, the first count is a conspiracy to violate the Racketeer Influence and Corrupt Organization Act. And when you look at that indictment as a whole, which I have done multiple times, the state
You
of...
gave me the wrong indictment.
You have the indictment? You say you have the indictment, right?
No, I said, you might want to take a look at this one.
It's coming next.
Oh,
So I did not give you this indictment. I thought you had it, but I can hand you, with the state's permission, my copy.
no. Are you talking about the indictment in this case
Yeah.
or the Trump indictment?
Our case.
Okay. This is what you handed me.
I know, I thought everyone had our indictment.
No, you handed me the Trump indictment.
That's coming next.
Okay, all right. I have our indictment. Okay.
Yes. So on page 12, Your Honor, if you look at our indictment, page 12,
All right.
the grand jury alleged, on the top of that page, with the offense of conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, 16-14-4C is in Colette and in Charlie, for said accused, together with unindicted co-conspirators in the state of Georgia, county of Fulton, on or between 24th day of January 2013, the 8th day of May 2022, and this is where I stretched, did unlawfully, there's that word again, conspire to acquire and maintain directly or indirectly an interest in and control of the United States currency, other personal property, through a pattern of racketeering activity in violation of 16-14-4, A as in Elisa, and Alpha, and while associated with an enterprise did unlawfully, again, conspire to conduct and participate directly and indirectly. So that's from the statute, but what the Supreme Court of Georgia has told us, what the Court of Appeals of Georgia has told us, is the following. May I approach, Your Honor?
You may. Mr. Steele, it certainly would have been nice for you to send me these cases earlier, so I could have read them.
Okay, and I would always want to. So the first case is MacArthur, M-C, capital A-R-T-H-U-R versus Beach, which is spelled B-E-E-C-H, Haven, H-A-V-E-N, Baptist Church of Athens. Your Honor, if you look at page 8 of 11 of this case that I've handed out to this honorable court and the parties, on the right-hand side, 5th line up, center.
What page?
8 of 11. The right-hand side, 5th line up from the bottom in the center. The Honorable Court of Appeals wrote, the RICO statute also prohibits a conspiracy to violate the statute, and they cite to footnote 41, which is what we're charged with, OCGA section 16-14-4C, as in Colette and Charlotte. Under Georgia law, a person may be found liable for RICO conspiracy, and this is what I stress, if they knowingly and willfully join a conspiracy which itself contains a common plan or purpose to commit 2 or more predicate acts. The next case, Your Honor, is Cotman, C-O-T-M-A-N, versus State, which is 342 Georgia Appeal, 569, 2017 case. Your Honor, on page 17 of 22 of the copy I've given this Honorable Court, cases that I know about. So, this is not,
I'll wait, okay, I mean, Mr. Steele, I understand. I'll wait and hear what Mr. Floyd has to say about that, but...
no, unless you tell me not to, I'd like to answer your question. But if you look at the word unlawful, unlawful means illegal.
But that's what the statute tracks.
But
So how can I be asked to include something else that the statute doesn't necessarily require? I mean, I know that the state always, has to prove for a conspiracy or for other criminal charges, we offer the jury intent, right?
you have to.
I mean,
Well,
the state's required to prove that, right?
and it's not in the indictment. I mean, if you just think that through, the old law,
But does it have to be in the indictment?
yes, those are the Supreme Court cases I gave you, and that is exactly the dissent in Tate Jerusalem that's on cert. And if you think it through, I'm going to request charges on knowing and willful, a conspiracy. You have to join it knowing and willful. I believe this honorable court will grant that. It will charge on that. You are now charging on essential elements that are not alleged in the indictment. If you just think that through, there is a disconnect. And yes, Georgia courts held that for a long time, but as Judge Dillard writes, he writes a good dissent. He goes through the history. He said that law changed years ago. And that's what I wrote to you, or read to your honorable court on page of the dissent. Page 5 of 9, on the right-hand side. Judge Dillard wrote, it's the first full paragraph, but the jurisprudential landscape has changed dramatically since Dye, and most of its progeny were decided. Indeed, as the Supreme Court of Georgia has explained, the omission of mens rea from an indictment renders the charging document void. Unlawful is not a mens rea. Unlawful means illegal. Well, I could illegally be holding cocaine. Doesn't mean I know I'm holding cocaine. You're going to have to charge on knowledge. Otherwise, your charge is defective because you're not giving an element of offense. And the element of offense, the grand jury buying through the Fulton County District Attorney's Office with all their resources, they blew this indictment. They failed to do it. And that's why I gave you Donald Trump. It's not like this is unknown. They failed to do it. So, I accept whatever this honorable court's ruling is, and if it's adverse, I believe I have a dual track. I will obviously go on trial, but I just respectfully request if you can get your order in, I will file a notice of appeal. It's a direct appeal. It will not stop our trial, it's my understanding, and I will ask the appellate court to take this up during our trial, and if they grant it, then we could abort the trial at that time. Count 56 and 57 are the same exact issues. Now we're dealing with Mr. Williams charged wrongly participation in criminal street gang activity. And it says again, and I'm reading 56, Your Honor, OCGA 16-15-4D, as in David Delta, for the said accused, County of Fulton, State of Georgia, between 12th day of May 2018, 8th day of May 2022, while occupying a position of organizer, supervisor, or other position of management or leadership of the criminal street gang YSL, did engage in, directly or indirectly, or conspire to engage in any one of the following acts of criminal street gang activity of YSL, to wit, murder, aggravated assault with deadly weapon, armed robbery, hijacking a motor vehicle, sale of marijuana, possession of marijuana with intent to distribute, theft by receiving a firearm, and possession of a weapon by a convicted felon. And then on 57, same crime, that targets the 9th day of May 2022, did unlawfully, again, that's all it says is unlawfully, while associated with criminal street gang YSL, participating in criminal street gang activity through the commission of at least one of the offenses enumerated in 1 of 16-15-3, possession of marijuana with intent to distribute, possession of codeine with intent to distribute, possession of cocaine, possession of firearm during commission of felony, as alleged in count 58, 59, 60, and 61 of the indictment. If you look, Your Honor, at Rooks, R-O-O-K-S versus State, case I gave you.
I've read Brooks.
Not you.
I've read Brooks.
Okay.
But what do you want to point my attention to?
Say it one more time.
What do you want to point my attention to?
Okay, and it's, if you don't mind, I'll just cite it for the record. It's S23A0783, is decided October 24th, 2023, and on page 10 of 21 of the copy of the ensemble court, and the parties on the right-hand side. The first full paragraph, bottom, the Supreme Court of Georgia wrote, "The evidence also was constitutionally sufficient for a jury to find Rooks and Clark guilty of the criminal street gang crimes which they were convicted," and then this is what I'm stressing, "to establish that Rooks and Clark participated in criminal street gang activity under 16-15-4, little a's and Elisa alpha. The state was required to prove 4 elements. 1, the existence of a criminal street gang, defined in 1615-3-3, as an organization, association, or group of 3 or more persons associated in fact with a formal or informal which engages in criminal gang activity. 2, the defendant's association with the gang. 3, that the defendant committed any of several enumerated offenses, including those involving violence, possession of a weapon, or use of a weapon. And 4, and this is what I'm stressing, that the crime was intended to further the interests of the gang." Those are material elements. There is nothing in count 56 or 57 for any of these other people who are charged with criminal street gang activity that says that the crime was intended to further the interests of the gang. 56 and 57, Mr. Williams can admit that he committed those acts. He can admit that. And just like count 1, the indictment is fatally defective because it does not set forth the elements. Mr. Williams demur as opposed to this.
Is it any other place in the indictment, in the preamble or anything such as that?
No, because this is not the count 1. This is its own count of criminal street gang activity. So the answer to your question is no.
You said 56 and 57?
Yeah, if you look at the indictment, you're on page 90.
I have it. Okay.
So in those 2 counts, I'll just take them together, they failed to allege the essential element that we're going to ask the court to charge on. So you are charging on essential elements that are not contained in the indictment. The state is going to rely on the word unlawful. That is all they're going to do. They're going to say, well, the statute says unlawful, and they're going to ignore. They will have 0 case law that says you can ignore what the United States Supreme Court has taught us, and the Georgia Supreme Court has taught us that when the statute is silent as to the intent, as to the mens rea, courts step in and mandate that that's an essential element. And that's the Alanis, E-L-O-N-I-S versus United States case I cited earlier, as well as X-I-U-L-U Ron versus United States, which I cited earlier, and it's called the mens rea doctrine. Otherwise, all your court would charge is it's unlawful to do this criminal street gang activity. Mr. Williams doesn't have to do anything to promote the interests of the gang, which we know is wrong. That's what Rodriguez was about. That's what the court needs to charge the jury. So you're charging the jury on something not pled by the grand jury, and you're going to go back to, not you, but it puts us back in time to a fairly defective indictment. And the state, of course, is going to pound the table and say that's preposterous, we're tracking the statute. Just like the majority in Tate Jerusalem, they drew a much well-thought-out dissent in Tate Jerusalem, and it's on appeal, and they're ignoring that. They'll agree that you have to charge on these essential elements. So how is it not in the indictment? The next counts against Mr. Williams, Your Honor, is count 58, 59, 60, 61. They also include Mr. Kendrick, in all of those counts, so it applies to him, and 62. And in all of those counts, Your Honor, the first four, 58, 59, 16, 61, are violation of the Georgia Controlled Substance Act, and then they're different. It's possession of marijuana with intent to distribute is 58. Possession of codeine with intent to distribute is 59. 60, Your Honor, is possession of cocaine. 61 is possession of a firearm during the commission of those crimes: possession of marijuana with intent to distribute, possession of codeine with intent to distribute, and possession of cocaine, simple possession of cocaine. In all of those counts, Your Honor, the state fails to charge knowingly. That is a element of this offense. So when Mr. Williams puts up a defense that he did not know that there was codeine, did not know there was cocaine, did not know that there was this gun, the juries are going to have to decide that, and you're going to have to charge it. The state proved beyond a reasonable doubt, if you charge it, I will ask for it, that Mr. Williams had this knowledge. The Supreme Court of Georgia has written in the mens rea into the statute, because the statute only says unlawfully, and the Supreme Court of Georgia said no. There has to be knowledge, and that's on page 3 of 9 of the majority opinion of Tate-Drewsome versus State. In the first full paragraph on the left-hand side, the two judges said, nevertheless, Tate-Drewsome argues, and the dissent agrees, that in Duval, D-U-V-A-L-L versus State 289 Georgia, 540-2011, the Supreme Court abrogated, within the context of an indictment alleging possession of a controlled substance in violation of 161330A, both the legislative directive of 17-7-54A and the well-established pleading rules upon which the courts and prosecutors of this state alike have relied for decades, but Duval cannot be so construed. To be sure, the Duval court held that possession of controlled substance is not a strict liability offense, and therefore the state must prove that an accused both knowingly possessed the drug and also knew that the drug he or she possessed was a controlled substance. That is my issue. I understand that the two judges in Tate-Drewsome said, but we're ignoring that. That's just for a charge. But I disagree vehemently on reading. You know, I loved it. As the court did, I love this. I mean, this is, you know, it's interesting. It's fabulous. And this indictment is fatal. It should have charged the mens rea. And you're going to be asked to charge. And I believe that you will charge. I mean, you'll follow the rules. But the issue, Your Honor, we just take off all these cases, just throw everything away. You are charging on elements of the offense. You will tell the jury, you must find for these drug offenses that Mr. Williams knew that it was cocaine and knew that he possessed that cocaine. That is not in the indictment. If it's not in the indictment and you're charging as an element, there's not much of a road to climb to realize that the indictment is bad. It left out facts. If the word unlawfully is so broad, and this is what the two judges said in Tate-Drewsome, I ask for you to disagree with them. It's not binding on you. If you do that, I'm telling you, you are ending the case. Mr. Williams is walking out. So I'm telling you that. Now the state obviously has the right to appeal, but it's double jeopardy. The jury's here. This is a great issue for Mr. Williams. If, God forbid, I was charged with crimes, I'd want this indictment because it's fatal. And I don't know, I had nothing to do with it, but the grand jury should be taken to task if they want to bring a good case in Fulton County. And the last one is the same thing, Your Honor. It's the same exact issue. It just deals with possession of a firearm within the confines of the marijuana with intent to distribute, possession of codeine with intent to distribute, possession of cocaine. That also has the knowledge requirements. And then the same as 62, possession of a machine gun. You have to knowingly possess the gun with the converter switch and the extended magazine. The state did not allege that either. They have failed to assert a material element in the indictment. I wish to answer all your questions. That is it. Mr. Floyd is a tremendous advocate and an honorable man, but his reasons are wrong. And he's just going to take up the mantle for the state and take Jerusalem, which is not binding on anyone, but he can never, ever get around the fact that this honorable court will be charging on elements not included in the indictment. That's what the indictment needs. Mr. Williams can admit every essential element of this indictment, say, I admit everything, and he is not guilty of a crime. I ask the court to grant it. If you don't grant it, Your Honor, then I ask that you can just please decide to write the order and impose the order, because I believe I'm correct that I can appeal it during our trial. I will not hold up our trial. We'll do openings, we'll do everything, but this case will go up expedited. I will explain to the appellate court we are on trial. The man it's a double jeopardy case. Take it. They may not, they may just put it because it's direct appeal. It's a final order denying a plea and bar, so they'll put it in the queue. I would hope they put it, I have no idea if they'll expedite it, but within 5-8 months we will have a decision. We'll still be on trial. I want to thank the court. If you don't have any other questions, otherwise, as always, Your Honor, thank you so much.
Okay. Thank you, sir.
Good morning, Your Honor.
All right, good morning, Mr. Floyd.
So I did not have, prior to this, the advantage of the cases that Mr. Steele has cited. His motion cites no cases regarding count one. However, the fact of the matter is that he is incorrect on his argument. I'm going to argue with regard to count one. And let me walk through that. The indictment charges that the defendants unlawfully conspired. The governing law makes it abundantly clear that that is sufficient. In this particular context, they were charged with conspiring to violate 1614(4)A, a crime, and 1614(4)B, a crime. So we have two layers. They have a criminal objective, and they committed a crime by conspiring to do so. Notably, only 3, I believe, of the cases cited by Mr. Steele were RICO cases. He did not cite the governing cases. I will distinguish his and lay out the ones that we believe are controlling. Beginning with that is Evans. That is Evans versus State. It is 360 Georgia Appeals 596. On page 612, the court expressly rejected the argument that specific intent to violate the law is an element of a RICO conspiracy, and that the trial court erred in failing to charge the jury on this specific intent requirement. Evans is not a 2-1 decision. It is not on cert. It is a 2021 RICO conspiracy case. It is directly on point. It is binding on this court. That, candidly, is the end of that. The Evans is itself consistent with the Supreme Court's ruling in Dorsey and a host of cases cited in Dorsey. Dorsey is 279, Georgia at 534. At 540, the Supreme Court makes it clear that a RICO violation, he was talking substantive there, requires only 2 acts of racketeering activity. And here I should point out, Your Honor, Mr. Steele spoke as if acts of racketeering activity themselves have no mens rea requirement. and as though, therefore, that RICO somehow functions on its own without any mens rea requirement, and that you have to read it in, and you have to read it in not only as a requirement of the statute, but as a requirement of an indictment. There is no Georgia support for that whatsoever, none. Dorsey makes it abundantly clear that if two related acts are proven, that is sufficient to support the indictment. That is sufficient to support a conviction. This issue is not a new one. In the 11th Circuit rejected this argument in United States versus Pepe in 1984. In that case, and speaking of jury instructions...
How do you spell Pepe?
I'm sorry, Papa Echo, Papa Echo.
Okay.
In that case, speaking of jury instructions, the challenge was that the district court erred in declining to instruct the jury that participation in the enterprise's affairs had to be knowing and willful. The court rejected that. Without these elements of mens rea and scienter, appellant's claim, RICO would become a strict liability measure. Sound familiar? The 11th Circuit said, we disagree. They had already decided this in a case called Dicedue, D-I-E-C-I-D-U-E. It's at 603 F second, and specifically the pin site was 548 there. We rejected this contention. A plain reading of the statute indicates that RICO does not contain any separate mens rea or scienter requirements beyond those encompassed in its predicate acts. I was quoting Pepe there at 675 and 676. In this regard, there's no material difference between the Georgia statute and RICO. They both use unlawfully. It's the same formulation. Other federal courts long ago disposed of this argument. An example is United States versus BAFA, Bravo, Oscar, Foxtrot, Foxtrot, Alpha, 513 F Sup 444, in which the court observed that RICO does not itself contain an express intent requirement over and above that required by the individual crimes. Consequently, no specific intent to engage in an unlawful pattern of racketeering activity prohibited by RICO necessarily need be alleged in an indictment. Similarly, the Second Circuit in Boylan, also in 1980, 620 F Second 359. Boylan is spelled Bravo, Oscar, Yankee, Lima, Alpha, November. I quote from page 361 and 362. RICO count does not include a scienter element over and above that required by the predicate crimes. And the Second Circuit, also in 1980, in United States versus Scotto, Sierra, Charlie, Oscar, Tango, Tango, Oscar, 641 F Second 47 at 56. Again, a case in which the defendant argued that a willfulness instruction should have been given to the jury. The law at issue here does not demand willful violations of the RICO statute, the Second Circuit concluded, nor does it require willful violations of the predicate offenses. Here, as in Boylan, which I just referred to, we think the court's charge was favorable to the defendant because it permitted conviction only if the jury found a criminal motive or purpose. Even the cases cited by Scotto do not require as much. So there, the trial court actually sort of overshot the mark and gave a more demanding instruction than the statute required. But the court went on to say, it went on to observe that RICO has no separate mens rea requirement. And I quote, "We have no reason to believe, however, from the words of the statute or from general criminal law doctrine, that the quantum of mens rea required for a RICO conspiracy conviction should be different from or greater than that required for a substantive RICO offense." So these are the actual RICO cases that have actually dealt with this issue. What Mr. Steele is doing is attempting to tease out of the dissent in Tate Gesserum a ruling trying to get you to follow it. Tate Gesserum is not a new novel case. Its ruling was basically that unlawfully was sufficient to track the requirement of mens rea. It cited prior Georgia Supreme Court cases. To hear Mr. Steele argue it, you would think that this fell out of the sky. One of the cases that are cited is Humphrey versus State, 231, Georgia 855 and 861, a 1974 case. All right, which held that the allegation of criminal intent is necessarily inferred from an indictment that charges an offense in the language of the statute and alleges it was committed unlawfully. That is exactly what the state did here. Charged in the language of the offense and alleged that the conduct was engaged in unlawfully. Other Georgia cases, not limited to physical precedent, not with a dissent, include, and this one is a bit of a mouthful, I apologize, Stevo-Stianova, Sierra Echo Victor Oscar Sierra Tango India Yankee Alpha November Oscar Victor Alpha versus State, 313 Georgia App 729, a 2012 Georgia Court of Appeals case, no dissent. Said that the term unlawfully in the accusation with reference to the appropriate code section sufficiently included the intent to commit the criminal act and the knowledge necessary to form such intent. Appellant could not admit the allegations of count one and remain innocent of the charge alleged therein, thus a general demur to the accusation would not lie. Those last two sentences are fully applicable here. Again, a 2012 decision. It's not just that Tate Gesserum is a majority case, it's that Tate Gesserum reflects a long-standing body of Georgia law. Another example is State versus Meadows, 252 Georgia Appeals at 376. It said that use of the word unlawfully instead of the word knowingly was sufficient to charge the defendant, in that case with committing arson, with the requisite intent. There it was citing a case called Frost v. State, 200 Georgia Appeals at 267. In Meadows itself, the court said similarly, in this case, the use of the word unlawfully was proper in charging Meadows with 2 counts of simple battery. This is not new law. This is not controversial law. This is not uncertain law. I mentioned Humphrey previously, the Georgia Supreme Court decision from 1974. The quote there at page 231 Georgia at 861, the present indictment charges this offense in the language of the statute and alleges it was committed unlawfully, from which allegation the criminal intent is necessarily referred. And Humphrey itself was not new. It cites 2 rather old Georgia, an older Georgia Supreme Court and an older Georgia Court of Appeals case. Again, not new law, not controversial law. That takes us to the cases cited by Mr. Steele. State v. Heath, not a RICO. Heath v. State, not a RICO. Gesserum, he relies on the dissent. Rowan is a United States Supreme Court case. It's decided under Title 21. It was a case involving the conviction of physicians for the unlawful distribution of controlled substances. Dealt with the adequacy of proof at trial, not a challenge to an indictment. And it's materially different because, unlike Mr. Williams on these drug charges, these doctors could have lawfully distributed controlled substances if they had written a valid prescription. And the question was on a specific provision of a code of federal regulations that dealt with what makes a facially valid prescription unlawful, and it had a specific intent provision in that. It's a fundamentally different case. Alanis is not a RICO. The cases that are cited that were RICOs, MacArthur is a civil case. Cotman arose out of the APS cheating scandal. I was on that case. Wiley was another criminal case. Each one cites, these were cited for the quotation of a description of the elements of RICO conspiracy that included knowing and willfully. But every one of those traces back to a federal district court case. That federal district court case was Rosen versus Protective Life Insurance Company, 817 F sub 2nd 1357 at 1382. That was a summary judgment issued by Judge Duffy. I remember it because I was on the wrong side of that summary judgment. I represented the plaintiff in that case. But that's Judge Duffy's formulation of it for purposes of deciding a summary judgment. He injected the words knowingly and willfully in there. Other Georgia courts have picked it up, quoting generally the elements of this, but there is no knowingly and willfully requirement in the statute. It is not, this is not anything that has ever been used to dismiss an indictment. It is, that language is superfluous. The fact that it's been quoted does not mean it's been decided. Two very, very different things. Similarly, the citation to the Trump case, where out of an abundance of caution on page 14, the state did reference knowingly and willfully joining a conspiracy. The fact that we did that in that indictment doesn't make it an element and doesn't make it a requirement in other indictments. In fact, we have evidence which says quite clearly it's not. In fact, we have Pepe, Bafa, Scotto, and others that say it's not. And so the idea here that we're going to create an additional requirement that exists nowhere in Georgia law has been rejected by Georgia courts, specifically in the context of RICO, that the idea that unlawfully is insufficient, that has been specifically rejected by the Georgia Supreme Court and the Georgia Court of Appeals on multiple occasions. There's no room to maneuver there. It just doesn't give you an option, Your Honor. And on top of that, were there any doubt, federal courts interpreting the same language in this federal statute, counterpart language there, in an area where, although there are significant differences between the two statutes, here, on this point, relevant to what you're deciding now, there are none. The word is unlawfully in both. Those courts have all reached the same conclusion that Evans reached, which is this is not a requirement for a charging document, not actually a requirement for jury charges either. Mr. Steele has not given you what you would expect here, which is a single case, single RICO case from anywhere in the country that says the absence of knowing and intentional in the charging document requires its dismissal. There is no such federal case. There is no such Georgia case. This would be the first one of which I've been aware. So if the court has any questions, happy to address them. Otherwise, I'll turn it over to Mr. Uleski, who's going to deal with the other counts.
Okay, all right.
Thank you.
May it please the court, Your Honor. Same as with the RICO discussion, there's been provided no case law that says as to gang counts, particularly 56, 57, that the absence of the words knowingly, these magic words knowingly and or intentionally requires dismissal subject to a general demurrer. Instead, when you look to counts 56 and 57, you'll note that 56 is under Gang Act Section D. 57 is under Gang Act Section A. Going to 1615-4 in those particular subdivisions, there's no specific intent required in the language of either A or D, which 56 and 57 ride upon. Whereas you do see intent in subsection B and F and stuff like that, you don't see it in A or D, which is alleged in this indictment properly. And more than that, the discussion of how the word, knowingly and willfully, that's sufficient, right? But pursuant to all this authority we've been talking about, so is unlawfully when it tracks the language of the statute, which counts 56 and 57 both do. And I'll point out that 57, in fact, says that, on so-and-so day, the accused did unlawfully, and then it tracks the language of the statute. And then in 56, it tracks the exact language of the statute, and I'll point out that the verb conspire is included in there, which there's some discussion, and including the Black's Law Dictionary discussion, about how it's not really conceptually possible to accidentally or sort of negligently conspire to do something. So I would argue that mens rea is sufficiently alleged both in 56 and 57. And on top of all that, 56 and 57 both say at the end that this was done, these verbs were done contrary to the laws of the state. So they got unlawfully on both of those counts. Those are as to the Gang Act counts. And I will go forward and talk about the other counts as well. Going to 58 and 59, all the same discussion that we've had applies. It says unlawfully in both of those counts. It tracks the language of the statute. On top of that, though, it does say with intent to distribute. It literally says the intent in 58. And 59 it literally says with intent to distribute. It literally charges the mens rea. 60, 61, and 62 all track the language of the statute. They all include the verb, the adverb unlawfully. And for the argument to be made that, well, Brooks applies because, the charging instructions to the jury need to allege, that it was knowingly and willfully or what have you. As echoing Mr. Floyd, that analysis is incorrect because, Brooks is to do with the evidence at trial and what the jury's charged on after having heard the evidence at trial, including any defenses that may be raised. So, for example, I got an indictment and it says somebody did something unlawfully, right? Well, let's say somebody raises a defense of accident or mistake of fact or something like that. Well, of course, after the evidence is out, you're going to have to charge the jury relevant to those defenses, right? So the same as Mr. Williams has told us that he's going to raise lack of knowledge on these, well, then maybe there is going to be a charging instrument later on after evidence is in that has to do with knowledge. But we're not into evidence. There was no general demur raised in Rooks. It's inapplicable. It's inapposite. And to strike any of these counts on this basis is really to confuse what in logic is called like a sufficient versus a necessary condition. It's not necessary that every count has the word, these magic words, knowingly, willfully. Unlawfully is enough when it tracks the language of the statute, and that applies to 56, 57, 58, 59, 60, 61, and 62. Your Honor, Mr. Floyd and I would be happy to address any questions, but at this time, with your Honor's permission, I'll conclude.
Okay.
Thank you.
Come back, hope that will. Okay? All right, we're going to recess.
All right, Judge, everybody present, count for.
Okay, if I could get everybody's attention so I could go ahead and rule upon this issue and kind of talk about where we are for the rest of the remainder of the afternoon. The court's had an opportunity to consider the defendant's plea and bar motion to dismiss General Demur filed on behalf of Jeffery Williams. Courts also had an opportunity to consider the state's response in opposition to defendant Jeffery Williams. Court's also taken a look at the indictment filed in this case as it appears under 22 U.S.C. 183572. The court's also considered State versus Heath, citations which have already been set forth on the record. Ron, and that is X-ray India, uniform Lima, uniform Ruan, Romeo, uniform Alpha November versus United States. Elanis versus United States, MacArthur versus Beach Haven Baptist Church of Atlanta, Cotman versus the state, Wiley, that's Whiskey, Yankee, Lima, India, Echo versus Denton, Rooks versus the state, and Tate, Jeshurun, and that's Juliet Echo Sierra, uniform Romeo, uniform Mike, Tate versus Jeshurun versus the state. Tate, I should say, hyphen Jeshurun versus the state. The court's also considered the following other cases as well, and that's Evans versus the state, which has already been cited by counsel. United States versus Pepe, cited by counsel. United States versus Boffa, cited by counsel. United States versus Scotto, cited by counsel. Rooks versus the state, also cited by counsel. After consideration and of reading these particular cases and hearing the arguments of counsel and reading the motions that were filed to therein and the responses and the plea and bar motion to dismiss General Demur, the court is of the opinion that pursuant to Pepe, Boffo, and and Scotto, that a consideration, among other cases, in consideration of the elements of knowingly and willfully are not required. On our case law at this point in time, unlawfully is sufficient, and it tracks, and I find that the state's indictment tracks the language of the statute and is sufficient therein for counts 1, 56, 57, 58, 59, and 60, 61, and 62 as it pertains to the state versus Mr. Jeffrey Williams. For those reasons, the court is going to deny the defendant's plea and bar motion to dismiss General Demur. Mr. Floyd, if you will prepare a suitable order for my signature, submit that for Mr. Steele's consideration. I'll go ahead and file it, and he can take whatever other steps that he feels necessary on behalf of his client at this point in time to go ahead and do that. I don't know if he'll be able to take a direct appeal. I think he probably can, but that won't stop this trial of the matter.
Understood, Your Honor.
So,
Thank you.
all right, if you could get, when do you believe you could get that done? You already owe me some homework for today, but when do you think?
That's in process.
I know, sir. I know, sir.
We'll get that today.
What, you think, what, a week?
Is end of business tomorrow sufficient? Your
That
Honor?
would be more than sufficient.
Okay, thank you.
All right, that'd be more than sufficient. All right, okay, Mr. Uhelski, when are your colleagues, when this will be back? Because I believe they have, unless you have some other, I believe we're supposed to review the witness list. There's a motion to disqualify Mr. Steele. There is a continuation on a motion to suppress Nichols 17 and 18.
Yeah.
Is that correct?
That's correct, according to my records. I'm not quite sure when there will be finished
Okay.
there. I don't want to represent otherwise.
All right, I'm going to come back at 1 o'clock, okay? Mr. Steele, as I understand it, you're supposed to be in front of my colleague Judge Ingram at 2?
I told the Honorable Judge Ingram now with you, but, I'll do whatever I'm telling you what it goes.
All right, well, let's come back at 1 o'clock and we'll see where the afternoon leads us at this point in time, at that point, okay? All right, anything else? All right, so I'll see everybody at 1, okay? Okay, all right.
Like everybody present, counsel. Yes, sir. Yes, sir. Everybody's present, counsel, Judge.
Thank you. Okay, all right. Mr. Yelsey, do you have any ETA colleagues, Ms. Love and Tilton?
I'm being told they're wrapping up and it should be about 15 more minutes. That's the presentation I've been told.
Take care of the other business, or are you going to, what's your pleasure?
No, I'm with, my pleasure is with you. I'm staying with you. So if you don't know this, the other case is Mr. Blaylock. I represent him on appeal. He's a co-indictee here. Mr. Ryan, he's present in your honorable courtroom. He's represented by a different person on appeal from the same case. They were co-defendants in a murder case. They both were government convicted, so they both appealed. Miss D. Williams is not the appellate lawyer for that case. I have already done everything for Mr. Blaylock. So it's really not me. If I go to the Honorable Judge Ingram, I will do what you tell me to do, and I will sit there. If something comes up, of course, I'll adopt it. It's the co-defendant who needs Mr. Ryan, co-defendant's appellate lawyer needs Mr. Ryan, because they are calling, I believe, and please understand, I may be wrong, but they're calling the trial lawyer for testimony, and they're calling 3 alibi witnesses that were not called to trial. I have no idea how long that's going to be, but I'm just going to sit there. If something comes up that, for Mr. Blaylock, I'll, of course, argue it and adopt it. So I'm sure that's why the Honorable Judge Ingram summoned me. But otherwise, your Honorable Court, if you remember, months ago allowed me to do that hearing. I did my hearing. The other side asked for a continuance. They were not ready with witnesses. So to answer your question a long way, I'm just with you. I believe, though, and I don't want to overstep my bounds, you didn't ask this, I believe Mr. Ryan needs to go. He's really the issue, the way I understand it.
Yeah, I can ask for exact correct, Ewing.
Yes, Your Honor, that's correct. I have been speaking with his appellate attorney to find out how many witnesses and about how long he thinks it'll take today.
Okay, all right. Okay. Thank you, Matt. All right, let's do this. Can you, let's at least take 15 minutes. If you could let me know, Mr. Yelsey, when this rubber back, so I can kind of gauge accordingly, because I may have to let Mr. Ryan go to this, for this 2 o'clock here, so, I'm gonna plan for the rest of the afternoon. I'm gonna have to take a break, if that's the case, so. But I just want to kind of reorganize the count for the afternoon, so I think it was what that, this motion is the press finish on 17
Yeah, we'll be prepared whenever, I'll give you up to the minute updates.
I just didn't know whether or not we'll be able to do it today. That would be my plan, hopefully today. But I need to, there's some other business that wants to be picked up and then everyone will be here tomorrow. I could do it tomorrow, but I'm gonna try and do it tomorrow, just housekeeping on some other things.
Sure. I believe our witnesses for those motions to suppress are going to be here today, so
Yeah.
that's the preference.
Okay, all right. So folks, we'll be in recess about 15 minutes and then we'll see what you have to know. We'll leave in terms of the order of the mayor, okay? All right, we're in recess.
Thank you, Your Honor.
Okay.
Where's Mr., oh. Where'd Mr. Steele go?
Oh, he might have just stepped down.
I was gonna.
He's right there.
Okay, all right. Okay, ladies and gentlemen, what I'm going to do at this point in time, given that Ms. Hilton and Ms. Love are still tied up with Judge Dempsey, I'm going to recess us until 4:30, so Mr. Steele and Ms. D. Williams, your client can also handle that particular other issue he's got, okay? So we'll reconvene here at 4:30. Until then, we'll be in recess, all right? Okay, see you then. Christina, do me a favor, yank that thing up for me. Okay. All right. Okay, I think we do. All right. Ms. Love and Ms. Hilton, first, good day. I hadn't seen you all day long. You've been taking care of other business, I understand. Yes, Your Honor. So first time to greet you, ladies. All right, so got a couple of things. Are you all prepared to deal with motion to suppress 17 and 18 for Mr. Nichols?
Yes, Your Honor.
Okay, all right. You have your witnesses here?
Yes.
All right, call your first witness.
It'll be Sergeant Maldonado, Maldando. And Your Honor, as Sergeant Maldonado is coming in, I just want to kind of frame what's going on with for both of these hearings today. Your Honor, this is Mr. Nichols' motion to suppress for two separate instances, Your Honor. The first is a July 3rd, 2017 incident in which Mr. Nichols seeks to suppress drugs and a gun found during a search of a vehicle for which he was an unlicensed driver. It had 4 outstanding warrants, and the owner of the vehicle, who was the passenger, gave consent to search the vehicle. Mr. Nichols subsequently pled to these charges. He pled to possession with intent to distribute, narcotics, possession of a firearm by a convicted felon, possession and use of drug-related objects, drugs not in original container, which was a misdemeanor, driving without a valid license. And all of this he pled under indictment 17 SC 153307. He received a sentence of 10 years to serve, 2 years balanced on probation, and he got that sentence in March of 2018. In October 2018, while he was on probation for the 17 SC case, Mr. Nichols was then again arrested and charged with possession of marijuana with intent to distribute, possession of a firearm during the commission of a felony for 3 guns that were in a car in which the state contends that he abandoned. He was charged with possession of a firearm by a convicted felon for those same 3 guns. In 2019, Mr. Nichols did file a motion to suppress the drugs in that case, which the state believes was subsequently abandoned because the defendant pled to the facts in that case. He pled to a reduced charge of disorderly conduct for the marijuana and pled to possession of a firearm by a convicted felon. So we're here on a motion to suppress for those 2 incidents. Your Honor, as to both, we do have witnesses present to be heard. We do believe in the 2018 case, Mr. Nichols lacks standing to challenge the search of that vehicle. And we will ask to address that after we present the first witness in that case. We'll ask to address the standing issue before we call the second witness. But we will start with the 2017 incident.
Okay, all right. I'll call you first witness. Sergeant Maldonado.
Maldonado, yeah.
All right, Sergeant Maldonado, good afternoon. Sir, if you would please approach the witness stand. Before you get there, if you would turn and face Sergeant Ingram and be sworn as a witness, please.
Raise your right hand. You swear firm testimony you give the truth, whole truth, nothing but the truth. I do. Have a seat. State and spell your first and last name for the court. So now to the mic.
Sure, I'm Sergeant Carlos Maldonado. Carlos is C-A-R-L-O-S. Last name is M-A-L-D-O-N-A-D-O.
And Sergeant Maldonado, where are you employed?
I'm currently employed with the City of Atlanta Police Department
And how long have you been with the City of Atlanta Police Department?
for 11 years.
And what is your current position?
I'm currently assigned as a supervisor for the Aggravated Assault Unit, and I'm a task force officer with the Federal Bureau of Alcohol, Tobacco, Firearms, and Explosives.
How long have you served in your current assignment?
I've been with the Aggravated Assault Unit since the summer of 2021, and I've been with ATF since September of last year.
Prior to your current assignment as a sergeant in the Ag Assault Unit, where were you employed?
I was with the Zone 4 Field Investigations Team, assigned as a supervisor.
And if you could tell the court a little what you do as a Zone 4 Field Investigation Team and as a supervisor.
Sure. So the FIT team also is called the Crime Suppression Unit. Their names are interchangeable between the two. Each zone has a FIT team whose job basically is to look at crime trends in certain areas and patrol those specific areas in order to combat whatever the current crime trend is. They work in both uniform capacity, wearing uniforms and driving marked vehicles, as well as working undercover assignments in regular clothes, driving regular cars, observing crime, and using marked vehicles as units to make contact with whatever it is that they observe to initiate a stop and complete an investigation with.
And in 2017, were you assigned with the FIT team?
I was, as an officer.
Okay. And in 2017, what zone were you assigned to?
To Zone 4.
And where is Zone 4?
Zone 4 encompasses the southwest Atlanta portion of the city. It goes all the way from the west end of Atlanta to Camp Creek Parkway, and to the west it borders up against the city of South Fulton and goes all the way to the eastern border of Lee Street, where it turns into Zone 3.
Okay. I want to direct your attention to July 3rd, 2017. Did you have the occasion to participate in a search of a vehicle in Zone 4 as an officer with the FIT team?
I did.
What brought you to Zone 4 that day?
Sure, that was a regular assignment. That particular time we were trying to combat an area that was seeing an uptick in robberies. So we were patrolling in the 700 block of Cascade Road, which had seen an increase in robberies in the previous days leading up to that day.
Were there other officers with you that day?
Sure, I was riding in a vehicle with Officer Travis Owen. Travis is spelled Travis, and Owen is Owen. And then there was a separate vehicle which was occupied by 4 officers. It would have been an Officer Mayfield. It's Mayfield. Officer Rhodes, Rhodes. Officer Chisholm, Chisolm. And I believe there's just 3 of them in that vehicle.
Okay. And while on patrol, did you have the occasion to stop a 2016 Volkswagen?
We did.
Okay. Can you describe the car for the court?
Sure. We were patrolling in front of an apartment complex, which is located at 763 Cascade Avenue, which was in that particular area, which we were directed to patrol. We observed a vehicle that was exiting the apartment complex and entered onto the city street of Cascade Avenue. The vehicle had extremely heavy tint. We could not see the occupants inside that vehicle. We followed the vehicle until it came to the next major intersection, which was Cascade and Donnelly Avenue. The vehicle pulled into the Checkers restaurant into the drive-thru, and we initiated a traffic stop as it was in the drive-thru.
What happened when you initiated the traffic stop?
Sure, we walked up to the vehicle. We made instructions to the officers, or to the occupants of the vehicle, to lower the windows because it was extremely heavy tint and we could not see inside of the vehicle. And the door was open slightly ajar, and they stated that they could not lower the windows because it was fresh tint that was just installed on the window.
You said they. Was it someone specifically who spoke to you?
It was the driver of the vehicle.
And how many occupants were inside of the vehicle?
There were 5 people inside of the vehicle. There were 3 males and a female and a baby.
Once the driver opened the door because they could not wind down the window, what happened next?
We asked the driver for his driver's license, and he stated he did not have one.
Once the driver said that he did not have a license, what happened next?
We had him step out, and Officer Owen detained him until we could figure out more information about him and who he was.
Okay. And were you able to figure out more information?
We were.
What were you able to determine?
We identified the driver as Mr. Quamarvius Nichols. I would have to refer back to my report for the exact spelling of his name. And then we discovered, after running an inquiry in our in-car computer, that Mr. Nichols was not licensed to operate a motor vehicle in the state of Georgia.
Okay. Once you were able to determine that Mr. Nichols was unlicensed to drive, what happened with the other occupants of the vehicle?
Sure. As we were checking our computer to check the information for Mr. Nichols, Officer Chisholm was speaking to a female who was in the front passenger seat. That was Miss Pierre, who was actually the registered owner of the vehicle, and she had her step out, and they were talking away from the vehicle.
Okay. Once Could you see them talking to each other?
I can't recall from my position if I saw them or not.
Once they finished talking, what happened next?
Officer Chisholm came back and stated that the female, Miss Pierre, had given consent for us to search the vehicle.
Okay. And after you were given the consent, did you all search the vehicle?
We did.
What, if anything, did you find?
Sure, we located a loaded Taurus 9mm handgun, which was underneath the driver's seat, which would have been directly underneath Mr. Nichols, and also at the feet of the rear passenger, who I believe is Mr. Brandon Warren.
Okay. Did you find anything else in the vehicle?
Yes, in the center console, we located powder MDMA, as well as some Xanax pills, and in total, it weighed 47.7 grams.
After you searched the vehicle, what happened?
Sure, all occupants in the vehicle were identified, and we ran them on our in-car computer as well, and discovered that there were other occupants that had warrants. Ms. Pierre had a failure to appear warrant for a traffic violation out of the city of Atlanta, and then Mr. Nichols actually had 4 separate warrants for his arrest. One for violation of probation for criminal damage to property, an aggravated assault charge, a simple assault charge, and a burglary charge out of Florida.
And did anyone make claim to any of the drugs or gun in the vehicle?
No, we actually did Mirandize all the occupants. Only one person wanted to speak to us, Mr. Norman Harris, but he denied knowing of any of the items in the vehicle, as did everyone else. Everyone else did not say anything about anything that was in the vehicle and denied knowing that it was there.
Okay. And at any point in time, did you actually test the window to see if the tent was a legal tent?
I did.
And what happened?
Sure, it measured at 21%, which is below the legal limit in the state of Georgia for a sedan. It's required to be at 32%.
Okay. And let me ask, in 2017, did you all have body cam video?
Yes, we did.
And as it relates to arrest, so let me back up, was your body cam on?
It was.
As it relates to arrest, would you still have access to those 2017 body cam videos?
Unless it was downloaded, no.
Okay, why is that?
Sure, so every time we make an encounter with the police department, we have to classify our interaction for whatever the case may be, whether it's a general citizen encounter, an investigation, or an arrest. In this case, the footage would have been labeled as an arrest since an arrest was made, and our retention policy period for arrest videos is for 5 years unless it's related to a capital offense or a serious offense such as murder, a homicide by vehicle, or any sort of SVU, like a special victims related crime, which is in that period is retained for an indefinite period of time.
After you searched the vehicle and found the gun and the drugs from the central console, were those items taken to APD?
Yes, so since we operate in a team capacity, one of us would have collected all the evidence that we collected in that particular workday, and then we would have taken it down to the annex, and it would have been submitted to Atlanta Police property.
Okay. After searching the vehicle and making all the arrests that were made, did that conclude your involvement in the case?
With this case, yes.
Court's indulgent.
Okay.
Thank you. Seeing no further questions.
Good afternoon, Sergeant.
Afternoon, how are you?
Pretty good. All right, so on the day of this incident, were you in plain clothes or uniform?
Sure, so we were in plainclothes capacity, which would have been defined by a outer carrier vest that's clearly labeled with police on the front and the back, but we were operating in marked vehicles.
Okay. The marked vehicles, please tell us exactly what type of vehicle.
Sure, I would have not in a Ford Taurus. Officer Mayfield would have been driving a Ford Explorer, but it would have been a typical Atlanta police marked vehicle, the blue background with the red lettering.
Were you driving or were you a passenger?
I was the passenger of the vehicle.
All right, at the time you explained that field investigation team, you work on trends.
That is correct.
Correct. And the trend at this time in 2017 was for robberies, is that correct?
That is correct.
So was your primary investigation or duties to look into robberies?
No, it was to basically just be like proactive enforcement in those areas where those crimes were occurring.
And how?
Sure, by conducting person stops, suspicious person stops, vehicle stops, anything that we saw, any crimes being committed, just targeting those people. And our job was to go beyond the stop. We would stop someone, say for a violation, talk to them, see if they have any information about crimes occurring in the neighborhood, or on a vehicle stop to push forward and see if there's anything that might be inside of a vehicle.
And that was your duty on the 2017 when you pulled over the car that Mr. Nichols was in?
That's correct.
Tell us the other officers that were with you. Did you say it was 4? I know you said 4.
Sure, so it's 2 in my vehicle since we're in the Ford Taurus. It would have been Officer Owen and myself. And then the other vehicle, the Ford Explorer, would have been Rhodes, Chisholm, and Mayfield.
Okay. So 3 officers inside the Explorer?
Correct. It didn't have a cage, so they rode either 3 or 4 deep, depending on how many people were at work that day.
What was the approximate time did you see this vehicle?
I would have to defer to report, but I believe it was afternoon.
Now, I know this was in 2017. Do you have any recollection of this incident besides what's in your report?
I do.
And would your report help refresh your memory?
Sure it would.
Ms. Westmoreland, what do you want to refresh his recollection as to? Is that what you're trying to do?
Your Honor, I'd like to know the approximate time that he pulled over the vehicle.
Okay, all right.
So I'll ask again. Sergeant, what time did you pull over this vehicle?
Sure, the exact time, I would have to look at the report to refresh my memory, but I do recall it being afternoon.
All right, so just mark it as D1 for the purpose of motion?
Yes.
All right.
May I approach?
You may.
Thank you, ma'am. And the time that we pulled the vehicle was 16:37, which is 4:37 in the afternoon.
Now, you stated that you could not see inside this vehicle.
That is correct.
Okay. So you couldn't see the driver nor the passengers.
That's correct.
You've received some training in window tint and to be able, yes?
Yes, I have.
Okay. And at what tint measurement can you not see inside the vehicle? Do you know?
No, particularly I don't have that memory.
Did you or any officer with you run the plates to this vehicle prior to pulling it over?
No.
And how long did it take from the moment that you saw the vehicle to the moment that you pulled the vehicle over?
Sure, we saw the vehicle as it exited 763 Cascade, and we would have called saying that we're about to stop this vehicle, and that's waiting for the other vehicle, which had Officer Mayfield, Chisholm, and Rhodes in it, to conduct a stop with us. And by that point, the vehicle had pulled in the drive-through of the Checkers, which is approximately a quarter mile away from the apartment complex.
Now, you said you would have called. Are you saying that's what you did? Or
that is what I did, yes.
So would it be fair to say less than a minute?
Approximately.
Approximately. Now, we know that you wrote a report regarding this incident. Did you write any supplemental reports?
I did not.
So as far as you remember, you only wrote one report?
The main incident report.
Is that the report that I just handed you?
It is.
Did you review that report today, prior to your testimony?
Yes.
When you pulled over the vehicle, I know that you were in the Ford Taurus and you had a Ford Explorer. What vehicle was ahead of who? Were you first, or was the Ford Explorer first?
We were the primary vehicle that initiated the stop.
Okay. All right, so once you initiated the stop, the Explorer is behind you. You pull over the vehicle inside the checkers, correct?
That is correct.
All right, and then you stepped out of your vehicle?
Correct.
All right. And when you stepped out of your vehicle, tell me what you did.
Sure. Officer Owen approached the driver door, and I came up right behind him on the passenger side, and the other occupants of the vehicle would come up on the passenger side. That was a standard operating procedure for our fit team on how we stop vehicles.
Okay, so you said Officer Owen
Correct.
approached the passenger side.
No, the driver's side.
Okay, so Owen approached the driver's side, and you approached the passenger side.
No, I approached the same side, the driver's side, and I would have been at the second window. Because as a driver, he would have been in the first one to come up to driver, and I would come up to back him up on the driver's side.
Is it fair to say that you would be standing on the driver's side by where the passenger window is?
Yes, the rear driver's side door, correct.
And then the other officers, the ones that were in the Ford Explorer, what did they do?
Come up along the passenger side.
How many officers total approached this vehicle?
It would have been all of us, so it would have been 5.
5 officers. Do 5 officers generally approach a vehicle for window tint?
For the fit team, yes.
For the 15. And why is that?
Sure, we're targeting vehicles. Typically, we encounter weapons in multiple occupant vehicles, and as standard procedure, we're able to talk. Other officers are able to look at body language. In this particular vehicle, obviously, the tint, we're unable to do so, but that's why, if you read the report, it mentions that we ask for all the windows to be lowered, so that way we can start reading body language and talking with the occupants of the vehicle.
You believe that's in that report?
Yes.
All right, may I?
Sure. In the second paragraph, it says, we approached the vehicle and asked them to lower all the windows.
Okay. All right, and you stated that Mr. Nichols slightly opened the door?
Correct.
Okay, and what about the other passengers?
I can't recall what they did.
Now, once that Officer Owen, he's the one who asked Mr. Nichols for his identification?
Correct.
And you could hear that exchange?
Correct, I was standing right next to him.
Okay. All right, and Mr. Nichols stated that he did not have identification.
Correct.
Now, were you there, did Mr. Nichols, did he give his name?
Yes.
Okay. And he gave his correct name?
He did.
Now, the owner of the vehicle, she was also in the vehicle, correct?
Correct.
Ms. Pierre? Okay. So once that Officer Owen asked Mr. Nichols for his identification, and he stated that he did not have it, then what did you do next?
Sure, I would have escorted him to the vehicle, and I was the one who performed the inquiry on the computer.
Okay. When you say you would have, and I'm not trying to be funny,
Sure, sure.
I'm not sure if you're saying that's what you did that day or that's what you suspect you would have done. I don't understand.
My role in the fit team was to run everyone's information on the computer. So I was the person who ran both Mr. Nichols' information as well as all the occupants in the vehicle's personal information.
Okay. After Mr. Nichols explained that he did not have identification, was he immediately removed from the car?
He was.
Okay. So at that time, he was detained?
He was detained.
Okay. And did you walk him over to your patrol car?
He was placed in the rear seat of our vehicle.
He was placed in the rear seat. Okay. So at this point, Mr. Nichols is in the rear seat with you?
Correct.
Okay. And Officer Owens is?
Still at the vehicle.
Okay. Are the other officers, are all of them still at the vehicle?
They are.
At this point, are all the other passengers in the vehicle still in the vehicle?
Still in the vehicle.
What time, if you know, did this happen? What time was Nichols placed into your patrol car to run his identification?
Sure. Right after he said he didn't have a driver's license.
Okay, so are we still within a minute?
Maybe within 5 minutes.
Within 5 minutes?
Correct.
Okay, please explain what happened within the other 4 minutes.
Sure. We came with the vehicle, had the conversation. He didn't have a driver's license. He was asked to step out. He was detained, placed in the rear of the vehicle.
Okay. All right, so I just want to make sure because 5 minutes sounds like a little long.
Sure. That's why I said within 5. I'm not an expert on time. That's why I'm just simply estimating it would have been no longer than 5 minutes.
Okay, so is the answer you don't know?
That is correct.
Okay. But you do know it was immediate?
Correct.
All right, you know you immediately asked for identification when he did not provide it, he was asked to step out of the vehicle. You know that happened immediately?
Yes.
All right, and you do not have any recollection that anything happened in between that time?
That is correct.
All right, and then you know that you walked him to your patrol car and that was immediate?
Correct.
All right, you didn't have any other conversation with Mr. Nichols between the taking him out of the vehicle and walking him to your vehicle, correct?
I asked for his name and his date of birth.
And that's it?
Yes.
All right.
Well, and if his driver's license was out of the state of Georgia.
Out of the state of Georgia. Okay, so you asked him 3 questions and then you put him inside of your vehicle.
Correct.
All right, and then you immediately ran his name?
Correct.
All right. And how long did it take for the results of Mr. Nichols' name to come back to you?
It's instantaneous.
Okay. And when you received those results, at that time, were you aware that Mr. Nichols had warrants?
At that time, no.
No. Okay. All right. What did you do next?
Sure. Upon receiving information, discovered that he was unlicensed operator of a motor vehicle, and then that's when I discovered that he had possible warrants.
Okay, so your first information received was a reference to the license, and then you found out about the warrants. I'm trying to figure out how long did that take?
Sure, that part is instantaneous. Upon running his information in the computer, the first thing that comes back is his driver's license information, and then if someone was to have a possible warrant, that information will come up next.
Okay, so that's immediate.
That is correct.
All right, so you found that out while Nichols was still in the car with you?
Correct.
All right. And so once that you found out that Mr. Nichols did not have a license and had a warrant, what did you do next?
Sure, at that point in time is when Chisholm notified us that we had received consent to search the vehicle.
Okay. All right, let's go back for a second to the vehicle. The owner, Ms. Pierre, she was inside the vehicle. You just stated that, correct?
She was.
Did you ask her if her windows were factory tinted?
I did not know.
Okay. Did you ask her if she had any kind of medical exemption?
I did not.
Did you ask Mr. Nichols, he was the driver of the vehicle, did you ask him if he had any kind of medical exemption?
I did not.
Did you ask any of the passengers?
I did not.
At what point did you do the tent reading?
It would have been at the end of the stop.
At the end of the stop. And did you do that personally or did another
I did.
officer? Okay. Did you, and so when you do the tent reading, the results come back immediately, right?
Yes.
All right. Did you take a picture of those results?
I did not. They would have been captured on the body camera.
Okay. A body camera that no longer exists?
Correct.
Okay. When Officer Chisholm, is that his name? Okay.
Her name.
Her name. When she asked Miss Pierre to step out of the vehicle, were you standing there?
I was not.
Okay. So you do not know what that officer said to, okay.
I do not.
Where was Pierre and Officer Chisholm, where were they standing?
I can't recall.
When you walked up to the vehicle, or at any time, actually, did you see anything illegal in the car?
From outside the vehicle?
Yes.
No.
Okay. What about standing up close to the vehicle with the door open? Did you see anything?
No.
Could you see inside of the vehicle through the window tint when you were standing up close on it?
No.
You didn't smell anything that...
No.
So you asked, or one of the other officers asked to search the vehicle?
I would believe so, yes.
You believe so?
Correct.
You didn't ask to search the vehicle?
I did not.
Okay. You didn't have any indication that anything was in the vehicle?
Correct.
Who exactly searched the vehicle?
I was involved in the search. To my knowledge, this would have been the team. I couldn't tell you particularly. I would assume everyone that was on scene would have been involved in the search, but I know that I retrieved the firearm from the scene.
Okay, so you know you retrieved the firearm and you assume everyone else searched, but you just do not know?
Who did what? No, I can't recall.
Okay. And do you know how long the search of the vehicle took?
I don't.
The entire car was searched?
It was.
The female passenger, Miss Pierre, she never gave you consent, correct?
No.
And you stated that Officer Chisholm told you that the female passenger said that you could search the vehicle.
That's correct.
Did Officer Chisholm tell you why he isolated Miss Pierre from the vehicle and from her friends and family?
She did not.
At any point in time, did you give Mr. Nichols any Miranda warnings?
I did.
And when did that happen?
It would have been at the end of the stop. Once we recovered everything, I ran it to all the occupants of the vehicle.
What time was Mr. Nichols arrested? Do you know that?
As soon as we found out that he was not licensed to operate a motor vehicle, he would have been under arrest.
Is it fair to say you have no idea what time any of this happened? Okay.
Yeah.
Is that yes?
That is a fair statement.
You're aware that when you call dispatch that they create CAD reports?
I am.
What's your understanding? Okay. Now, you're unaware of all the times. Is it fair to say that's what body cameras are helpful for?
They are.
They are. Because if you have a body cam, you can go back and you can review the body cam, right?
That is correct.
And then we would have an answer to a lot of these questions. You agree?
Yes.
All right. Now, you stated that the body cameras last for 5 years?
Correct.
Did you make any effort to locate the body cam in this case?
Yes.
Okay. Tell us about those efforts, please.
Sure. When I received a subpoena for this case, I asked for the agency case number, and then I looked into our evidence.com website for that case number and saw that it no longer existed.
Okay. All right. And that is a 5-year time frame?
That is correct.
Okay. So this incident happened July 3rd?
Correct.
Right? And that's 2017?
Correct.
So when this case was originally indicted in May of 2017, this body camera existed?
I would assume so, yes.
Okay. And no one asked you in May of 2017 for this body camera footage?
No.
No. The field team and the primary responsibilities of the field team back in 2017, you did not observe any of those type of crimes being committed by by the occupants in this vehicle, correct?
We refer to those crimes.
Robberies?
No.
Okay. I have no further questions, Your Honor.
Can you redirect, Madam?
What happened to the vehicle?
It was released to someone at Ms. Pierre's request.
Okay. And what about the minor child?
To the same person.
Okay. And do you recall, did you have to wait for that person to come to the scene to retrieve the child and
Yes.
the vehicle?
We did.
Okay. Do you remember how long you had to wait?
I don't, but we were out there for quite some time.
No further questions.
Anything further, Madam?
No, Your Honor.
Okay. Ms. Sergeant Maldonado will be permanently or temporarily excused for purpose of the motion.
Permanently for the purpose of the motion.
All right. Sergeant Maldonado, thank you for your patience with us. I'm going to permanently excuse you for purpose of the motion. Don't discuss testimony to anybody except the attorneys in this case, okay?
Yes, sir.
Thank you, sir. All right, now.
Next we have Agent Chanel Chisholm.
All right, Agent Chanel Chisholm, you ready to proceed?
Yes, Your Honor.
Okay. All right, Agent Chanel Chisholm.
Agent Chanel Chisholm.
Agent Chisholm, good afternoon, madam. If you could please approach the witness stand. Once you get there, if you'd be so kind and turn and face Sergeant Ingram, be sworn as a witness, please.
Raise your right hand. You swear affirm testimony you give today the truth, the whole truth, and nothing but the truth? That's it. So you can spell your first and last name for the course, please.
Chanel Chisholm, Chanel Chisholm.
And Agent Chisholm, where are you currently employed?
With the FBI
And how long have you been with the FBI?
for approximately 4 years.
And prior to working with the FBI, where were you employed?
Atlanta Police Department
And how long were you with the Atlanta Police Department?
for approximately 6 years.
When you left the Atlanta Police Department, what was your assignment?
I was an officer on the FIT team in Zone 4.
Okay. How long did you serve on the FIT team with Zone 4?
For approximately 4 years.
And what were those years?
I believe that was 2015 to 2019.
Okay. I want to direct your attention to July 3rd of 2017, where you were assigned with the FIT unit in Zone 4?
Yes.
All right. And during that time period, on that day, did you have the occasion to stop or be a part of a stop of a 2016 Volkswagen?
Yes.
Briefly, if you can, tell us what you remember about the stopping of that vehicle.
I remember us conducting a vehicle stop at Cascade and Donnelly. I remember the windows being heavily tinted, was one of the reasons why we pulled the vehicle over. And I do remember us conducting a search on the vehicle and retrieving drugs and a handgun.
Okay. Now, you said that you stopped the vehicle. Do you remember how many occupants were inside of the vehicle?
I cannot recall the exact number.
Okay. We're looking at a copy of a police report. How refresh your memory?
Yes.
All right. Is it up there? Is there a police report up there?
No.
We have it. Okay. I'm going to show you what's been marked as defense exhibit number 1. Just take a moment, look at it, and see if it helps refresh your memory as to how many vehicles inside that car. And once your memory's refreshed, just look up and let me know.
Okay.
How many people were inside of?
I recall it being approximately 4 people and a child.
And once you stopped the vehicle, do you recall how you would have approached that vehicle?
Typically, when we stop vehicles, we all approach the vehicle, all officers.
And was that just standard of how you all approach vehicles when vehicles are stopped as a part of the FIT team?
Yes, correct.
And in this particular instance, did you speak with any of the occupants of the vehicle?
Yes, I spoke with the female occupant, Pierre.
And do you recall where she was seated when you spoke with her?
I do not recall her exact position inside the vehicle.
We'll look at a copy of that report, help refresh your memory?
Let's see.
So it will help you refresh your memory?
Yes,
Okay.
it will. Okay, so Pierre was occupying the front passenger seat.
Okay. And did you speak with Ms. Pierre?
Yes, I did.
What, if anything, did you speak with her about?
Objection, Your Honor.
Basis.
I'm common violation of the Confrontation Clause. I understand that hearsay is admissible with these type of proceedings, but this goes beyond hearsay. This is going to be reference to consent, and I believe that that's testimonial that Mr. Nichols has a right to for Confrontation Clause.
Your Honor.
Go ahead, Madam.
This is a suppression hearing where hearsay is admissible for the court
On a
to make it.
104 basis, so I'm gonna consider it for that weighting purpose, Madam. Is Ms. Pierre gonna testify at trial?
No, Ms. Pierre will not be testifying because this is a motion to suppress, Your Honor. So we're just trying to get the fact that the police had a right to be inside of the vehicle or had permission to search the vehicle.
Your Honor, may I respond to that?
Yes.
I understand the purpose that the state wants it. That doesn't make it allowable. Your Honor, our Georgia Constitution goes beyond the Constitution reference to these type of protections. That our Georgia Constitution includes language of any criminal proceeding. This counts. This is not just regular hearsay. This is hearsay, hey, the car was blue. This is testimonial. Mr. Nichols has a right to confront with any witnesses against him. This goes beyond that.
If I may, Your Honor, I'm directing the court to Bates v. State of Georgia, 277, Georgia 543, where it says it has long been recognized that hearsay is admissible in determining the existence of probable cause. Admission of hearsay for that purpose does not violate the constitutional right of a defendant to confront the accusing witness because guilt or innocence is not the issue for determination. There's a great difference between what is required to prove guilt in a criminal case and what is required to show probable cause for arrest or search. A finding of probable cause may rest upon the evidence which is not legally competent in a criminal trial. So again, Your Honor, we're trying to determine whether or not the officers were able to go inside and search the vehicle, and therefore, for this particular hearing, hearsay is allowed.
All right, I'm gonna overrule the objection, I should say. However, it's subject to it'll be subject to a trial foundation. So
you can
answer the question.
Okay. Can you repeat the question, please?
What, if anything, did you and Ms. Chisholm discuss?
Me and Ms. Pierre, we discussed.
Sorry, Ms. Pierre, sorry.
I spoke with her about if there was anything illegal inside the vehicle, and I also asked if we can get consent to search the vehicle as well.
And did she give you consent to search the vehicle?
Yes.
And did you all subsequently search the vehicle?
Yes.
And upon searching the vehicle, did you find anything?
Yes, we found narcotics and a gun.
Okay. Do you know what type of narcotics?
I do not recall.
We're looking at a copy of your report to help refresh your memory. Go ahead.
Okay, so inside the vehicle we found MDMA, Xanax, and ecstasy pills.
And then you said you also found a weapon, a handgun.
Yes.
After the search of the vehicle, was there anyone arrested?
Yes.
Okay, who?
All occupants of the vehicle were arrested.
Do you recall what happened with the vehicle?
No, I do not recall.
We're looking at a copy of the report, help refresh your memory as to what happened to the vehicle and what happened to the child, the minor child.
I do remember us releasing the child to the aunt. And as far as the vehicle was released to her as well.
And did you have to wait for the aunt to come to retrieve the minor child as well as the vehicle?
Yes.
Court's indulgence.
While you're looking, Madam, how long did you have to wait for?
I don't recall.
Is it in your report?
No, I'm sorry.
Okay, all right.
No further question, Your Honor.
All right. Anything further, Madam?
Yes. Good afternoon.
Good afternoon.
Could you please explain to us what distinguishes the FIT team from a regular street patrol officer?
The FIT team, we are proactive in which we go into areas where we receive complaints from citizens about high crime in relation to robberies, drugs, guns, gangs. What we do is we conduct traffic stops and suspicious person stops.
Okay.
A regular patrol officer, they would just be a first responder responding to 911 calls.
Would it be fair to say that one of the things that distinguishes the FIT team from a street patrol officer is to go beyond the stop?
You said go beyond the stop?
Yeah, beyond the stop, beyond the traffic violation.
I don't understand what you mean by that.
Instead of just doing a traffic violation, the FIT team, they are involved in, like you said, high crime situations, robberies, guns, drugs, things of that nature. Would it be fair to say that the FIT team goes beyond traffic, meaning if they do a traffic stop, that they go beyond the stop to try to get more information about the type of crimes that you guys investigate, or the FIT team investigates?
Yes, when we conduct our traffic stops, we do look for different things during our traffic stops, and that does go beyond a traffic violation.
Were you in plain clothes?
Yes.
Now, on your direct, you said window tint was one of the reasons that you pulled this vehicle over. What were the others?
I don't recall the traffic stop being more than the windows being tinted.
So that was just a misspeak? You said one of the reasons?
Yes.
Okay. Now, why were you specifically in this area on this date? Was there a specific reason?
There's no specific reason. In most situations, we are sent to areas, like I said, we get complaints from civilians, in which our command staff sends us to certain areas. And I don't remember that day in particular, us being sent to that specific location.
Okay. And on this day, you were riding in a Ford Explorer?
Yes.
Okay. And you were in the Ford Explorer with two other officers?
Correct.
Okay. And where were you specifically in the Ford Explorer? Front seat, back seat, passenger, driver?
I don't recall.
Did you specifically observe window tint?
Yes, I did.
Okay. Could you could see the driver or the passengers in the vehicle?
Not through the tinted windows.
Now, what time was this vehicle pulled over?
I do not recall the specific time, but I'm sure I documented my report, if it's okay if I can look at it.
You wrote a report?
Time. Officer Maldonado.
Okay. Did you write a report?
No, Officer Maldonado wrote the report.
Okay. Once the vehicle was pulled over, you stepped outside of the Ford Explorer, correct?
Correct.
All right, immediately? You immediately stepped out of your patrol vehicle?
Yes.
Okay. And you stated that you approached the vehicle, you went with the whole team?
Correct.
Okay. And what side of the vehicle were you standing on?
The passenger side of the vehicle.
Were you standing on the passenger side in the front by the driver, by the front passenger side or the rear passenger side?
I don't recall if I was in the front, but when I approach vehicles, I'm usually in between the front and the back side of the vehicle. Okay. So it'd be in between the rear passenger side and the front passenger side.
And when you approached this vehicle, tell us the first thing that you did.
When I approached the vehicle, the first thing I saw was the tinted windows.
Okay.
And then I also saw there was a child in the vehicle and a female passenger.
Okay. So you could see through the windows once you were standing?
Once the windows were rolled down, correct.
The windows were rolled down?
Correct.
Okay. So no one told you that they couldn't roll the windows down?
Sorry?
No one told you, no passenger in that vehicle told you that they could not roll the windows down?
Yes, so when we approach vehicles, the windows usually roll down, and if not, the doors are open, just in those cases, usually because the windows are freshly tinted.
Okay, instead of telling me about what usually happens, will you tell me what happened at this particular incident?
Okay, so approaching the vehicle, once I saw inside the vehicle, the only thing I can recall is seeing a front passenger female who I interacted with, and a child in the back seat.
Okay, all right, let's slow down a little bit because I'm not sure how you saw inside the vehicle yet. All right, so you approach the vehicle, you're standing on the passenger side. Tell me what happened next. You approach the vehicle and then what?
Approached the vehicle, I approached the passenger on the passenger side of the vehicle, which was Miss Pierre.
Okay.
Once the vehicle door was opened, I encountered Miss Pierre.
Okay, so you asked Miss Pierre to open her vehicle door?
Correct.
You did not ask her to roll down her window?
No.
Okay.
Did I misspeak on that?
It's all right, we'll move on to the next question. All right, so you asked her to open her car door and she complied?
Correct.
Okay. All right, and then what did you do next?
I asked Miss Pierre to step out the vehicle.
Okay. All right, so you immediately asked Miss Pierre to step out of the vehicle?
I don't recall how soon I asked her to leave the vehicle, but I do remember asking her to exit the vehicle.
Okay. All right, time's pretty important here. So tell me, and maybe this is easier for you to tell me in the court kind of continually what you did next so we can see about how long that took. So you approached the vehicle, you asked her to open the door, she opened the door, correct?
Correct.
Then what'd you do next?
After she exited the vehicle, I had a conversation with her outside the vehicle.
Okay. All right, so it didn't take long for her to exit the vehicle upon you approaching the vehicle?
I don't recall the exact time. I know that you say time is important, but I cannot recall from when the amount of time it took us to get her from outside the vehicle.
All right, is less than a minute fair?
I do not recall, I'm sorry.
Okay, do you recall what you were doing or saying within the time before she stepped out of the vehicle?
No.
No? All right. Okay, would it be fair to say that you probably was not standing there doing nothing?
No, usually we approach the vehicle if an officer, in that case, is speaking to the driver of the vehicle. We see the occupants inside the vehicle. There's no time limit or there's no standing around. So I couldn't tell you the exact amount of time I took to speak with her or move her from the vehicle.
Okay. All right, so the answer is, I don't know.
Correct.
All right. All right, so you asked Ms. Pierre to step outside of the vehicle, and then where did you, when you had her step outside the vehicle, what did you do? Did you stand there right outside the vehicle, or did you walk away with her?
We stepped away from the vehicle, but not very far away from the vehicle.
Okay. All right, and you asked Ms. Pierre to step away from the vehicle to isolate her?
No.
Okay. May I approach and grab Defendant's Exhibit 1?
Yes, ma'am. You certainly may.
You have the report?
Yeah.
Okay. All right, so why did you ask Ms. Pierre to step outside of the vehicle?
I do not remember the exact reason why I asked her to step away from the vehicle, but it's very common whenever I see a female or a child in the vehicle, if I, just based off my experience, see that someone appears to be nervous, mainly a child or a female, I will put them to the side.
Okay, and right now you're generally speaking, you're not talking
Correct.
about this incident?
Correct.
All right, so here you do not know why you asked?
No, ma'am.
Okay. All right, and if another officer thought that, well, if another officer stated that you asked Ms. Pierre to step out the vehicle to isolate her, that's nothing that you told that officer?
There may be...
Oh, wait. Other objection, basis?
The form of the question?
I sustain this the form.
I'll rephrase. Did you tell any other officers that you asked Ms. Pierre to step out of the vehicle to isolate her?
No.
Now, once you isolated Ms. Pierre from her family and friends, tell me exactly.
Objection, Your Honor. Again, form of the question.
Once you isolated Ms. Pierre from the individuals that she was riding with,
Objection, Your Honor. Again,
what's
the use of the term
objection?
isolation because the officer has not testified to that.
Okay. Once you asked Ms. Pierre to step away from the vehicle, you spoke to her privately.
Correct.
Okay. Was there any other officers with you when you spoke to her?
No.
Okay. All right, so none of the passengers was there that she rode with, correct?
Correct.
And none of the officers was there?
Correct.
And you asked Ms. Pierre if there was anything illegal in the car?
Correct.
And she told you it was not?
Correct.
Did you ask Mr. Nichols if you could search the vehicle?
No, I did not.
Did you ask any other passengers in the vehicle if you could search the vehicle?
No, I did not.
And do you have independent recollection of this incident? Besides what's in your report? Okay.
Yes, I do.
All right. All right. So you asked Ms. Pierre. You tell us in the court exactly what you said to Ms. Pierre.
So I remember removing Pierre from the vehicle. I remember asking her if there was anything illegal in the vehicle. She said no. And then I asked if it was okay for us to search the vehicle, and she said yes.
Okay. All right. And you had no other conversation with Ms. Pierre around this time frame?
No, ma'am.
Okay. All right. And do you know at what time Ms. Pierre told you that you had consent to search the vehicle? Do you know the time?
No, ma'am.
Okay. Was the vehicle immediately searched after that?
Yes, ma'am.
Did you participate in the search?
No, I did not participate in the search by myself. Whenever there's a search that's conducted, and in this case, there was a young child, and the female, I stand to the side with them.
Okay. All right. Do you know where Mr. Nichols, where was Mr. Nichols during the search?
Where was he during the search? Off to the side of the vehicle.
Was he standing off to the side of the Miss Pierre's vehicle?
Correct.
The one that you searched?
Correct.
Okay. All right. When you first when you first stepped out of your vehicle and approached the vehicle with your fellow officers, right? It's your understanding that what officer approached your driver's side of the vehicle?
I believe it was Officer Maldonado that approached the driver's side.
Okay.
I don't recall where the exact position of every officer. I just recall my position, which was on the passenger side of the vehicle.
All right. So you didn't participate in the search. You stated that, right?
No, ma'am.
Okay. All right. And you were standing just outside of the vehicle
Yes.
during the search? Okay. Did you have any conversation with Mr. Nichols during this encounter?
Not that I can recall.
Did you have body camera
Yes.
for the date of this incident?
Yes.
Okay. Have you tried to locate that body camera footage?
No, ma'am.
Do you know if that body camera footage is still in existence?
No, ma'am.
Your Honor, may I have one moment?
You may.
No further questions, Your Honor.
All right, anything further from the stage?
Nothing additional, Your Honor.
Agent Chisholm be permanently temporarily excused for purpose of motion.
Permanently excused for the person of motion.
All right. Madam, thank you for your patience with us. I'm going to excuse you for the purposes of the motion. Please don't discuss your testimony except the attorneys in this case, okay?
Thank you.
All right, thank you, madam. Ms. Hilton, any other witnesses?
No witness for the purpose of this 2017.
Okay. We're going to move on to the 2018 one at this point in time to stop, or?
Can we argue on this one first?
Sure. First, all right. Does the defense have any witnesses or evidence for the purposes of 2017 stop?
No.
Okay. All right. We'll go to argument at this point in time.
Your Honor, first I want to address standing as it relates to Mr. Nichols first, and then depending on the court's ruling with the standing issue, I'll reserve argument for the second issue. Your Honor, the state believes that Mr. Nichols does not have standing to challenge the stop of this vehicle. Your Honor, I'm going to direct the court, and I apologize, I do not have a copy for the court, but Hall v. State, which is 223, Georgia Appeals 211, which is a 1996 case, but it is good law.
What's the citation?
Sure, Your Honor. Hall v. State.
Okay.
223, Georgia Appeals 211. And Your Honor, what is held inside of that case is that a protected privacy interest giving rise to standing the challenge of a search is a person's possessory or property interest in the vehicle itself or some item found therein. And a person who has been loaned a car while not acquiring any property interest in the car does have a present possessory interest giving rise to a reasonable expectation of privacy. However, the use of a car, in this particular case, the defendant in that case had a car that was a rented car. It's considered a bailment. And when an individual has a car that's a bailment, that person's standing to complain of a search extends only so long as he was in possession of that vehicle. In this particular case, Your Honor, we are arguing that Mr. Nichols was a bailee of the vehicle owned by Ms. Fabian Pierre. And so his possessory interest would only be so far as he was in possession of that car. It is the state's contention that once Mr. Nichols was arrested for being an unlicensed driver of that vehicle, and he was arrested not just being an unlicensed driver, but for the 4 outstanding warrants that he had, that his bailment terminated and any expectation of privacy, derivatively or not, his standing to complain about this search were extinguished because he no longer had possession of that car at that point in time, because he was A, an unlicensed driver, and B, had 4 outstanding arrest warrants, that he no longer had standing to challenge the search of that vehicle. So that's the state's first position, Your Honor, is that Mr. Nichols does not have standing, given that his bailment concluded at the point at which he was arrested for those warrants for being an unlicensed driver and for the 4 warrants.
All seems to indicate that there's no Georgia case. This is back in 1996. But which examines the scope of a bailee's reasonable expectation of privacy in a vehicle, but other jurisdictions have. So, have you found anything earlier or anything that the courts, Judge Johnson writing for the majority at this point in time, the Court of Appeals, have you found anything else?
Hall was the first case. So Hall was the first case that addressed that issue, and that was what was found, is that given the bailment, Hall did not have standing to challenge.
I don't think that's what Hall indicates. Okay. Respectfully, Hall argues he had reasonable expectation of privacy because it was a loan to him. So, And it looks like it says, okay, I see what you're saying. So you're saying that Hall's use of the car created bailment, and then under Hall versus State says we hold his standing to complain of a search extended only so long as he was in possession of the car.
Correct.
All right.
And what we're saying is,
in the car up till the time you stopped, though, wasn't he?
but until he got arrested. So we're saying at the moment that he got arrested for being an unlicensed driver and the 4 warrants, that he no longer had a right to the vehicle because he can no longer drive the vehicle. He was going to get arrested. So his bailment ended at that point in time once he was arrested for being an unlicensed driver, and then subsequently the four additional warrants. And so because of that, his present possessory interest ended at that point in time. Therefore, being unable for him to challenge what was subsequently found in the car.
All right, okay, I understand what you're saying. All right.
Thank you. And then additionally, so the only person who had consent or had the ability to consent to a search was the owner of the vehicle, who was Ms. Pierre, who gave the consent to search.
Gotcha. Okay, all right, madam.
Okay, Your Honor.
How would you distinguish Hall, Ms. Westmoreland?
Well, I'm reading Hall now, but it looks like in Hall, the car was impounded without objection. And at that point, the bailment terminated and the expectation of privacy terminated. We have nothing like that in this case.
Well, they're saying, so what the state's saying is that your client doesn't have a reasonable expectation of, doesn't have standing because that it was a bailment. It is basically a bailment, meaning that he's not the legal owner of the car, he's just driving it. And that and that his standing to complain of a search only extends so long as he's in possession of the car. So once he's arrested, and then the vehicle is given back to or given to the Ms. Pierre's mother at that point in time, his possessory interest ends and he doesn't have standing.
Okay, so I do not agree with that and will argue against it.
Look, I'm reading along with you, okay?
But, Your Honor, before we even get there, these officers were very confused in reference to time and how long everything took. But Mr. Nick...
We're going to object because, again, before we even...
Yeah, you got to get the standing first. Let's deal with the standing first, okay?
Okay, all right, so the reason why I brought that up, Your Honor, is because the state has nothing to even prove that he was arrested before the search.
Your Honor, and again, that's not about standing. She doesn't even get to argue that until she says that her client has standing.
Okay, all right, so Your Honor, we have standing for a few reasons. The driver of a car has a reasonable expectation of privacy, that even a car that he does not own, United States v. Cooper, 133 Fed 3rd, 1394. Your Honor, I also have, and I have a copy for you.
What's the citation for Cooper? 193 F 3rd, what?
1394, 11th Circuit, 1998. You know, may I approach? I have another case.
Sure. You can give it to Ms. Weaver. Thank you.
United States v. Flores, 81-4339. That's a 2023 case. Your Honor, in this case, this was a rental car. The defendant in this case did not own the car, nor was he listed on the rental agreement. But the court reasoned in this case that due to the fact that he obviously had permission because he was possessing the car and or operating the car, and that the officers observed him inside of the vehicle, that he had a reasonable expectation of privacy to show Fourth Amendment standing.
Can we get a cite for Cooper once more, Your Honor?
133 Fed 3rd, 1394. Your Honor, in Flores, I believe at 343, it states, the court reasoned that one who lawfully possesses or controls property will in all likelihood have a legitimate expectation of privacy by virtue the right to exclude. Your Honor, this case goes on to say possessing keys suggests lawful possession, permission is lawful possession.
Once more, cite for Flores. Madam.
That's the one, I gave it to him. No?
Thank you.
Your Honor, as a quick side note, in this case also deals with standing being proven by the defense through the state calling a witness, through that we can prove standing through cross-examination by the state calling a witness, and in this case specifically that witness was the arresting officer. And that officer testified that he observed this individual in that vehicle, operating or possessing and or controlling that vehicle. And the court said in this case, and they actually used the words common sense, that he had an expectation of privacy to this vehicle because he was using it and he was controlling it and he was operating it and he had the permission to use it. You do not have to own a vehicle for your Fourth Amendment right to apply.
You got any other Georgia cases on this point, Ms. Westmoreland? From our highest court?
No, Your Honor.
Grand Court of Appeals decisions?
Your Honor, I'm sure that I could within a few minutes, but and I understand that. No, Your Honor, I have the 11th Circuit case that I provided, and I also have the 3rd Circuit case that I provided. In the 3rd Circuit case quotes several other cases that has this exact same conclusion that the court cites Baker 221 Fed 3rd at 443. The court also cites the 7th Circuit, the 10th Circuit. I can look in here and see if they cite the 11th Circuit also. But, Your Honor, all these cases say the same thing, that if an individual has permission or if they are in control or possess a vehicle, that, you know, I'll quote, if an individual has the owner's permission to use property, society surely recognizes this as reasonable. Where the defendant offers sufficient evidence indicating that he has permission of the owner to use the vehicle, the defendant plainly has a reasonable expectation of privacy in the vehicle in standing to challenge its search.
All right. Okay. All right, thank you.
Sure. Your Honor, the two cases cited by Ms. Westmoreland are distinguishable in this case. If Mr. Nichols had never got arrested, if he had never been unlicensed and been arrested, then that position would stand. What we're saying is he did have a privacy right and a possessory interest until he was arrested for those unrelated matters. Once he was arrested, that bailment concluded, he no longer had a possessory interest in the vehicle. So had he not had a warrant, had he not been unlicensed, then yes, he would have standing. But at the point in time that he was unlicensed to drive the vehicle, so he shouldn't have been driving it in the first place, and then he had 4 additional warrants, he no longer had his possessory interest ceased at that moment, and he lost the possessory interest in the vehicle. So that's why these cases are distinguishable from what happened in this present case. It is because of the arrest that he lost his possessory interest, not because someone allows him to have the car or use the car, but once he was arrested, his possessory interest, he no longer had it, Your Honor.
Your Honor, may I briefly respond to that?
Yes.
Your Honor, we stand on the cases that we have provided the court, but additionally is that this vehicle was searched prior to Mr. Nichols being arrested anyway. The officer testified that he did not do that arrest till the end. I asked him that, and he testified to that, and the defense can prove standing through cross-examination of a state-called witness. That's exactly what happened in the case that I just provided to the court. And the court speaks about it. The court states that this is how the defense proved standing. They did it through the government's own witness, and that the state called that witness to the state is stuck with the witness testimony. And he testified that that arrest did not happen until the end. The search was already conducted before Mr. Nichols was arrested, regardless, even with the argument that the state is making now.
Okay. All right, given the facts and circumstances, I'm going to find Mr. Nichols has standing. So call your next witness.
You're going to find that he does have standing?
I'm going to find he does have standing.
Okay, Your Honor. So there's no more witnesses. We just have to argue.
Okay.
Argument, but we're reserving our argument.
Okay, all right. You have any other witnesses, madam?
No, Your Honor.
Okay, all right. Go ahead.
Your Honor, we rely on our motion and our particularized motion in the record today, but I do want to point out a few things. Your Honor, this was not a traffic stop by regular street patrol. This was a traffic stop by the FIT team. And Your Honor, they're not looking for window tints. The FIT team primary duties is serious crime, robberies, things of that nature. And on this particular occasion, July 3rd, 2017, the FIT pulls this vehicle over. They all exit the vehicle. They all exit. All of the officers exit their patrol cars. They all surround this vehicle. They do not even ask. I mean, they almost unapologetically is not even interested in window tints. They do not ask any of the typical window tint questions like, do you have a medical card? Does anybody have a medical card? Were these windows factory tinted? None of that. Your Honor, as soon as they as soon as they approach the vehicle, they're immediately interested in everything and anything beyond window tint. As a matter of fact, the first officer, Sergeant, he even stated, he said, listen, our purpose is to go beyond a traffic stop. Your Honor, this stop was pretextual, and it was meant to harass, and this traffic stop was not based off of the violation that they ended up writing. Your Honor, the officers didn't even bother testing the windows to even see if the windows were.
They did.
No, they didn't even bother testing the windows.
Testified about that. I mean, I should say, Maldonado testified about that.
Your Honor, I'm sorry. I was almost finished that sentence, and I think you'll know where I'm headed. The officer testified that he didn't even bother testing the windows until the end of the stop, to right before.
Pulled them over because of that.
And did not even bother testing the
But they
windows.
tested it sooner or later, right?
Sooner or later, which is going to lead me to the prolonged detention argument. But yes, Your Honor, he did.
How long were they at the stop for?
Well, Your Honor.
5 minutes, 10 minutes? I mean, the testimony Maldonado gave us was, he said, probably 5 minutes from the initial stop to the inquiry of the occupants, right?
So, Your Honor, Sergeant Minato was all over the place in reference to timing, and when I directly, after going back and forth and me suggesting, hey, was it a minute, was it 2, was it 3, even when he guessed 5, and I said, hey, 5 minutes for that type of encounter, he's like, well, I'm not exactly sure. Both the officers at the end of the day said they did not know how long that the traffic stop lasts. The only thing they did know is that they pulled the vehicle over at 4:36.
You'd agree with me, though, that whenever you have a traffic stop, it is lawful for the officers to run license, to see if there's a licensed driver, to see what the status of the occupants are. They can do that. That's within the confines of a traffic stop, correct?
Well, Your Honor, I believe that if they ask those, I believe case law supports that if they ask those questions for another investigatory purpose, then now they are prolonging the stop.
I think you're mistaken.
Okay.
I'm asking you, I'm distinguishing this because on ordinary traffic stop, a police officer can conduct those particular activities as part of the stop without running afoul of the time or extending the time issue. correct?
Your Honor, I've read those cases, and the reasoning why is for safety purposes. No officer here testified in reference to safety purposes.
I don't think it's for safety purposes. A stop fairly includes whether or not, the running of a driver's license and the status of the occupants. That's fairly contained within the dictates of a traffic stop.
If it's in relation to that traffic stop, not for other investigatory purposes. That's the whole problem. That's what Rodriguez talks about, is that when the officers are asking questions for other investigatory purposes, that was not for the matter that they stopped.
But I can stop you and check your license, though, and determine whether or not you got a valid license for any traffic stop.
Absolutely.
Okay, so that's what they did in this case.
Well, Your Honor, actually, what they did in this case is that they asked Mr. Nichols for his identification, and he told him he did not have any.
Okay.
They immediately detained.
So they can run him at that point in time, right?
And they did, and his information came back immediately, as the officer stated.
All right.
And from that point on, the officers' questioning and everything that they did for several minutes was investigatory for another matter. That prolonged the stop, and we know exactly why they did it. They were FIT, and they are trained to go beyond the stop because they're looking for robberies, they're looking for serious crime, so they immediately went into their job primary duties, and that's exactly what they started investigating. They didn't even bother testifying, hey, we just asked for ID off a routine, hey, we had safety concerns, hey, someone looked nervous. They told you. It's our job to go beyond the stop, and that's exactly what they did. And Rodriguez and other cases tell us is that when you prolong a stop by asking questions or doing any activity for other investigatory purposes, you have prolonged the stop, and that's exactly what they did.
Okay.
Your Honor, our primary arguments are pretextual, which I started with, and the prolonging the stop in Rodriguez v. State says even a short one. Even a short one. Millie v. State, that's 866 Southeast 2nd, 639, Georgia App 2021, says even a short prolongation is unreasonable to justify a continuation of the detention to pursue a different investigation.
What's the citation for Miller?
Your Honor, I believe I'm going to give you the 866, Southeast 2nd, 639. It's a Georgia Appellate Course 2021.
I'm sorry.
639.
So what's the citation, please?
866.
866.
Southeast 2nd, 639. That's a Georgia appellate case in 2000.
How is Millie spelled?
Neely.
Oh, it's Nilly. One more time, N-E what?
Neely.
Neely, okay.
Neely. And Your Honor, I know that the court has Rodriguez v. State, 2014. Your Honor, I'd also like to give the court Wagner v. State. That's a Georgia appellate case, 1992, 424, Southeast 2nd, 861. And what that case says, Your Honor, is that an officer is not within their lawful discharge of their duties when they approach and question individuals in reference to a matter other than what they came to the traffic stop.
All right, anything else, man?
Your Honor, in Rodriguez, the court explains that traffic stops are generally prolonged in two different ways. Either the traffic stop is prolonged because the traffic stop goes beyond the conclusion of the investigation, or the traffic stop is prolonged because the officers perform investigations into other matters. And here, Your Honor, I argue that we have both. Beyond the conclusion because the officers could have pulled Mr. Nichols over. They could have asked for identification, taken Mr. Nichols out of the car, take him immediately back to the police car, run his name, his information immediately came back. They even immediately knew that he had warrants. But instead of arresting Mr. Nichols or writing him his citations and ending the traffic stop because the window tint investigation is over.
They had 3 other people in the car and a baby.
I understand that, Your Honor. I understand that. And instead of it,
You have to look at the totality of the circumstances.
you do, and Your Honor, and think of, and Your Honor, the totality of the circumstances is this. They're there, they pulled this vehicle over for a temp violation. They have 3 individuals in the car, one who is the registered owner, and they do not even bother to ask her about her window tint. Your Honor, credibility is always at issue.
Yeah, but you see, you have a couple of things going on in
Sure.
circumstance. So I have to take a look at that when I look at the totality of circumstances. And going back to Neely, Neely is distinguishable from the case you have here because once the officer learned that there were no warrants, he didn't conclude the traffic stop. Here, your officer determined there are warrants. So thus that extends the time for the traffic stop, within the facts and circumstances.
Your Honor, absolutely agree, but that's not what the officer testified to. He did not say our traffic stop took time because warrants came back, so I started doing.
But that's what I heard. I mean, so that's what I heard in terms of the evidence presented by the state.
So actually, Your Honor, what the officer testified to was that, remember, Mr. Nichols was the first person out of the car. That's what the officer testified to. He stated that he took Mr. Nichols directly to his patrol car. He immediately ran his name, and he used the words that the result was instantaneous. That's exactly what he said. And then after that, he did not testify that, hey, what I did then was starting arresting Mr. Nichols or writing his citation, or I moved forward with because he had all of the information.
But you had 3 other people in the car.
Right, Your Honor, and those 3 other people in the car, even because with the second prong of prolonging is whether the officers were diligent, the officers did not testify. We can't read into it. The officers didn't testify, hey, while I was doing this with Mr. Nichols, and I was processing him and arresting him and whatever the case might be, my other colleagues was getting the other passengers' information because that's routine or that's safety or something of that nature. That's not the testimony that we received today. The testimony that we received today is, hey, we're FIT, we're trained to go beyond the stop, so while one officer was handling Mr. Nichols, we were going beyond the stop trying to get more information, ask if there was anything illegal in this vehicle. The officers did not testify that they really did anything in reference to the other passengers, including the owner, to try to wrap up the tent investigation. And the officer that arrested Mr. Nichols testified. He just sat there.
Well, that's because they got consent from the driver and searched the vehicle and found other contraband.
Well, Your Honor, listen, Your Honor, I think that consent, and I think this is the state's burden, is shifty at best. The officer had very trouble remembering. She didn't really remember what she did, what she said. She couldn't heavily rely on her own report because she did not have one. The body camera, the officer who alleged allegedly took the consent had body camera and the other officer, the sergeant, had body camera. This case was indicted in May of 2017 when that body camera was still available and still there, and the state didn't even bother to get the body camera. But that was a private conversation. This individual, Ms. Pierre, was isolated from the individuals that she rode there with. The officer that testified kind of gave this generally, this is what we do, but I don't remember why we did it in this particular situation. And, Your Honor, for this court to decide that consent was free and voluntary, I don't even think that the officer who testified was able to give enough information in reference to that. She barely remembered what happened. But, Your Honor, so that's my argument in reference to the consent, is that I don't think that you have enough to be able to say that she gave free and voluntary and valid consent, and it's the state's burden to prove it, and I don't think that they did. But, Your Honor, even a short amount of time, these officers testified what their primary purpose and duties, and I think the problem that you have here, Your Honor, and we can't ignore it, is that because they're field investigation team, they are taught a different level of training, and they are released out here to patrol areas, and they are given a task. And that task is pull someone over if you can, but go beyond the traffic stop. That was his exact words, and you just can't get out of it. Go beyond the traffic stop. And that's exactly what they did. And the problem is you can't go beyond the traffic stop investigating other matters while you have somebody detained, and that you're going into different investigations, and you could be moving quickly and diligently. And in the shortest amount of time, it's too long, according to Rodriguez.
All right. Thank you, madam. All right.
Thank you, Your Honor. So,
You got three arguments to address, Ms. Hilton.
Yes, Your Honor.
One is that they say you're saying the stop was pretextual, the stop was prolonged, and they didn't have valid consent. Start out with those three things, and you can tell me what else you need to argue.
Pretextual was one. What was the second one, Your Honor?
Prolong the stop. The stop was prolonged. I think Ms. Westmoreland cites for that proposition neatly.
Your Honor, I want to frame, and I'll address all three, but just want to frame the facts again, Your Honor, because I think that the facts and some facts are being left out, which I think is important in the evaluation. So what we have, Your Honor, is that the officers see a car with a heavily tint, so much so that when Sergeant Maldonado stopped the vehicle, what he advises that Mr. Nichols tells him is that we just got the windows tinted, and so he had to open up the door. Both of them, both Sergeant Maldonado and Agent Chisholm, both advised that it was so dark that they could not see inside of the vehicle, Your Honor. So that is the reason for the stop. Once they actually are able to speak with the occupants inside, Mr. Nichols and Ms. Pierre, they realize it's 4 adults in the car and a minor child. Once they detain Mr. Nichols and ask him whether or not he has ID, they detain him, move him to the other vehicle, as Sergeant Maldonado says. They run they find that he's unlicensed, and then also find that he has additional warrants. It is during that time that that Agent Chisholm is speaking with Ms. Pierre, and Ms. Pierre advises that, Agent Chisholm advised that Ms. Pierre gave consent to search. That is when the male officers search the vehicle. Agent Chisholm is sitting on the side with Ms. Pierre, and the vehicle is being searched. All of that is taking time. And then importantly, once the search was conducted, what Sergeant Maldonado said on my redirect was they had to wait for the woman who was coming to take the car and the child to get to the location. So they had to wait that time, which in totality, all of that time was why this stop was prolonged. Not because of the search, Your Honor, but because of also having to wait for someone to come and retrieve the child and the vehicle because all occupants were getting arrested. So that is some of the facts that I think we need to frame. So let's first discuss the pretextual stop. I'm going to direct the court to Garcia-Carrillo, Carrillo, v. State, which is 322 Georgia App 439. And in that case, Your Honor, this is a case in which the defendant, Mr. Garcia-Carrillo, thought that he should have had a motion to suppress be granted because the officer had a lack of probable cause to stop him and that the stop was pretextual. What the court said is, we likewise find no merit in appellant's claim that his motion to suppress should have been granted because the stop of his vehicle was pretextual. A suppression motion arguing that a traffic stop was pretextual necessarily fails where an officer observes the motorist committing even a minor traffic violation. Here, the officer said that the window tint, and not just said it, but also tested the tint, was that Mr. Nichols was driving a vehicle with an illegal window tint. It was...
What was that citation again, ma'am? I'm sorry.
Sure, Your Honor.
The street?
322 Georgia App 439, and it is a...
What's the name of the case again?
Garcia-Carrillo, Carrillo. That the window tint measured 21%, which is substantially lower than the 32%, which is the legal tint limit. And that's the plus or minus 5 that one could have. So the fact of the matter is they were driving around in a newly, freshly illegal tinted window car. Once they stop Mr. Nichols, and they speak with him, he's now driving an illegal tint, but he's also unlicensed, so he shouldn't be driving anyway. So now we have a second reason why Mr. Nichols is detained. Then, not even detained, then we learn that he has warrants. At that point, while they're talking to him and finding out about the warrants, Your Honor, they have to confirm those warrants. They have to make sure that those are valid warrants. They ask Ms. Pierre for consent to search. She gives them the consent in which they find guns and drugs. So as it relates to the fact that it was a pretextual stop, Your Honor, again, the courts have held, and this is good case law, that again, when there is a valid traffic violation, this stop is not pretextual. Secondly, Your Honor, and I'm going to actually go to the consent. We're going to deal with consent next, Your Honor, is what the courts have also said, and I'm going to direct the court to Hall v. State. Let me get the right citation, Your Honor. Which is 306 Georgia Appeal 484, which is a 2010 case. That the Fourth Amendment is not violated when during the course of a valid traffic stop, which we have here, an officer requests consent to conduct a search of the vehicle. That's at Hall 306 Georgia at 486. We have here that the officers received consent from Ms. Pierre. Now, the defense want to contend that they don't know if it's credible or not, but let's take the totality of circumstances. They speak with Ms. Pierre, they search the vehicle, and then they allow someone to take the vehicle. And they, as opposed to, they could have impounded it. but they didn't. They waited for someone to come. They waited for someone to take both the child. They could have called defects. They didn't do that. They waited on scene for someone to come pick up the child and take the car. When you look at the totality of what interactions occurred there, it is credible that Ms. Pierre gave consent. They told you that she first said that there was nothing in the vehicle, and then after that they asked for consent, and she gave that consent, and they ended up finding both drugs and a gun. And then subsequently Mirandized everyone to find out whose stuff it is, and when no one claimed it, it is at that point they arrested everyone. But they're trying to find out who does the stuff belong to, what happened to it. They're having conversations with the individuals and the occupants of the vehicle. So when you look at the totality of the circumstance, you look at what the officers testified to, it is credible that Ms. Fabian, given what was happening at the time around the car, her child is out there, it's possible that she's going to get arrested, that she gave consent to search the vehicle, and that's what happened. There's nothing here to contend otherwise that they did not have consent to search. So, Your Honor, we do believe that the testimony prevails that they did have actual consent to search the vehicle, given everything else that happened that evening as it related to the stop of this car. And then the second concern is that it was prolonged. Again, Your Honor, given the totality of everything that occurred that evening, Your Honor, and what Sergeant Maldonado said was it took a long time for her to come. Her being the person who was going to take the child in the vehicle, that's what they were waiting for. But for the officers to have confirmed that Mr. Nichols' warrants were still valid warrants, for them to search the vehicle, for them to wait for the aunt, I believe, of Mr. Nichols to come and get the child, all of that, when you look at the totality, it is not a prolonged stop, given everything that they had to do. It wasn't just that there was a traffic stop and they prolonged them. The traffic stop yielded a consent, which yielded the search, which yielded the finding that they were that Mr. Nichols had warrants, and then all of these individuals were ultimately arrested and charged for possession of the items in the car. That's not a prolonged search. That is an actual search. That's the time that it needed for the search to be complete. And in addition, Your Honor, really what... So for those reasons, Your Honor, we don't believe that it was a prolonged stop. It's not a pretextual stop. And given the totality of the circumstances, Your Honor, we believe that the evidence would support that the officers did have consent to search the vehicle. With everything else, Your Honor, we stand on our pleadings. We did send a copy over to the court yesterday evening, Your Honor. I believe it was filed this morning, but we will stand on the pleadings from there, unless the court has any additional questions, Your Honor.
Thank you.
One more thing. I failed to remember that Ms. Pierre was going to get arrested because she had a failure to appear. So the car would have been searched because she was getting arrested, the owner, as well as Mr. Nichols was going to get arrested as well. And so for that reason, the car would have been subject to a search prior to, even though they allowed for the aunt to get the vehicle, the car would have been subject for a search because of the incident, but it's certain incidents of arrest.
All right, the court having considered the particularized motion to suppress evidence and or other relief filed by Mr. Nichols' legal team on November the 8th of 2023, state's response, as well as case law that's been cited for the court's information and consideration. Citations have already been given to Neely versus the state, Rodriguez versus the United States, Garcia, Carrillo versus the state, and Hall versus the state, among others. The court, in this particular circumstance, summarizes as follows. This case involves the seizure of evidence or traffic stop that occurred on July the 3rd of 2017. It alleges that Officer Maldonado was on parole with other officers when they initiated a traffic stop at the 2016 silver Volkswagen Jetta for a alleged window tint violation. There were multiple occupants of the vehicle, to include Mr. Nichols as well as Miss Pierre, the owner of the vehicle. Testimony also alleges and shows that there was Miss Pierre gave consent to search the vehicle during this particular encounter. The search of the vehicle yielded some drugs as well as a handgun. All the occupants of the vehicle, except for the small minor child, were charged with possession of Schedule 4 narcotics, since the narcotics were found inside the vehicle's center console, and possession could not therefore be attributed to any particular occupant. And the handgun was located underneath the front seat of the vehicle, and Mr. Nichols was charged with possession of a firearm during the commission of a felony. It is alleged by the defense that this particular stop was in fact pretextual and in violation of the defendant's rights under the 4th and 14th Amendments to the United States Constitution and Article 1, Section 1, Paragraph 13 of the Constitution of the State of Georgia of 1983, and that the acts on part of the police officers constituted an unreasonable and unlawful search and seizure of this particular circumstance. The defense specifically argues that one, the stop was pretextual; two, the stop was prolonged; and three, that the consent given by Ms. Pierre was not freely and voluntarily given in this particular circumstance. In considering the arguments of counsel, the court will address each of the defendant's arguments. In terms of the stop as being pretextual, the court of course, a traffic stop has to be based on reasonable suspicion. And this particular circumstance, The court would cite to Baggett versus the state at 367 Georgia Appeal 851, decided by our Court of Appeals of Georgia on 5 June of 2023, citing therein Betancourt 322 Georgia App at 204-205, explained that an investigatory stop of vehicle with unlawfully tint dark window tinting, during which the defendants consented to search the vehicle approximately 20 minutes after initial stop, was not unreasonably prolonged beyond the time to fulfill the purpose of the traffic stop. Also, Betancourt, as well as, and that's Salmeron, and that is SALMERON, 280 Georgia at 737. It does not unreasonably expand the scope or duration of a valid traffic stop for an officer to prolong the stop to immediately investigate and determine if the driver is entitled to continue to operate the vehicle by checking the status of driver's license, insurance, and vehicle registration. So, the dispositive factor is not the nature or subject of the officer's questioning, but whether the questioning took place during an otherwise lawful detention for committing the traffic violation or violations in the officer's presence. The driver's question gives consent while he's being lawfully detained. During a traffic stop, there's no Fourth Amendment violation. And for that purpose, the state's given the Garcia-Carrillo case at 322 Georgia App 439. In terms of the prolonging the stop, the court just cited Baggett for that particular proposition. Given the facts and circumstances of the matter at hand, this was not a prolonged stop. And in Neely versus the state at 362. Georgia 103. Defines a reason what a traffic stop that is initially justified by the interest in issuing a ticket to the driver becomes unlawful when it is prolonged beyond the time reasonably required to complete that mission. However, a reasonable time to conduct a traffic stop, and this is in Neely, includes the time necessary for the officer to run a computer check on the validity of the driver's license and registration and to check for outstanding warrants and/or criminal histories of the driver and other occupants. And that's citing Allen versus the state, 348 Georgia, App 595, pinpoint 598. And as Ms. Westmoreland has mentioned, even a short prolongation is unreasonable unless good causes appear in the meantime to justify a continuation of the detention pursuant to a different investigation. And that cites Weaver at 490. That's I should say 851 Southeast 2nd 125. In this particular situation, the court has also taken consideration of the testimony of Officer Maldonado, Sergeant Maldonado, and Agent Chisholm. In considering the facts and circumstances of the stop, and takes into account the totality of the circumstances. Probable cause on this particular issue was that the windows were heavily tinted, just tinted. They detained Mr. Nichols, found out he was unlicensed, he had warrants. They got consent to search from Ms. Pierre, and which is the third point that the defense makes, that this is not freely and voluntarily given. And in consideration of the Fourth Amendment is not violated during the course of a valid traffic stop to an officer questions the driver or occupants of the vehicle and requests consent to conduct the search. Salmoron versus State, 280 Georgia, 735, pinpoint 736. And again, this case also cites the proposition of a reasonable time to conduct a traffic stop includes the time necessary to verify driver's license, insurance, registration, completing paperwork, citation, warning, run a computer check for any outstanding arrest warrants for the driver or passengers. In this particular circumstance, even though the defense has raised the issue of that this may have been because of the type of officers these were, they still didn't arrest, or this stop was not, the court does not find the stop to be pretextual. The court finds also in terms of credibility that the consent was freely and voluntarily given. It's credible under the facts and circumstances as the officers did let the car owned by Ms. Pierre to be released to Mr. Nichols' aunt, and also the child, which also extended the time, for the totality of the stop, and they had to wait and release the car and the child to the aunt, which they could have impounded the car and as the state argued, taken other steps to send the child to de facto custody at that point in time. So for those aforementioned reasons, the court finds that there was, in fact, probable cause for the stop, for reasonable suspicion, and the court also finds that the stop was not pretextual, that the stop was reasonable in nature, or reasonable in duration, and the consent was given. So for those reasons, the court will deny Mr. Nichols' motion to suppress the 2018 stop on July the 3rd of 2017, and rule it otherwise admissible as long as the state can lay a necessary foundation. So that's my ruling.
I think you said 2018 stop, but you meant the 2017 stop?
2017 stop. Yes, please. All right, so what about the 2018 matter?
We're ready. If I could just have a brief 2 minutes, but we're ready.
All right.
me, Your Honor. Can we have a comfort break?
You may.
Thank you.
All right, we'll take 5 minutes. Are your witnesses here for that case, ma'am?
Yes, Your Honor.
Okay, all right.
Come on, man. Come on, Jackie.
All right, Ms. Hilton, so we're going to transition to the 2018 matter at this point in time from November the 2nd.
I think October 23rd.
Yes, ma'am, October the 23rd, 2018.
Yes, Your Honor.
All right.
It's going to be first Sergeant C. Ross.
All right, summon Officer Ross, please.
Your Honor, do we have the ability to give me sharing access?
No, I don't. Officer Ross, can I get you to approach the witness stand? Come on up. Once you get there, if you would be so kind, turn and face Deputy Ingram before you sit down. Be sworn as a witness, please. All right.
Raise your right hand. You swear firm testimony you give the truth, the whole truth, nothing but the truth?
I do.
Have seen.
All right.
State spell your first and last name.
My technical advisor is on much deserved leave.
First name Charles, Charles. Last name Ross, RSS.
And Sergeant Ross, where are you employed?
I'm employed with the City of Atlanta Police Department.
And how long have you been with the City of Atlanta Police Department?
About 11 years.
And what is your current rank at the City of Atlanta Police Department?
I'm currently a sergeant.
How long have you been a sergeant?
Approximately 3 months.
Okay. Congratulations. And where are you assigned?
I'm assigned to.
Congratulations, sir.
Oh, appreciate it. I'm assigned to the Field Operations Division, which is basically patrol.
Prior to your current assignment, where were you assigned?
I was assigned to the Apex unit.
Okay, and what is the Apex unit?
It's the Atlanta Proactive Enforcement and Addiction Unit.
And what does that unit do?
We're tasked with going out into the community with a citywide unit and basically locating individuals and conducting investigations as far as lower level narcotics all the way up to individuals wanted for robbery and other violent offenses, and conducting investigations and finding probable cause and bringing those individuals before the court.
And prior to becoming a sergeant, how long were you assigned to the Apex unit?
About 3 years.
You now have, I'm sorry, you now have screen sharing capability, okay?
Okay.
About 3 years.
About 3 years. Okay. I want to take you to October 23rd, 2018. Were you assigned with the Apex unit within APD?
I was.
And within the Apex unit, are you assigned to different zones, or how were you dispersed throughout the city?
Based on the leadership at that time, we were currently assigned to various zones throughout the city. My zone was Zone 3.
And where's the Zone 3 area?
That is going to be the area that covers, I don't know streets per se, but Mechanicsville all the way to the Cleveland Avenue border, goes into Hateville.
And taking to that day, October 23rd, 2018, did you have the occasion to interact with an individual by the name of Cornelius Nichols?
I did.
How did you first encounter or see Mr. Nichols?
Well, while reviewing social media, I came across what is believed to be Mr. Nichols' page, which displayed like an Instagram story. On the Instagram story, Mr. Nichols could be seen sitting inside what appeared to be a Chevy or Chevrolet vehicle. He had what appeared to be marijuana in a sandwich bag where he was wrapping it up while engaging in conversation with several individuals standing around. That was the conclusion of the video, pretty much.
Okay. And where were you when you were observing this vehicle? I mean, you were observing this video.
I was on assignment. I was at work. I'm not sure exactly, where my location was.
Okay. But you weren't at the precinct or anything. You were in the street.
I believe so, yes.
Okay. And once you observed who you believe to be Mr. Nichols kind of bagging up drugs, did you know where he was?
Yes.
How did you know that?
So I'm assigned to the Zone 3 area where one of my main focuses of areas of operations was the Lakewood area as well as the Cleveland Avenue area. So I was familiar with the Steele Avenue location because I had been there before. And I know the layout of the actual land.
And when you say you knew the layout of the land, what do you mean?
I've been inside the apartment parking lot area, and I'm familiar with what that would look like.
Okay. So once you saw this Instagram video, what did you do next?
I let my supervisors know. I gathered additional officers to assist me with conducting the investigation. We found a location to stage, and then we went into the location of 2612 Steel.
And when you say you found a location to stage, what do you mean?
So basically, I found a location that was big enough to support myself and supporting officers coming to assist me with conducting an investigation at the location. There, I would have given them instructions on what we're about to do, what we're looking to investigate, and who the target of the investigation would be.
Okay. Once you all stage, what happened next?
Once we stage, like I said, I'd go over the plan, and then we would move towards the actual location and conduct our investigation.
And what was that actual location?
2612 Steel.
All right. And I think you mentioned earlier.
Steel, yes, ma'am.
And is that an apartment complex, a house, a home? What is that?
It's an apartment complex.
Did you all go over, let me back up, about how many officers met with you in the staging area?
I'm not sure.
Once you gave the rules and regulations, you headed over to Steele. What, if anything, happened?
So upon our approach, one of the individuals yelled out 12, which is slang for police. This is a sign or a phrase that's given to alert individuals that are in the immediate area and possibly participating in criminal activity that law enforcement is approaching. Okay. And once you heard someone yell 12, what happens next? We continued on into the apartment complex where I then noticed the possible vehicle in question, which was a Chevy. I'm unfamiliar exactly what kind of car it was. Small Chevy, which was parked next to a white Toyota Solara. There were several individuals sitting on the trunk and on the side of that Solara, and then I noticed upon approaching the vehicle and parking in front of that Solara, Mr. Nichols as well as two individuals sitting in the door frame of the Toyota Solara.
And let me back up. When you saw who you believe to be Mr. Nichols inside the vehicle on Instagram, what kind of car did it appear that he was in?
It appeared he was in the Chevy.
And he said, you don't know what type of Chevy it is. Did you do a report in this case?
I did.
And we're looking at your report, help refresh your memory as to what type of Chevy it was?
Yes, ma'am.
All right. And let me ask you this, in speaking about a police report, did you provide the state with a police report, last?
Yes.
Okay. And why did you provide the state with that police report last week?
After reviewing after reviewing the report that I noticed that the state currently had, I went and looked up the case number myself to get my own copy. And then I noticed additional information in the copy of the report that was on our system.
Okay. And in looking at let me ask you this. Did I show you a report before you went back to the office and pulled up a report?
You did.
Okay. And when you looked at that original report, what, if anything, did you notice about that original report that I showed you initially?
Oh, no. At that point, it looked fine. It was when I got back to my office and I tried to pull up the case number myself for a copy, and I noticed that it was additional information added into the copy that was on our system.
And the copy that was on your system, when was that report done by you initially? Do you recall?
I don't.
Okay. That's fine. Permission to approach around?
You may.
I'm going to show you what's marked Stacy Zimmer number 4. You recognize Stacy Zimmer number 4?
I do.
How do you recognize Stacy Zimmer number 4?
It's official Atlanta Police Department report that I completed.
And we'll look at Stacy Zimmer number 4, help refresh your memory as to the type of Chevrolet in which you initially saw, or it appeared that you saw Mr. Nichols in when you saw him on Instagram.
It's a Chevrolet Sonic.
Well, will it help refresh your memory?
Yes.
Okay. I want you to look at Stacy Zimmer number 4,
okay.
And then once your memory's refreshed, let me know.
Okay, I got you. It's refreshed.
Okay, what kind of vehicle is it?
Chevrolet Sonic.
All right. Now, once you approach, so you were describing that there was another vehicle, a white Toyota Solara?
Yes, ma'am.
All right. And when you all approached, was there anyone inside of the Chevrolet?
No.
Okay. And I believe you just testified to when you got, after you heard 12 and you all got there, what did you see? Once you got there, what did you see? What, if anything, did you see happen to the gray Chevrolet?
So upon entering out and then yelling out 12, I noticed that the vehicle was remotely locked. That means, it makes the audio sound of the horn beeping, as well as the lights from the vehicle will flash to, signify that the vehicle is being locked or unlocked.
Okay. And do you remember how far you were away from the vehicle when you saw that occur?
Nah, I wouldn't be at probably like 20 yards.
Okay. And when you saw that happen, the lights flash, did you see anyone in the vehicle?
No.
Okay. What happened once you actually get inside after you see the car lights flicker?
We exit our patrol vehicles. I then exit the vehicle and smell the odor of burning marijuana. It smells as if it was coming from the direction of the Toyota Solara that Mr. Nichols and the other occupants were inside. I then immediately walked up to them and began my investigation, advising them that it smells like marijuana, and detained them. We ended up searching the vehicle. Inside the vehicle was shake, which is like slang for like small crumbs of marijuana inside the vehicle. I think ultimately, as we got around to the other side of the vehicle, we found a actual small blunt or joint of marijuana laying on the ground.
Hold on, so let me stop you really quickly. And you're talking about when we were in that car. Which car are you referring to at this point?
The Toyota Solara.
All right, and you said that you saw Mr. Nichols at the Solara. How many other people were in the Solara?
So it was Mr. Nichols as well as two black females.
Okay, so let's first talk with the two black females. Where were the two black females?
So one female was in the driver's seat next to Mr. Nichols, who was inside like the door jamb of the vehicle, and another female was in the passenger seat.
Okay, and when you first approached the vehicle and you smelled the marijuana, do you then focus on the Toyota Solara?
Yes.
Okay, and when you said you found shake inside of the vehicle, were you talking about the white Solara?
Yes.
All right, and when you detained Mr. Nichols, did you also detain the other two females that were inside of the white Solara?
Yes.
Okay. Once you detained Mr. Nichols and the other two that were in the white Solara, and you searched inside of the vehicle, you saw the shake, and I believe you said you saw the And at this time, the key was found inside of the center console of the white Solara, not the gray car.
Yes.
Okay. At this point in time, did anyone make claim to the gray vehicle?
No.
Okay. What happens after you find the key to the vehicle?
I detained, well, they were already detained, but I Mirandized one of the females that was in the passenger seat. She was actually the owner of the vehicle.
She's the owner of which vehicle?
The Toyota Solara.
Okay.
She waived her rights to counsel at the moment. I spoke with her about the findings in her vehicle, I believe, as well as the key. As far as the key, she advised that, she didn't know who it belonged to or how it got in her car. At the time that I believe she said at the time that we entered the parking lot and the vehicle was locked remotely, she wasn't paying attention. She was looking down at her phone, so she wouldn't have known, who locked the vehicle.
Okay. After you spoke with her, did you speak with Mr. Nichols at all about the vehicle?
I can't remember.
Okay.
Yeah.
What about the other young lady, the driver?
Can't remember.
But you notated in your report that you spoke to the passenger, who was the owner of the white Solera.
Yes.
All right. After speaking with her, what, if anything, occurred?
At that point, I believe we called K9 out and to do a search of the general area for any additional narcotics. Officer Carney would have came out and brought his K9 dog, Chacon, and he would have conducted an open air smell or search or whatever you want to call it of the parking lot area before he was the K9 was pulled towards the Chevy Sonic. At that point, he did alert on the actual vehicle to the presence of narcotics, which I was notified by Officer Cornelius. And at that point, I would have went back and got a search warrant for the vehicle.
Okay. So once the K9 hit, you did not go into the car, you went and got a search warrant?
Yes.
And were you able to obtain, were you ever able to obtain a search warrant?
I was.
Once you obtained the search warrant, and what car did you obtain the search warrant for?
I took the search warrant out for the Sonic, the Chevrolet Sonic.
Once you obtain the search warrant for the Chevrolet Sonic, what happens next?
Upon receiving that valid search warrant, I returned to actually process or execute the search warrant. I used the key to access the vehicle, and upon entering the vehicle, I noticed that there was a red bag which appeared in that same Instagram video that appeared to be aside Mr. Nichols. I believe that bag was the bag that contained the 17 grams of marijuana that we ultimately ended up seizing. There was also 3 firearms located in that vehicle, one in the not center console, but right there, I believe, by the gear shifter for the Sonic, and 2, one under the driver's side seat and the other under the passenger side seat.
Okay. Before I move on, at any point in time, did Mr. Nichols exert ownership over that car key fob that you found in the center console?
No.
I sustain the objection.
Okay. As it relates to after the search, what, if anything, did you do as far after the search of the vehicle?
I left a copy of the search warrant inside of the vehicle. And to my knowledge, I processed. We checked the firearms to see if they were stolen. 2 of the 3 ended up being stolen, and everybody was processed accordingly.
And when you say everybody was processed accordingly, what do you mean?
Mr. Nichols was, arrested because I had evidence of a direct nexus between him and that vehicle, being that Instagram video that I observed prior to my arrival there.
And that Instagram video was before you came, but once you came, Mr. Nichols was not in that vehicle?
No, he was not.
Okay. And did not claim ownership of that vehicle?
No.
All right. And was Mr. Nichols the only person arrested that evening?
I believe so.
All right. Did Mr. Nichols have any All right. Let's strike that. And you've had the opportunity to watch your body cam video. Have you also, prior to this hearing, been able to watch the Instagram video that you saw that led you to actually going over to 2612 Steele?
Yes.
Permission to approach?
You may.
I want to show you what's in market six exhibit number 1. Do you recognize this exhibit number 1?
I do.
How do you recognize this exhibit number 1?
It's a flash drive that I signed to, say that I reviewed the evidence on it.
Okay. And did that flash drive have that Instagram video as well as your 2 body cam videos?
Yes.
And in reviewing both the Instagram video and the 2 body cam videos, does that appear to be a fair and accurate depiction of, 1, the Instagram video that you saw on the night of the incident?
Yes.
And did it also seem to be a fair and accurate depiction of your body cam video covering what occurred that evening?
Yes.
Your Honor, this time the state, was there any additions or deletions?
No.
Your Honor, this time the state would like to send the state exhibit 1 into evidence.
Your Honor, I'm going to object.
Basic.
Well, on the body camera video, there is an individual who has a conversation with Sergeant Ross. This individual is Mirandized, it's a full-fledged statement, and we're going to object because this is a violation of Mr. Nichols' confrontation clause. This is violation. This is not just hearsay. This is completely different, and, as I stated earlier, Your Honor, the Georgia Constitution, language is broader than the U.S. Constitution, and this is a violation.
Your Honor, again, this is a motion to suppress hearing. Again, this is not the guilt innocence phase. It's for the court to determine whether or not Sergeant Ross had probable cause to get a search warrant, probable cause. The state is arguing that Mr. Nichols does not have standing in this particular incident. But again, this is a motion to suppress hearing, Your Honor, in which hearsay is allowed for the
I'll
purpose.
overrule the objection, so please go ahead and testify.
Permission to publish the...
I'll admit states 1 over your admission now, or your objection, I should say, for purpose of the motion.
Your Honor, I'm also going to object because, from my understanding, the state is presenting this just to refresh his memory. To refresh his memory means he needs to look at it for himself, finish it, and then he can testify.
Your Honor, we're also entering it. For one, we've entered into evidence to show how Sergeant Ross was able to, one, get the initial probable cause to go over to Steele Avenue in the first place, which is the Instagram video. And then when it gets to the particular portion of where, I'm not going to play the entire video, but specifically as it relates to the portion with the key, that I could show that to him for sure, and then see if it refreshes his memory as to where the key was. I don't have to play the entire video, but to the Instagram video, we believe that that's relevant for the purposes of this hearing.
I'm going to overrule the objection.
I'm only going to I will show him the portion of the video for the body cam where the center console is. I don't need to play the entire video unless, depending on what happens on cross-examination. But I am playing the Instagram video.
auntie right here, talking about she want her a young nigga, and Quay right here trying. He trying. Quay right here trying to get in. Auntie said she want her a young nigga. Man, show these man, my boy, man, I got part of the.
So is this the Instagram video that you initially saw before you went over to Steele Avenue?
It is.
All right. And you talked on during your testimony during seeing Mr. Nichols bag some items up.
Yes.
I'm going to about 15 seconds within the video, or a little bit before 15 seconds.
Quay right here trying.
Is this one who you referring to as Quay?
Yes.
All right.
Quay right here trying to get in.
And just at about 7 seconds in, when you talked about seeing him wrapping up or bagging up bags, this is what you were referring to?
Yes, it's actually two parts.
Sorry.
It's actually like, I think 2 parts in there where you can see it. You go further to the end, it hit again.
You want her a young nigga. Man, show these, man, my boy, man.
And he right there got it at the bottom of his hand.
Okay. And when you spoke about the red bag that you saw, is this the red bag back here where the arrow is?
Yes.
Okay. And again, this was the video that preceded you going over there.
Yes.
All right. Now I am going to show you, and I will bring the computer to you to see if it helps refresh your memory as to where the central console. And I'll
First, Marlon, if you want to get up and move around to see that when he's shown that, you're welcome to do so, okay?
Thank you. And let me back up and ask you, I'm not going to play the video, but these are 2 cars you're referencing. Looking here at State's Exhibit, again, number 1, this video, it's not playing, but are these the 2 cars that you're referencing? The car where my arrow is the left, gray Sonic, and then this white vehicle to the right?
Yes, ma'am.
Okay, and when you said that Mr. Nichols was sitting in the door panel, was that on the driver's side or the passenger side?
Driver's side.
And would that be in the crack where this door was opening?
Yes, ma'am.
Okay. And Your Honor, not to prolong, I'm just need to find the timestamp. I can finish my questioning now, and then let Ms. Westmoreland go, and then I can come back up for that particular portion, Your Honor.
All right.
I'm going to go find the part to refresh his memory so I can show it to him, but I don't want to prolong being up here, because that's the only thing I have to do.
So you can finish with your direct.
I'm going to finish my direct.
Good evening, Sergeant Ross.
Good evening.
Okay. Now, what time on October 23rd, 2018, what time, approximate time, did you see this Instagram video?
I don't recall.
Okay. Was it morning of the October 23rd?
No, I normally work in the afternoons, I believe, so it would have been sometime later.
Okay, what was your shift?
At the time, probably 4 to 12 or 2 to 10.
Okay. So 4 p.m. to 12 a.m.?
Yes.
Okay. All right, so you would have had to see the post sometime after 4 p.m., but you also said it may have been 2 p.m. You gave 2, okay. All right, do you know if you saw the post closer in time that you arrived to work that afternoon, or?
Yes, ma'am. It would have been closer to the time that I was at work because I staged. So I would have saw the video playing for staging. If I saw the video earlier in the shift, I wouldn't have waited, hours before I went and, met Mr. Nichols.
Okay. All right. You're guessing right now on what you would have done. You're not sure what time you saw the video?
I'm not sure what time I saw the video.
Just tell me if you know. If you do not know, tell me you don't know.
All right.
All right. All right. I believe you testified on direct. Or correct me if I'm wrong, you may have been at the precinct when you viewed the video, or you weren't at the precinct when you viewed the video?
I'm pretty sure I wasn't at the precinct.
You pretty sure you what?
I wasn't at the precinct.
Okay. Where were you?
I'm not sure.
But you were on duty?
Yes.
Okay. Do you know if you were sitting in your vehicle?
No.
You know you weren't? No, meaning I know I wasn't?
I don't know if I was sitting in my vehicle or standing outside the car.
Okay. Now, and I'm asking because I don't know.
Understood.
All right. If you're not in the precinct, then is the only other options in your vehicle or standing outside?
Yes.
Like, could you be in a restaurant?
I could be.
Okay. Whose social media were you viewing?
Mr. Nichols.
Okay.
I believe Mr. Nichols.
Well, how did you believe that? What led you to that conclusion?
He had several photos of himself on that, as well as he made a story post.
What led you to looking at Mr. Nichols, what you believe was Mr. Nichols' social media page?
I was just going through Instagram stories and came upon it.
Okay. Do you regularly monitor who you believe to be Mr. Nichols, his social media page?
Regularly monitor? No. If it pops up, just click through the Instagram stories.
Okay.
Or if they make a post.
Okay. All right. How long were you reviewing social media pages that day?
I'm not sure.
Okay. All right. You testifying today, you do not know what day and time. Well, let's take it a step at a time. Testifying today, you do not know what day that social media video was created.
Created? No.
Okay. And you do not know the time that that social media video was created.
No.
And you do not, testifying today, you do not know the day and time that social media post was posted?
Say it again?
Okay. Testifying here today. You do not know the exact time that social media post was posted.
I don't remember it right now, but it would have showed me the time frame of the post on Instagram during the time.
Okay. All right, and you agree that what you believe to be marijuana or the baggie, you believe that was a very short amount of time in the video? That bag appeared for a short amount of time?
Say it again?
Was the video long to you?
No, it wasn't long.
Okay, all right, so you agree that Instagram post video was pretty short?
Yes.
Okay, so would you further agree that the bag that you just discussed on direct inside that video, that appeared for a very short amount of time?
Yes.
What device did you watch this video on?
I'm not sure. I believe my city cell phone.
But you don't know?
I had the account on my city cell phone.
I'm sorry, say it again.
I had the Instagram account on my city cell.
Okay, all right, so you watched it on your city cell phone?
Yes, ma'am.
Okay. Were there other officers with you when you watched this video?
We ride in 2 to 4 man cars, so it would have been somebody else that saw it.
Who was with you?
On that day, I'm not sure. You have to check the staffing.
Okay. All right, so you know that you had to be with someone, at least one person, but you're not sure who that someone was.
No, yeah, I'm not sure. I flip-flop partners on this
right.
unit before.
Okay. And since you were watching the video remotely, it's safe to say that you could not view the contents of that bag up close, correct?
What you mean, like he had it in my face? No, he didn't have it in my face. I watched on the video. Yeah.
All right. And, and I'm asking.
I got you.
But you would agree that you couldn't smell the contents of the bag or anything of that nature. You're watching it remotely, right?
I would agree, but based on, knowledge, training, experience, and seeing all this stuff, I know what marijuana looks like.
Okay. All right, but you couldn't smell any contents or anything of that nature, correct?
Not through a phone, no ma'am.
Okay, all right, great. So at the end of the day, you didn't know what was in the bag?
I just went off of reasonable belief.
Okay. All right, the gray Chevrolet that you said Mr. Nichols was in the video.
Yes, sir.
All right, in the video, that gray car, in the video that you watched, the Instagram post that you watched, that gray car was parked in a parking space?
It was.
Okay, and it was backed in a parking space?
It appeared to be.
You couldn't see the license plate from the video of the gray Sonic?
No.
All right, so before arriving to the incident location that night, you didn't know who the car belonged to?
No.
All right, because you couldn't run the tag, correct?
That's correct.
You didn't know the tag number?
I did not.
All right. So you believe that you saw Quamarvis Nichols, right, on that Instagram post?
I believe I did.
Okay, and he was sitting in that gray Sonic?
Yes, ma'am.
All right, and where was he sitting in the gray Sonic?
It appeared to be the driver's seat.
Inside the driver's seat. Could you see the keys in the video?
No.
Did the car appear to be on?
I couldn't tell. It didn't show the lights or the exhaust of the vehicle.
Was there anyone else in the car with him?
Not that I saw.
Okay. How long after watching the video did you said you told your supervisor, how long after watching the video did you report to your supervisor concerning the contents of that video?
No, my normal practice is, I like to respond to something that I see like that immediately, so it would have been as soon as possible.
Okay, I appreciate you explaining your normal practice, but I'm really trying to figure out specifically what happened on October 23rd. So if you know, please tell us. Do you know how long it took you, or how much time between the time you saw the video that you reported to your supervisor?
Exactly from 5 years ago? No, I don't.
Okay. All right, and then you, after telling your supervisor, you stated you gathered officers?
I did.
And can you explain a little bit, what does that mean? Physically gathered officers, you called officers? I don't understand.
I don't get what physically means, but actually I would call them and have them come to the scene. I don't know how it was physically.
Sure, let me explain. Physically means, hey, officer, come over here with me.
That appeared to be calling, but I got you.
Okay. All right, so how did you call other officers?
Probably over the radio.
Okay. You said probably, you're not sure?
I'm not sure.
Okay. All right, and then you stated you found a location to stage. How did you find the location?
Well, I'm familiar with the general area, so I would know an area big enough to, fit all of us.
Okay, when you say all of us, how many people are we talking about?
Honestly, I'm not sure. It could have been 4, it could have been 20. I'm not sure.
Do you know whether it was over 10?
I do not.
Okay, under 10?
No, I don't know.
Okay. I noticed you have testified a few times that you needed to find a staging location big enough or large enough for all of us.
Mm-hmm.
So just help me understand, does a staging location need to be pretty large for 4 officers per se?
It does.
Okay. All right, so can you tell myself and the court how long you stayed at the staging location once you found it?
I cannot.
Okay. Okay, and can you tell us how long the conversation bringing everyone meaning your colleagues, the other officers, up to speed? You said, you testified a few minutes ago that at the staging location you had conversations and discussed target and things of that nature. You remember when you just testified to that?
I do.
Can you tell us how long that took?
No.
Okay, what about going over the plan with the team? You said after you had the talk that you guys went over the plan. How long did that take?
I'm not sure.
How far, do you remember the location of the staging location?
Yes.
Okay, where was that?
Right across the street.
Okay. All right, so when you arrived to the apartment complex, I'm sorry, let me back up. When you were at the staging location, had you called yet for a K-9?
I don't recall.
The K-9 was not at the staging location with you though, correct?
I said I don't recall. I don't know if you want me to.
No, I asked you if you called, but then I asked you, let me rephrase it. Did the K-9 ever come to the staging location?
I don't recall.
Did you review your body camera footage before testifying today?
Yes.
Okay, because you knew you were testifying today, right?
I did.
All right. All right, let me ask you this. Was your body camera on when you were at the staging location?
I don't believe so.
Was your body camera on when you were watching the Instagram post?
I don't believe so.
What about a dash cam? Was your vehicle that night, was it equipped with any kind of dash cam?
Yeah, I don't know, but dash cam only catches outside the car.
No, I understand. I'm still asking, did your vehicle that you were driving that night have dash cam?
I don't know.
Okay. Okay, and I know that you already testified you're not sure how many officers was at the staging location, but do you know how many officers that was with you when you actually arrived to the incident location?
No.
Okay. do you know what time you arrived to the incident location?
It would have been on my body camera.
Okay, but you don't know?
No.
It was at night?
Yes.
Does it sound accurate? Was it late at night? Do you remember if it was late? And when I say late, I mean after 10 p.m.
I'm not sure.
Okay. Would looking at the time on your body camera, would that assist you? Would that refresh your recollection?
It would.
Okay. Can I use State's Exhibit 1? Okay, Hilton, how do I share this from your computer too? Thank you, I appreciate it. Go to Zoom, and then go to share screen. I think this is about to. That's not one? Yeah. Can we just touch it? This one? Is it not? You want to see the time, right? Yeah.
I'm sorry.
That's all.
What about it? The actual dog? Yes.
It's not that.
I think CHAKON, I think.
Okay. All right, officer, have you had a chance to view what's on the screen?
I can see partial, but I see a picture of you in the corner.
All right. Is this the time right here?
I believe so.
Okay. And it's your understanding that's military time, right?
That doesn't even appear to be military time.
Okay. All right. Can you tell what time from this?
No.
Okay. Oh, that is stuff. All right. So at the end of the day, testifying today, you have no idea what time you arrived at the incident location.
I mean, if I had to say, looking at the report, it would give you, I guess, somewhat of an idea.
Okay, so the report would refresh your memory?
Possibly.
Okay, let's try that. Did you put that in evidence? No. Okay, you have it up there with you, right?
I do.
Okay, great. Can you look at it, refresh your memory, and then let us know when you're done?
I'm ready.
Okay. What time?
The report, the time listed appears to say 20:38 hours, which would be 8:38.
Okay. And so you're saying that's the time that's written on the report? Does it say I arrived? I mean, does your report reflect that you arrived at the incident location at such and such time? That's what I'm trying to figure out.
I mean, approximately, yes.
Okay. All right, once you...
8:48?
No,
What did you say?
I just repeated whatever time that I thought you said. What time did you say?
I said 8:38. It sounded like you said 8:48. I just want to make sure.
No, 8:38.
Cool.
Okay, all right, and so are you pulling that from the report time?
Yes.
That's where you're getting that from?
Yes.
All right, and and so you're also noticing that it has start time and end time is the same time, 20:38 to 20:38?
Yes.
All right, so that can't be accurate, right? Start and finish it?
The start and finish can't be accurate.
Okay, all right. All right, so once you arrive to the apartment complex, the first thing that you saw was a gray ship. You saw the gray Sonic.
I did.
Okay. But you did not pull up directly to the gray Sonic, correct?
Yes, correct.
Okay. And you're positive there was no one in the gray Sonic, right?
I'm pretty sure, yes.
Okay. Now you saw people sitting on top of the gray Sonic, right?
Yes.
And you saw people standing beside the gray Sonic,
Yes.
none of which was Mr. Nichols.
Yes.
Okay. How many people, I know you said multiple people, how many people are we talking about? How many people was sitting and or standing by the gray Sonic?
Don't recall. You gotta look at the video.
Do you believe that your report will reflect how many people was by the gray Sonic?
No.
Okay. All right, so when you pulled in, you didn't see any illegal activities happening inside the gray Sonic, correct?
Yes.
And you didn't see any illegal activity happening with the individuals standing and or sitting on the gray Sonic, correct?
Yes.
Now, you saw the white Toyota?
Yes.
All right. And you saw Mr. Nichols?
I did.
All right. And he was sitting in the door frame of the white Toyota?
He was.
Okay. And there were only two other individuals in the car?
Yes.
And you said it was two black females?
Yes.
One sitting in the driver's seat, one sitting in the passenger seat?
Yes.
Okay. And you exited your patrol car?
Yes.
Okay. Now, before you exited your patrol car, you were able to ascertain that no one was in the gray Sonic, correct?
Yes.
Okay, you saw that as soon as you pulled up.
Yes.
As a matter of fact, you saw the gray Sonic before you even saw the white car, correct?
Yes.
All right. And the questions that I asked you about, you didn't see any illegal activity in the gray Sonic, you were able to ascertain that from your patrol car also, right?
I began assessing that, yes.
Okay. All right, so before exiting your patrol car, nothing's going on with the gray Sonic, but you see Nichols and you see the white Sonic. I mean, you see the white car.
The Toyota Solaris.
Yeah, the Toyota, the white Toyota, okay. So you stepped out of your vehicle?
Yes.
And you smell marijuana in the air?
Yes.
Okay. Are you looking at your report?
No.
Okay. All right, and I know that you already testified that you do not know how many people exactly was sitting on the gray Sonic. Do you know how many people or about how many people were just gathered in the area?
I don't like to guess.
Okay. Is it fair to say that there were several individuals? You said multiple.
Yes.
Okay. What's your definition of several?
More than one.
So your definition of several is more than one, officer?
That is.
Okay. So two people, several to you?
Could be.
Okay. All right, so you saw Mr. Nichols standing slightly sitting in the driver door, correct?
Yes.
Okay. And Mr. Nichols, he didn't have a bag in his hand, right? No bag of marijuana?
Not that I can recall.
All right, no sandwich bag, period?
No,
All right, and you didn't see Mr. Nichols smoking marijuana?
no,
You didn't see Mr. Nichols with a weapon in his hand?
no,
Matter of fact, you didn't see Mr. Nichols with anything in his hand?
don't recall.
All right. When you, in your report, did you state that you saw Mr. Nichols with anything in his hand?
I don't recall.
Okay. If there was something in Mr. Nichols' hand that was illegal in nature, would you have included it in your report, officer?
Yes.
Okay. All right. So there was nothing, for a fact, that you're testifying to. There was nothing illegal in Mr. Nichols' hand. That's fair.
Yes.
All right. And when you saw Mr. Nichols, you did not observe him doing any type of criminal activity, correct?
Yes.
Okay. All right, and then as soon as you approached Mr. Nichols, is it fair to say you immediately detained him?
I don't think so.
Okay. All right, so what did you do before detaining Mr. Nichols then?
After stepping out of the vehicle, that's when I began to notice the smell of marijuana, which would have given me the probable cause to detain everybody in the vehicle.
Well, the judge is going to decide that.
I think.
But, so I'm asking you, I asked you if you immediately detained Mr. Nichols, and you stated you wouldn't say immediately. So I'm specifically asking you, from the time that you exited your patrol car to the time that you detained Mr. Nichols, what were you doing?
Investigating.
Tell us how.
I smelled the smell of marijuana coming from the area of the vehicle. I thought I said that.
Okay, and you did. Is that the only thing that you did?
To my knowledge, yeah.
Okay.
Without seeing the video.
All right, so would it be fair to say that you stepped out of the vehicle, you sniffed, and then you detained Mr. Nichols?
Yes.
Okay, is that fair to say that was immediate?
I don't know. You want me to guess?
No.
Oh.
I want you to tell me if you did not immediately detain Mr. Nichols, because I'm not trying to be funny. We're just trying to get the facts. If you didn't immediately detain him, I just want you to tell us what you did in the meantime.
Your question sounds weird. This is what I'm saying to you, right?
Okay.
So, upon my noticing the smell of marijuana, and I began my investigation, that's when everybody was detained. When you say immediate, I get the interpretation that you're saying I just jumped out of the car and grabbed him for no reason.
No.
That's not what I did. I detained him after noticing the smell of burning marijuana and the other individuals in the vehicle.
Okay. I know that you said when you started your investigation. What do you mean? I understand. I am very clear about you're stating that you smell marijuana. I'm just trying to understand when you say, and then I started my investigation, what do you mean?
I started my investigation upon entering the location and exiting my patrol vehicle. I got it started.
Okay. All right, so you detained Mr. Nichols, correct? You detained him.
I believe so.
Okay. Did you put handcuffs on him?
I believe so.
Okay. All right, and at this point, you've detained Mr. Nichols because you smell marijuana?
Yes.
Okay. You asked Mr. Nichols if he had any marijuana, correct?
Not sure.
All right, did you ask any of the individuals there if they had marijuana?
I believe so.
And they told you no?
Yes.
Okay. In fact, didn't Mr. Nichols tell you, hey, you can search me? You remember that?
I don't.
Okay. All right, did you search Mr. Nichols?
Don't recall.
Okay, you're not sure if you searched Mr. Nichols?
I don't recall.
Okay, well, looking at your police report, help refresh your memory if you searched Mr. Nichols.
Yes.
Okay, please do.
It advises that I search the vehicle.
I'm sorry, I didn't understand what you said.
It advises that I search the vehicle.
You mean your report is advising you that you searched the vehicle?
Yes.
Okay. All right, so you're not sure if you searched Mr. Nichols. All right, you asked the individuals in the white car if there was marijuana in the car, correct?
I believe so.
Okay. Do you remember that their answer to you was no, that there was no marijuana in the car?
Yes.
All right. So you you detained the other passengers in the vehicle, correct?
Somebody did.
Okay. So they were detained?
Yes.
Maybe not by you?
Yes.
Okay. Do you know how long after approaching the white vehicle that they were detained? I won't say immediately for you. So do you know how long?
No.
Okay. Do you know if it was less than a minute?
I don't know.
Okay. Before detaining Mr. Nichols, you didn't see any marijuana in the car, and I'm now talking about the white car, correct?
I saw shake.
Before you detained Mr. Nichols, you saw shake, you sure?
Oh, you said before.
Yes, I'm talking about before.
I mean, approaching him, I've been looking at him.
Okay. When you detained Mr. Nichols, you had not seen marijuana?
No.
Okay. All right, so nothing in plain view or anything of that nature at the time that you arrived in the incident scene. I'm talking about before your search right now.
Okay.
Okay, meaning I'm correct.
Okay, meaning you're correct, yeah.
All right, so you did not receive consent from Mr. Nichols to search the white Toyota, correct?
No.
All right, and you didn't receive consent from Mr. Nichols to search the gray Sonic either, right?
Had a search warrant, no.
Okay, and then so it's fair to say you had no consent from the owners of any of the vehicles that was searched, well, of those two vehicles?
No.
Okay. All right, what time did the search start?
I don't know.
Okay, what time did the search end?
I'm not sure.
And your police report can't help with that?
I don't believe so.
All right. Did you call the K-9 once you arrived to the incident location?
I don't remember. I just remember Officer Cornelius showing up and walking his K-9 in the general area.
Okay. So you do not know how long you had Mr. Nichols detained before calling the K-9, correct?
Yeah, without looking at the video, I don't know.
Okay. And you don't know how long you had Mr. Nichols detained before the K-9 finally arrived, correct?
Yeah, without looking at the video, I don't know.
All right. And Mr. Nichols was detained while the K-9 conducted their air sniff, correct?
Yes.
All right. You never let Mr. Nichols go?
No.
All right. Now, let me go back just a little bit. When you detained Mr. Nichols, you asked him his name. You know that?
I possibly did.
Okay, but you're not sure?
I'm not sure.
All right. Do you, you went to your patrol car and you entered Mr. Nichols' name into the system, correct?
At some point, yes.
You did. All right, and when you say at some point, that was before searching the vehicle, the white car, correct?
I'm not sure.
Mm-hmm. All right, well, let me see if you're sure about this. You entered Mr. Nichols' name, you checked Mr. Nichols' name before the K-9 dog arrived, right?
Yeah, I watched the video, I'm not sure.
Okay, let me see this. Once the K-9 dog arrived, the K-9 dog walked around the car, right?
It walked around the area.
All right, around the area?
Yes.
Okay, and it's your understanding that the dog alerted?
Yes.
All right, and after the dog alerted, you left the location to get a search warrant, correct?
Yes.
All right, so you wouldn't have left that location to get a search warrant prior to running Mr. Nichols' name, correct?
True.
Okay. All right, now, do you remember running the other individuals, the two passengers in the white car? Do you remember running their name?
I don't.
Okay. Now, okay. All right, when you called to dispatch to run Mr. Nichols' name, he had no warrants, correct?
Not to my knowledge.
Okay. All right, and up until this point, when you called dispatch to run Mr. Nichols' name, you had not observed Mr. Nichols breaking any laws at the incident location from the time you arrived until the time you called Mr. Nichols' name in, correct?
Breaking any law? No.
Okay. All right, so at some point you search the white car
Yes.
and you find what you believe to be marijuana crumbs.
Yes.
Did you bag the crumbs?
No.
Okay. Did you ever charge anyone with those crumbs?
No.
Okay. All right, and there was nothing else, no other evidence that you collected outside of the white car beside the car key to the gray car?
Not sure.
Nothing else of interest for you in the white car?
In the white? No.
Okay. All right, I mean, there's no guns in the white car, right?
Not that I remember.
Okay.
Yeah.
All right, and you didn't find any baggies similar to the bags that you thought you saw in that video, correct?
I did not.
Okay. You do not know who locked, you testified that someone locked the gray car. You're not sure who did that?
I'm not sure.
Okay. All right. And you have no idea from the time that you first encountered Mr. Nichols until the time that the K-9 supposedly made this alert, you're not sure how much time passed by?
No, I'm not
All right. Your Honor, no further questions?
Okay. Any redirect, ma'am? Yes. Go ahead.
Ms. Westmoreland asked a lot of questions, and you talked about going back to the video, so I guess we're going to just have to watch the video. Watch it. Okay. And while I'm getting access back into the Zoom, just have a few questions for you, Sergeant Ross. As it relates to, Ms. Westmoreland asked you about ownership, so I want to be very specific between the white vehicle and the gray vehicle, correct?
Yeah.
When you got to the Steele Avenue location, there was no one in the gray car.
No one was in the gray car to my knowledge.
And did you, when you spoke with the woman who was the owner of the white vehicle, did she acknowledge that she was the owner of the white car?
Yes.
Okay. At any point in time, did Mr. Nichols ever claim ownership to the gray vehicle that was searched?
Objection, asked and answered 4 times.
You're right, but Ms. Westmoreland went into it extensively.
Oh, wow.
At any point in time, did Mr. Nichols claim ownership to the gray vehicle?
No.
Did he claim ownership to the key fob that was found in the white car that opened up the gray car? Did he ever establish ownership of the key fob?
No.
And never to the vehicle?
No.
Once the car, after the search, what happened with the vehicle?
The vehicle was impounded. And a hold was placed on it by FIU due to its belief to be involved in, the sales of narcotics.
Access. Oh, Your Honor, I think I have screen sharing disabled again. Okay. When it relates to the Instagram story, to your knowledge, how long do Instagram stories last? Do you know?
Instagram stories last, I believe, about 24 hours.
Okay. Okay. When you saw Mr. Nichols on the Instagram story, would you have waited 48 hours to go see if that was him in the car?
No.
I sustain the question. You can rephrase, madam.
Did you wait 48 hours?
No.
Did you go the same day that you saw the Instagram video? Did you go the same day?
Yes.
Did you do anything else to corroborate or to determine that Mr. Nichols was either wearing the same clothing or in the same items of when you saw him in the video?
Mr. Nichols had a post, I believe it was like 12 hours prior, where he had on like the same clothing that he had on when I stopped him.
Okay, so 12 hours before the video, he had on the same clothes?
Yes.
Okay, and so you saw that posting?
Yes.
All right, and then you saw the video?
Yes.
And then you went to the location?
Yes.
You know, since that was disabled, maybe it's telling us something, but... No, it's just one copy. You can have a copy. One of the two. Permission to approach?
Yes, ma'am.
I'm sure you mark Stacey's exhibit number 2.
Yes, ma'am.
Do you recognize Stacey's exhibit number 2?
Yes, ma'am.
And what is that?
That was a post that would have been approximately 12 hours from when the photos was captured of Mr. Nichols standing in the area of what appears to be Steele Avenue, wearing the same clothing that he was wearing when he was ultimately arrested.
Okay. And is that the same outfit he was wearing inside of that video?
Yes.
I mean, I understand like Stacey's exhibit 2 for the purposes of this hearing at this time.
Any objections, Stacey? No, you don't. All right, Stacey's in the first motion.
Your Honor, the screen is still disabled. However, in the abundance of the time and the hour, Your Honor, this video is in evidence, Your Honor. I do want to specifically refresh Mr. Sergeant Ross's memory specifically as to the question I asked earlier, which was...
I'm going to try and get my assistant to enable the sharing again. So she says it's done now.
Okay. I'll try one more time. Okay, yes. I'm playing at least a good majority of the video.
Well, I'm gonna object for the rule completely, so I thought you said you were gonna play the whole.
Oh, I can play the whole thing. I sure can.
Fellas, what's going on? Who got the weed over here? Nobody? Yeah, it's coming from right here. I ain't crazy. You don't smoke no weed? How about you, man? Are you talking about but it's coming from right here. Do me a favor, I'm going to detain you, man. What you detain? Step up. Why you detain? Step up, because this whole area smells like weed, so we're going to detain all y'all. If I can search you, that's fine. We'll get to that. I'm not locking you up. Listen to me. I'm detaining you. I'm detaining you. Detaining you means I'm detaining you. I'm putting you in handcuffs. You're not going to jail. You're not under arrest right now. You got me? You understand? All right. Hold him tight. Ma'am, anything in the vehicle I need to know about? You mind stepping out of the vehicle? How about you, Miss Lady? This your car? It's her car? Okay. William Robert Baker. William Robert. I got him detained. It's a blunt right here on the ground and some shake all in this car, in one of the cars over here.
Now, earlier I was asking if you remember if the center console was shut, open or closed. Does this help refresh your memory as to whether or not that center console was open or closed?
It does.
Okay, and what is it?
It appeared to be closed.
Okay.
What's the purpose? Somebody goes away to the... Oh, boy. Jimmy, you on the ramp? What's the purpose? Somebody goes away to the...
And going back right here, is that the key to the gray Sonic?
Yes, ma'am.
And is that where you found it? And again, that's the key to the other vehicle in which you earlier saw Mr. Nichols on that video?
Yes, ma'am.
Okay, and that was in the center lock console?
Yes.
Hey, Corn, whoever that was, answer. What's your ETA out here? You talking about Canine? Yeah.
Now, we should be out there in about 10 minutes.
I copy.
Cross y'all, is that 2612 still?
Yeah. I got 3. It's another group of guys, about 4 more guys that's not in handcuffs standing out around here. As soon as we pulled in, they locked the door. on the car.
Your Honor, for the state's purposes, Ms. Melissa can play any additional relevant portions, but I'm just going to fast forward to when the K-9 gets here.
Can you look at the time you stopped?
Sure. I'm stopping it.
You got a license? Never had one?
I initially stopped it around, I think, right about 7.
Oh, yeah.
About 6:50. Or probably a little before 6:50. Probably around 6:32 is when I'm initially stopping it.
6:32, okay.
Yes, Your Honor.
It's like you got ID. Appreciate it. Just 2 cars came out. Nobody knows.
Like one. So homeboy, I think it was homeboy right here. He was swinging in the corner.
Yeah, somebody was.
Yeah, I heard.
But nah, it wasn't him. I got a little bit of weed right there, but that was it right now. It's shaking their car. Entertain, man. Head run. NOLD. Did y'all got the rundown? Okay.
Is that K-9 there?
No.
Coming in at about 14?
Yes.
So in about 14 minutes to get in there is when the K-9 arrives?
Yes.
Did y'all got the rundown? Okay.
Normal areas and definitely shut.
Okay.
That was really the only car that was here.
Yeah.
And at this point in time, had Mr. Nichols, at this point in time, claimed
Blunt
ownership?
and all the
Claim ownership? I don't believe so.
blunt.
And at this point in time, had Mr. Nichols ever claimed ownership of the vehicle?
I don't believe so. I'm sorry.
The actual blunts that they broke down right there is proof that we ain't crazy. I know I ain't crazy, man. I smell weed. Then everybody holler, oh, I don't smoke. Okay. Somebody do.
Yeah. Just go and it's like you're just searching me so I can come. But not even say, yeah, well, we work down.
Exactly.
And is it sorry, I'm gonna pause. Is it at this point in time where the search of the vehicle with the K-9, the open air sniff occurs?
It was about to start.
Okay. And as we already tested, or as you already testified to, that's when the dog hit on the vehicle, and and that's when you left and went and got the search warrant.
Yes.
Okay. And lastly, on your police report, how did you identify the gray Solera vehicle?
The white one?
The gray Solera, in your police report, when you listed the vehicle, how did you identify that vehicle?
So if you're talking about the Sonic, you said Solera. Okay,
Oh, sorry,
I got
the
you.
gray Sonic. How did you identify that vehicle?
Can I look at my report?
Yes.
All right.
You can look at Stacy's exhibit. Stacy's book. On page 2.
Page 2? Okay.
And the bottom where you do the vehicle listing.
Let's see. Vehicle. listed as a Chevy 2017 with a Georgia tag or tag bearing WRB 616, four-door sedan, gray in color.
Okay, and when it says identifier, other stolen date time, October 23rd, 2018, what does that mean?
Identifier, let's see. I believe that's for, I'm not sure.
Okay. But that's just one of the identifiers listed for the
Yes.
report. Okay. I have no further questions.
And recross. Yes, please.
Sergeant Ross.
Yes.
So I asked you a little earlier how long until the encounter with Mr. Nichols, how long did it take you to detain him? The answer to that question, you can gain that from watching that video, correct?
I didn't count, but it was relatively quickly.
Okay. Your Honor, the video is in evidence. I need to play the whole video, and I can play it anyway for the rule of completeness. Would you like me to do that now, or?
I think that don't we have that information already from the videos put in play?
I'm sorry, say it one more time.
Don't we have that information from the video as played?
I don't believe that we do.
Didn't he put him in handcuffs like right in the first? Well, he detained him, and then he put him in the back of the vehicle.
He did. Well, let me say this, Your Honor. I'm about to ask several time questions that he couldn't answer any of the time questions earlier. So I know it's almost 9 o'clock at night, but I have to defend my client to the best of my ability, and he couldn't answer several time questions. It's going to be important.
Well, then take him to the point of the video, ma'am. Let's get with it.
Okay.
If you know what time you want to forward the video to, just go ahead and do it.
Okay, I'll try. It's quite a few. All right, I need to see that.
You've seen the video, right?
Oh, absolutely.
Okay, then take it to him. Take it to that particular point in the video. Let's move on.
I'll share this.
All right. I'm gonna have a few though. I'll try to tell them to you quick. All right. Will you take him to 0042? That's
42 seconds?
yes. I'm using the time. It's going to show at the top. Yeah, just 42 and 48 seconds.
How about you, man? Are you talking about going home, man? But it's coming from right here. Do me a favor, I'm going to detain you, man. Step up, step up. Why you detain? Step up, because like, this whole area smells like weed, so we're going to detain all right.
Okay, so that's 42 seconds in, you detain Mr. Nichols. Correct?
When did I get out of the vehicle?
Yes, after you got out of the vehicle. Yes, or all right, I tell you what. Right now we're at...
I don't know if that's the right time increment.
No, I'm actually going to rephrase my question, Your Honor. So the 2 minutes and 37 seconds, you see at the bottom?
Yes.
Okay. Would it be accurate to say there from the time that your body camera started, from the arrival of the location, that's how long, that's what time, that's how many minutes into the incident that you...
Yes.
Okay. All right. I'll take it. Oh, shit. If I press 30 seconds right here, will it do it?
No.
Okay.
You need to go 30 seconds.
Yeah.
So we're going to do 3 minutes and 7 seconds?
That sounds about right.
Hold him tight. Ma'am, anything in the vehicle I need to know about? You mind stepping out of the vehicle? How about you, Miss Lady?
You can pause it. All right, so now 3 minutes into the stop, you removed the other occupants, correct?
Yes.
Okay. Okay. All right, I'll take it to 44. All right, I will take it to 44.
44?
Yes.
That's time, right?
Yes.
I'm going to start at 43:50.
Okay.
William Robert Baker. Right back in. William Robert.
So, man, I got him detained. It's a blunt right here on the ground, and some shake all in this car, in one of the cars over here.
Real quick here. Whiskey Robert Baker, 2017 Chevy Color Grand Car. 28 acres of a female born in 63 out of Psycho. Jimmy, you on the ramp? Hey, Dan, what's the radio hold out? What the purpose? Somebody goes away to delivery.
Oh, boy.
Okay, you can stop it.
Oh, boy.
All right, now at this point, we're 5 minutes into your arrival. Your search of the white vehicle is complete. You've already searched it. You saw that on the video, correct?
Yes.
All right. Can you, 45:39. You might as well play it. All right, stop real quick. All right, now you have left the white vehicle, correct?
Yes.
And you're now investigating the gray vehicle.
Yes.
Okay, I'll take it.
Keep going?
Yes.
Hey, Corn, whoever that was answer, what's your ETA out here?
You talking about Canaan?
Yeah.
Yeah, we should be out there in about 10 minutes.
I got it.
All right, you can stop. Okay, thank you. All right, now that's you calling into the K-9?
Yes.
Okay. And you asked the K-9 what's his ETA?
Yes.
Now, you're calling out to the K-9 for the K-9 to come and to sniff the gray car, correct?
To perform a search in the area, yes.
And to walk around the gray car, correct?
I'm just calling for an area, search of the area.
Okay, so did you ask the K-9 to walk around the white car?
I didn't ask him to do anything.
Okay. All right, so you gave the K-9 no instructions.
It would have been improper or I believe illegal if I told him, hey, bring your dog out here and walk around the gray car.
Okay, so you just asked him to bring his dog out.
Yes.
And then what did you observe the K-9 dog doing? Where did you observe the K-9 walking?
I don't know. You got to play the video.
Okay. All right, I will. All right. let's go to... All right, Ms. Hilton, will you please take me to 4704? Okay. That's you bagging the evidence, correct?
Yes.
And that's the only evidence that you bagged. You already testified earlier you didn't bag the shake, correct?
Yes.
Oh, boy. Oh, yeah, I got ID on y'all? Can I take you? Nah, you got to hang tight right here. You ain't got an ID? You got a name? Come walk over here with me.
Now, that is Mr. Nichols that you're walking over to your patrol car, right?
Yes.
Yes.
You got a license? Never had one?
Can you get to 40?
From what? From prison?
Yeah, you stop right there. All right, you're still with Mr. Nichols right here, correct?
I guess so. I can't see anybody.
Okay, I guess, can we just go back 30 seconds? This is less than a minute later.
Okay.
Can you hear Mr. Nichols in the background spelling his name to you?
What you said?
I can't. I hear something, but I don't know what I'm hearing. I can take you as your word if you said that's what you're doing.
Okay. That's what you said now? All right, cool. You just told me you
All right, please stop. All right, when you closed your laptop right there, you saw the results came back?
Yes.
And you said, okay, cool. And you closed it?
Okay.
Okay, so that means Mr. Nichols' information had come back to you?
Yes.
Okay. And that is 8 minutes and 35 seconds into this encounter, right?
Yes.
Okay. All right, will you take me to 50, just 50? All right, you can start right here. That's even better. All right, and these are the two female passengers that was in the white car, correct?
Yes.
All right, and you're running their identification?
Yes.
Okay. All right, so now you're 10 minutes into this encounter, and you ran both of the females that was in the car, and no issues came back in reference to their identification, no warrants, anything of that nature, correct? Okay. All right, so everyone in the white car, so the two female passengers and Nichols. There was no one else in that car, right? All right, so you successfully, at this point, you've already run all the IDs that you need to in reference to the white car, correct?
Yes.
Okay. Okay, all right, will you take me to 52 on the dot? 56? Yes. Oh, okay, just right there. Thank you, sir.
You got here, you ran it? How old are you? How? You got ID? Never had ID?
Okay, can we stop right there?
Okay, come on with me.
Okay, so now we're 11 minutes and 48 seconds into your arrival. Now you have walked away from the white car, correct?
Yes.
And you are going to deal with some other individuals that were standing outside of the apartment complex.
That were sitting, those were the individuals sitting on the back of the Sonic.
Okay. All right, so you're dealing with them. All right, thank you. Can we go to, or you can keep it, no, can we go to 55?
55?
Yeah, 52 to 55, thank you. And Nichols is still in custody right now, correct?
Still detained, yes, ma'am.
Or in detention?
What's your name, sir? Last name.
Oh, no,
Spell it.
55. I'm skipping.
52, 55, just 55.
Yes, just 55. Okay, I'm ready. Okay, now you.
Y'all got the rundown? Okay.
Okay. All right, so you have dealt with some other individuals that was at the Gray Sonic and you've run their ID, correct?
Somebody did.
Okay. All right, can we go to 55, 50? I guess that way.
To this winter? You don't like women?
No. I like Christmas. That's why.
Because you get gifts.
No, I just like Christmas time.
Oh, okay.
I'm a in the spirit kind of person.
So you decorate?
Mm-hmm. Okay. Full of stockings up and everything. I like Florida Christmas because we don't get ruined.
Gotcha.
Can you pause it? Okay, now here we're 16 minutes into the stop. You see that?
I do.
And it's fair to say that you're having a very casual conversation.
Yes.
Okay, and you're speaking with this female officer about her liking Christmas, right?
Yes.
And she explains to you she likes Christmas because she receives Christmas gifts.
Yes.
And you have some conversation in reference to her about that.
Yes.
Right? Because right now you're not busy, right? You're speaking with her.
Well, I'm standing by waiting on them to conduct their, their search.
Well, you're standing by waiting on the K-9, right?
Yeah.
Okay. All right, so here you're standing and you're just having casual conversation with the officer because you're waiting on the K-9 to arrive.
They here. You're looking at the vehicle. You was just looking at the back of the vehicle.
Right, okay. Can we go back just a little bit? Okay, can we play?
I like Christmas. How far back That's why.
Because you get gifts.
We can start.
No, I just like Christmas time.
Oh, okay.
I'm a in the spirit kind of person.
So you decorate?
Mm-hmm. Okay. Full of stockings up and everything. I like Florida Christmas.
You can tell us when you see the dog.
Gotcha.
The dog vehicle is behind us, so you gotta go back some more.
Okay.
Y'all in zone 3 or what's on y'all in? Y'all in 3? Y'all in 4, okay.
You can keep it. Yeah, I'm waiting on the officer.
So that's the truck. As you can see, I think somebody doing a search of the general area, and the dog is walking right there.
Now, this is you going back in the white car to retrieve the key for the gray car, correct?
Yes.
Yep.
right, you can start with it. And that is the K9 walking around the gray car, correct?
Yes.
Okay. And will you take me, and I think, will you take me to... Let me ask you, after this, you remember speaking with, you remember the state asked you about speaking with the passenger owner of this vehicle, right?
I believe so.
You remember speaking with her?
Yes,
All right, and you remember you gave her Miranda rights?
I do.
Okay. And then do you recall that after giving her Miranda rights, you asked her about whose key, about that key for the gray car?
Yes.
Okay. And you and her had some discussion, right? You remember that?
I remember us talking.
Okay. And that discussion was you trying to figure out who locked that gray car? You remember that? And you were trying to figure out who put the key to that gray car in her vehicle?
Yes.
You remember that? And that who had access to the center console for that key? Do you remember that? That you had those conversations with her?
I probably asked that last part.
All right, and you told her that she wasn't being you told her that you were going to get to the bottom of it, of whose gray car and that key before you left that day. Do you remember that?
No.
All right, can you take me to we'll start at 102. You can stop right there. You can go back just a little bit. I'm sorry. All right, let's press play. Can I do a 30-second pause?
Man, walk with me. You want to speak with me, and if you don't want to speak with me, you understand? No, you're not, but you're detained. So in order for me to properly speak with you, I have to read you these rights. Now, you can say you don't want to talk. You can say you do want to talk. It's up to you. It's just...
1 minute, 30 seconds.
Yeah. Okay, let's start right there.
Yeah, I got hang tight. All right. Right, number 1, that I may remain silent and do not have to make any statement at all. Do you understand?
This should be the last.
Right, number 2. An attorney is present.
Yeah, just a little bit.
All right, with that being said, would you like to talk to me?
Yes.
Okay. All right. There are a pair of car keys in your center console right now. They belong to a Chevy. Are those your car keys?
No.
Okay. Whose car keys are those?
I'm not sure who car it is. Like,
No,
driving.
I got you. But who put the car keys in the center console?
I don't know. That's what I'm saying. I'm in my own world in my phone.
So you don't know who's been in and out of your car?
A couple of the boys I had, like, they got here.
I got you. Which one?
Okay, so directly after giving this young lady her Miranda, your first set of questions, you would agree, was about the gray car.
Yes.
Okay. And the last time I'll take is 106 and 50 seconds.
106.50?
Yep. You can start right there.
And that's fine, because we're going to get to the bottom before we let anybody go out here. But somebody in their car, and you know who locked the car. I mean...
Stop. All right, now, maybe that refreshes your memory. You told her, that's fine, but we're not going to let anyone go till we get to the bottom of this.
Yes.
And then you brought up the car, the keys to the gray car.
Yes.
Your Honor, no further redirect.
Anything further, madam?
No.
All right, may we permanently or temporarily excuse,
You can permanently excuse.
for purpose of motion?
Yes, yes.
Sergeant Ross, appreciate your patience with us this evening. I'm going to excuse you at this point in time for the purpose of motion. Don't discuss your testimony except the attorneys in this case, okay?
Yes, Your Honor, thank you.
All right. Is that your report or is that pieces? Okay, all right, okay, all right. Okay. All right, madam, any other witnesses?
Before I even go there, Your Honor, we don't believe that Mr. Nichols, again, has standing to even argue about this search. Although the burden of proving that a search and seizure were lawful shall be on the state, a defendant bears the burden of proof where his or her standing to raise a challenge to the legality of a search or seizure is contested by the state. A defendant who presents no admissible testimony on the question whether he was aggrieved by the unlawful search and seizure of property, the possession which is not otherwise unlawful, cannot prove he has standing to raise a challenge to the legality of the search. And that is Stinsky, S-T-I-N-S-K-I, v. State, which is 281 Georgia 783, which is a 2007 case. Your Honor, in this case, Mr. Nichols does not claim ownership of the gray vehicle, which was the subject of the search. He does not claim ownership to the key fob. He doesn't claim ownership to the vehicle. Therefore, he lacks any standing in order to even challenge this search and to even move forward. So before we move forward with anything else, Your Honor, it is the state's belief that he has to show that he has standing. The burden of proof is on him. And, Your Honor, as it appears from the evidence, and you've watched the video, Your Honor, that no one claimed ownership. No one outside the vehicle claimed ownership to that gray vehicle. So therefore, he does not have standing.
All right. Ms. Westmoreland, what about the issue of standing?
Yes,
Please stop.
Thanks, Your Honor. So, the state, I think that we crossed the bridge already that you do not have to own a vehicle in order to have standing. So I believe we've passed that prong. Am I correct, Your Honor?
It's a little different.
Okay. All right, so...
different in this factual credit.
Oh, no, I understand. It's interesting because the case that I presented to the court a little bit earlier in the last motion, the way I found that case was actually for this one. And the reason why was because this case, number one, states that you do not have to own the vehicle in order to have Fourth Amendment protection. But it also, what it goes further...
A little different because the issue in this case is the car and the fob and where it was found. So you have to either say that's my car or that's my fob.
Well, actually, so, Your Honor... And then nobody claims possession of this particular car or the fob. All right, Your Honor, I have an argument. I just need the opportunity to make it. So the reason, like I mentioned, I found this case, but I found this case for this case, and I'll tell you exactly why.
Is this the Flores? Is this the?
Yes.
Do you have any Georgia authority in terms of this particular proposition?
So I believe that the cases that I presented earlier also applies, and I'd just like the opportunity to explain why.
Okay, which case are you talking about in particular?
Sure. Okay. So, and I do have a few more. All right, Your Honor, a few cases. I do want to give you the Flores case again, and I just want to quickly point out that what happened in this case was that the officer witnessed.
I read Flores.
And I understand, and Your Honor, the similarity here, and it's a material similarity, is that the officer testified.
Controlling in this jurisdiction.
No.
Okay, then, again, I'm going to ask you for the second time.
Okay.
Do you have any Georgia authority for this particular proposition, either from our Supreme Court or from our Court of Appeals, or from the 11th Circuit?
All right.
It might be persuasive authority to me. But let's talk about the Court of Appeals and the Supreme Court of Georgia.
I understand. All right, Your Honor, I also want to give you U.S. v. Gomez. That's 276 Fed 3rd 694. It's a 2001 case. And in this case, the court held that although apparently it was not Gomez who locked the truck, he had a subjective expectation of privacy in the contents because he knew of the 170 pounds of marijuana stored there and was concerned it would not be discovered. Your Honor, this case is important because similarly, the state argues that Mr. Nichols was seen in that vehicle by the officers, so he was seen in the vehicle possessing it. Your Honor, the facts give an inference that he had permission to use that vehicle. That vehicle was not reported stolen. There was no one there on the scene that said Mr. Nichols was not supposed to be in that vehicle or anything of that nature. Number 3, that vehicle was locked, and in accordance with Gomez, it explains that it's apparent that it doesn't matter even who locked it, that with the allegation that the contents inside the vehicle were of illegal substance, that Mr. Gomez would have an interest in locking that vehicle. Also, the vehicle is still in close proximity to Mr. Nichols. He is right across from the vehicle. The key that opens and closes the vehicle is in very close proximity to the vehicle. And the state is quick to point out that he did not claim the vehicle, nor did he deny it. The officers did not ask Mr. Nichols, and that's why I asked the officer that. He did not ask Mr. Nichols, and Mr. Nichols would have been able to maintain his right to remain silent anyway, but he didn't ask Mr. Nichols, hey, is this your car? And then Mr. Nichols said, no, it's not my car. Hey, did you have permission to drive this car? I just saw you in it earlier. No, I didn't. Hey, I saw you in the car earlier, so you had some level of possession and control. You know, was that not you? None of those type of exchanges happen. So, Your Honor, I would like you to take into consideration several things. That our circuit has held that you do not have to own the car, and that what our courts look to is possession and or control. That I am able to get out proof of standing through the state's witness, which I have done. That the officer in this case observed Mr. Nichols inside of that gray car. That when he
the gray car or the white car?
The gray car and the white car. So the gray car and the white car, whichever. I thought we were talking about the gray car at this point. Miss Hilton seemed to be arguing that he didn't have expectation of privacy in the gray car because it wasn't his car. And he is observed, her witness that she put on, and I can get standing through him because it's still testimony, said that he saw Mr. Nichols in possession of the vehicle, meaning he saw him in the vehicle. He also, not only did he just see him in the vehicle, the gray car, the car that the search was conducted, that contraband was seized. Now, so that is the car that the officer testified. He said he saw him in both cars. But that is the car that the officer testified that he saw Mr. Nichols in on that Instagram post. And not only did he say that he saw Mr. Nichols in that car, he saw him in the driver's seat of that car. So you have possession.
You're talking about an Instagram vehicle, right?
Yes.
Okay, all right, done. All right, I'm good. Okay. Call your next witness.
Well, Your Honor, then the next portion is he abandoned the vehicle. So, Your Honor, when we talk about abandonment is...
Okay, now let's argue that, okay? But he's got standing.
Okay, so we're going to give him standing if you choose. Now we're going to talk about abandoning the vehicle.
Yeah.
So, Your Honor...
Because the Instagram video does show him in the gray car. And
So then the
Ms.
next-
Westmoreland is correct.
So then the next step is that he abandoned it. Because, Your
Let's talk a
Honor,
little bit about abandonment.
yes, abandonment, and this is in Bassett v. State.
What's the name?
Excuse me.
What's the citation?
Actually, I'm going to actually do Driggers v. State, which is DRIGGERS v. State, which is 295 Georgia Ave 711. And I'm going to also cite to Kyle Holt, KEILHOLTZ v. State, 261 Georgia Ave, which is a 2003 case. Sure, the second one is 261 Georgia Ave 1. Yes.
What's the first one, Driggers?
Driggers v. State,
Or is it 20, what did you say it was?
295 Georgia Ave 711.
295.
Yes, Your Honor. So, what Drigger says is a defendant who abandoned seized property lacks standing to challenge the validity of the search and seizure. Abandonment is primarily a question of intent, and intent may be inferred from the words spoken, the acts done, and other objective facts. The issue is whether the person prejudiced by the search had voluntarily discarded, left behind, or otherwise relinquished his interest in the property in question so that he can no longer retain a reasonable expectation of privacy with regard to it at the time of the search. The issue of abandonment is a question of fact to be resolved by the fact finder, and a finding of abandonment will not be reversed on appeal if there is any evidence to support it. As part of our review, we may consider evidence submitted at the hearing on the suppression motion at trial. That is Driggers. And Kyle Holt, which is actually an earlier case, which is a 2003 case, also says again that abandonment is primarily a question of intent, and intent may be inferred from the words spoken, the acts done, and other objective facts. All relevant circumstances existing at the time of the alleged abandonment should be considered. Police pursuit or the existence of police investigation does not itself render abandonment involuntarily. The issue is not abandonment in the strict property rights sense, but whether the person prejudiced by the search had voluntarily discarded, left behind, or otherwise relinquished his interest in the property in question so that he can no longer retain a reasonable expectation of privacy with regard to at the time of the search. What do we have here, Your Honor? Mr. Nichols, who you heard from and you saw the video, Sergeant Ross saw him bagging up the marijuana, and upon seeing that, wanted to go and further investigate because he was familiar with the area. He staged the police to come over. First things first, he heard someone yell out 12. When he heard someone yell out 12, which to him and his knowledge, training, experience, is when everyone disperses because cops are on the way. What happens? Mr. Nichols is not in the vehicle. Someone has locked the vehicle and then hid the key in the center console of the white Solera so no one could know whose car it is. He outright abandoned the vehicle by his actions. And why is that, Your Honor? Sergeant Ross testified he was a convicted felon. So he doesn't want anybody to know he got 3 guns in the car, plus the drugs in the car, because he on probation for the drugs that he just had in the 2017 case. So, Your Honor, he abandoned the vehicle knowing what was in the car. For that reason, Your Honor, he doesn't have standing. So when the officers arrive on the scene, he's sitting in the crack of the door handle, and when he's sitting there, he doesn't say, "That's my car." He doesn't say, "My keys in the center console." He doesn't say, "I gave my homegirl the car key so she can put it away for me." He says nothing. Because again, he does not want to be tied to the vehicle that has 3 guns, 2 of which are stolen. So, Your Honor, what Mr. Nichols did, knowing what was inside of the vehicle, is abandon it. Then upon abandonment, they get the K-9 to come out, the K-9 search, they smell the marijuana, they go actually get a search warrant, and oh, what do we find? Guns, marijuana, and subsequently he is arrested. He has abandoned that vehicle and no longer has standing to challenge the search of that vehicle, given what he did. he voluntarily discarded, left behind, or otherwise relinquished the property. And you can look at the totality of the circumstances here, which is he did not want to be associated with that vehicle given his predicament being a convicted felon and given what happened in the car. So, Your Honor, for that purposes, he's abandoned the vehicle and does not have standing.
All right, go ahead, Ms. Westmoreland.
Your Honor, Diggers v. State. Your Honor, this case is so different, it's ridiculous.
Well, it's a child molestation case to begin with, so...
You said what?
Child molestation case to begin with.
Yeah, okay, so...
But anyway.
But, Your Honor, please, this case says Diggers had been absent from the building for approximately 3 months. Living in Florida, made no efforts to retrieve his personal belongings from the building despite being advised to do so in a letter. Moreover, in January, at the time of the search, the building no longer had running water or functioning heat and was about to be demolished. He wasn't paying rent or utilities and had not entered into a lease agreement with the Lacey's. Finally, Your Honor, these facts, they are so different. Your Honor, this is an abandonment. This case, it has absolutely no bearing on the case and the facts that's been presented to you. So, Your Honor, I would ask that you completely disregard that. In reference to abandonment, Ms. Hilton, when she arrives to work tomorrow, and in whatever car she drives, whether it's hers or someone else's, and hits the door lock, she's not abandoning it because she walked across the street or up into this building to go to work. That's not the definition of abandonment. Now, this case, that may be the definition of abandonment, that you move out of state and you do not pay the bills and you do not respond to letters and everything of that nature, and you make no effort for your personal belongings. Your Honor, again, Mr. Nichols didn't make any statements in reference to ownership or lack of it, and he can do that. Ms. Hilton is arguing to you as if Mr. Nichols made a denial and vehemently denied that he owned the car or something of that nature. He didn't. He just didn't answer. And locking the door, that's actually a fact in our favor. And it doesn't even matter if it's Nichols who locked it. And I will refer the court back to U.S. v. Gomez at 276 Fed 3rd 694 2001 that says, although apparently it was not Gomez who locked the trunk. In this case, the court held that it wasn't even him who locked the trunk. He had a subjective expectation of privacy in its contents. He obviously knew of the 170 pounds of marijuana stored there and was concerned that it not be discovered. So that argument that Ms. Hilton just made actually helps Mr. Nichols. If he obviously knew that there were 3 guns, 2 of which was stolen, and controlled substance in that car, then of course he had a interest in locking it and a subjective expectation of privacy similar with Gomez. Also, Your Honor, remember that the key was in very still close proximity.
Okay, so let's assume that I don't buy the abandonment argument.
I'm sorry?
Let's assume I don't buy the abandonment argument. Well, they still went and dog alerted on the car. They went ahead and got a search. They went ahead and got a search warrant. So where are we at that point?
Time to argue?
Yeah. Ms. Hilton, I'm going to move on from the abandonment, okay? I'm taking a look at a couple other cases that I don't think that would have. So I'm just gonna, for the sake of, for the record,
I'm going to find there's not an abandonment. So we'll go to the other. We'll move on to the next issue.
Okay.
Which would be the search, or the dog issue, and then the alert from that, and then the getting of a warrant.
And Your Honor, we have the K-9 officer here. I'm not sure if defense counsel is going to challenge that the dog was certified, so we can definitely bring him in as a witness. If they're not challenging that the dog was certified, then I can release him, but he is here to deal with the certification of the dog issue for the open air search.
All right. Okay, so I take it we'll have to probably take some testimony on the dog, certification of the dog.
If they're challenging, if they're not, no, if they are.
Challenging that, madam? Ms. Westmoreland?
Your Honor, I'll stipulate to only the fact that the dog is certified.
Was there any other reason to call? Who's our K-9 officer?
Officer Cornelius. I mean, the video speaks for itself. I look did. I think the video shows what the K-9 did, so if they're not challenging the certification, then I believe that.
She says she'll stipulate that the dog was certified.
So I don't believe I'll have any officer Cornelius. So we can, the state reserve argument.
Do you have any other evidence, Ms. Westmoreland, you'd like to present now?
No, Your Honor.
All right, I'll hear argument then on the issue of the dog and the probable cause for that. Okay, go ahead, Mr. Swan.
All right, Your Honor, thank you. Your Honor, first argument is that the officers should not have detained Mr. Nichols in the first place. When the Sergeant Ross testified that he had no idea when that social media post was created. He didn't know when it was posted. And that's important, but he didn't even know when it was created, period. Yesterday, last week, last month, last year, and when Ms. Hilton tried to resuscitate that, the only fact that the officer could testify to was that Mr. Nichols had on the same clothes. And I believe most of us wear our outfit more than once, but even more importantly, he says that the picture that he saw Nichols with those clothes on was at least 12 hours before. And he said, he meaning Sergeant Ross, he didn't even know what time that he saw the Instagram post, but he knew it was sometime about after 2. Okay, so if he saw the post at 2:30, Nichols, in the daytime, Nichols had on those clothes almost the night before. The officer testified that it would be after 2, but he knew that it would be before 8 p.m. Remember that he had to see the post? But we also know from the officer's testimony that we had to be talking about a significant amount of time before that, because the officer testified to everything that he had to do. So he said he saw the post. He said after he saw the post, he had to speak to his supervisor. After he spoke to his supervisor, he had to gather a team. After he gathered a team, he had to find a location site, a staging site that was large enough to hold several officers. Then once he found a staging site that was large enough to hold several officers, then he had to, convene everybody, get everybody together. Then he had to go drive over to the staging location. He had no idea where he was coming from before to even where he watched the video and how far he had to travel to get to the staging location. And once he even arrived to the staging location, and all his other colleagues did too, and he has no idea, it might have been 20 or 30 of them or 10, but they had to talk and they had to prep and they had to decide what they were going to do. So we are talking about a significant amount of time between seeing this post and actually arriving to the incident location. That's number one. That even if it could be pinpointed, that we're talking about a significant amount of time. And not only that the video that the officer watched, he has no idea when it was even created. I say that all to say, Your Honor, an officer's reasonable suspicion, probable cause, which I don't even think watching the video establishes that, but it does not get to come with no expiration period. That officer had no reason to have a reasonable belief that a video that he was watching that he could not discern when that video was created, that he could show up there and the same situation was going on. And it doesn't matter that it coincidentally was. The point is that the officer did not have a reasonable belief to believe that without knowing the day and time that video was created, and especially with how long that it took him to get to the incident location after watching the video, however many several hours that was. So he had no reasonable belief that criminal activity was still afoot. If what he saw on the video was even criminal activity, I was having trouble seeing it myself, and Ms. Hilton put it on slow-mo and kind of started doing a kind of screen-by-screen, situation to try to slow it down, and the officer did not testify that he did anything of that nature. He couldn't testify to how many times he saw the video. He never testified that he watched the video in any kind of slow motion. He couldn't smell the contents. He couldn't see a close-up of the contents. He didn't even know whether he watched it on his phone or something else. But we argue, Your Honor, that there's no way that he could have...
You saw a bag in the video, and you saw, not the red bag, just a baggie in the video, and then when he actually was on scene, there's a baggie.
Well, no, actually. Actually, when he arrived, and I was about to get there next, so thank you, because I'll speed to that. When the officer arrives, after some unknown time video was created, he arrives and Nichols is not in that gray car. He's not in that car. The gray car that the officer thought he saw Nichols in with that bag of what he thought was marijuana that was vague and brief and only showed up for about half a second. When he gets to the incident location a long time later.
Well, what do we consider a long time? We don't really know how long it is. I mean, it was dark when the video was Instagram video was seen, right? And then it was dark when, they arrived on scene, and he's wearing the same clothes.
Well, I mean, Your Honor, I won't belabor it, but first off, the officer also testified in the same breath that he had no idea when the video was created.
I agree with you if it's a long period of time, but there seems to be some indicia that it happened within hours, because you see Mr. Nichols in the same clothing that he's in the Instagram video when he's actually stopped in the vehicle.
Your Honor, and the sergeant also testified that before the Instagram post, that video, that he saw Nichols with another post with those same clothes on 12 hours before that.
Okay, but I'm not worried about that.
Okay, but what I'm saying is...
I'm looking at the one he observed, and I'm trying to figure out, is there some reasonable time period between that Instagram post and then them arriving on scene on Still Avenue?
Right, no, I understand, Your Honor. Okay. So,
and that's why I'm saying I'm trying to have a conversation with you about that issue as to time. I think that given the fact that it was the Instagram post is you can see it's in the evening, you can see that then they arrive and he's wearing the same clothes.
Okay, Your Honor, I understand.
Okay, I just want to make sure.
No, and to make sure that I'm on the same page with you, what I'm explaining is that first off, the time on the police report is wrong. And the officer testified that the time on the police report was definitely inaccurate because the start and the end time is the same. So that he testified that the time on the report is wrong. That's number one. Number two, it appeared to me that the time on the body cam seemed to show that it was actually the 44 and the 54 at the top of the screen was actually AM. Actually throughout discovery, the date changes from the 23rd to the 24th, so he's mistaken. But the officer testified that the time was wrong. So that's that. And in reference to the same clothes, I understand that Your Honor's taken into consideration. I'm just asking you to also take into consideration that before the Instagram video was posted, those same clothes were being worn 12 hours earlier. So we're talking about Mr. Nichols having on the same clothes for a substantial amount of time.
But if I believe that, but that's for a different purpose.
Okay.
I'm not really concerned about that. It adds to his overall telling us what happened, but I'm more focused on that Instagram post that he relies on to go and conduct an investigation.
Yeah, absolutely, Your Honor. And I argue to you that too much time has passed, even given the officers, if you take him for his statement without even knowing exactly how much time, it's still too much time. He sees the Instagram post, he narrows it down from 2 p.m. to 8 p.m. Let's just say it's dark, and we're talking 6, 7, something of that nature. The body count, he's already told you that 8 p.m. is the wrong time on the police report, and I believe that the body cam shows that we're talking about 12 a.m. So we're talking about a good 6 hours with the body camera being in the 12 a.m. time and the time that it's getting dark. But just take into consideration the officer and everything that he told this court that he had to do. It's not like that he testified, Your Honor, I saw the Instagram post, I left from seeing that Instagram post from my police station, and I drove 3 minutes away, and bam. He didn't say that, Your Honor. He said he had a lot to do. And I won't repeat it if the court already, knows it. But he said he had a lot to do. He had to speak to the supervisor. He had to go pick a staging location, go to a staging location, prep the team, talk about it. A substantial amount of time, or let me argue it like this, Your Honor, too much time. This wasn't quick. Once Sergeant Ross, so that's the end, that's the conclusion of my argument. He shouldn't have even went to this scene and immediately detained Mr. Nichols anyway, based off of that Instagram post, which was way too insinuated. But once that the officer arrives at the incident location, Nichols is not in that gray car. He is not involved in any type of criminal activity. I asked the officer that, and different questions, multiple questions in reference to that. Did he have anything in his hand? Did you see him smoking marijuana? Did he have a weapon? Did you see the bags that you believe you saw in the Instagram video? Did you even see the red bag that you thought you saw in the Instagram video? And he answered in the negative for all of that. So not in the car, not involved in any criminal activity, nothing in plain sight before the search. The officer testified to that.
What about the dog now? Tell me about the dog.
My issue with the dog, well, it's a few things. I'll deal with the quick part of the dog. And Your Honor, it's the state's burden to
I'm sure they're going to give me some argument on it, but I understand it's their burden, but here's the thing. Okay, he's in the car to begin with, okay, the white car, and so, Officer Ross sees what's going on in the white car. He says he sees the grist, his video shows the blunt. So, he goes ahead and he smells marijuana. So he's got enough, at least at that point in time, to run the dog or have the dog come to the scene. The dog comes to the scene, starts looking around, and then, the alerts.
So actually, Your Honor, I did that whole time situation with the body camera video, even at 9 o'clock at night, because trust me, I'm tired too, but I did it for a reason. And the reason was that we're going to go back to Rodriguez and you can't prolong. At that point, the officer has shown up. He says he smells marijuana in the air. He immediately moves Nichols and the two females out of that white car.
How long did it take for the dog to come on scene?
The dog didn't get there until about 15 minutes. Do you remember even when the Officer Ross called and he said, hey, what's your ETA? This is the second call. He's calling, hey, where are you, K-9? And the K-9 officer says, I'm still 10 minutes out.
He calls the K-9 about 5:40, if I believe the timeline.
Yes.
And the dog arrives on scene about 16:29, 16 minutes, somewhere around there. And then around 17:26, the dog alerts on the gray car.
Yes. Well, I'm saying yes. I have to look to make sure. But I believe you.
I'm looking based upon the time hacks that when you slowed down the video.
Right. So you're saying 17 minutes the dog has arrived, right?
No, I'm saying.
What did you say?
The dog's on scene about 16:20, 16:29, something like that. Around the 16-minute frame time for the dog is on scene.
Okay.
And then I see the dog at 17:26 or thereabouts alerting on the gray car.
Okay. All right, so...
Got about from 5 to 16, about 9 minutes somewhere that the K-9, it takes the K-9 to arrive?
Yes, Your Honor, that sounds about accurate. The problem that the state's going to have is that everything dealing with the white car and the marijuana was over. So
I'm sorry?
It was over. So for over 8, almost 9 minutes. So what happens is, and this is why I made sure that I narrowed down the time, is that, remember, the officer, he arrives, he sees Nickel. I argue he doesn't have a right to, that he shouldn't have detained Nickel in the first place, but anyway, he does. He smells marijuana in the air, and he detains Nichols because of that. But then remember, he detains him immediately. The females are taken out of the car. Officer Ross walks Mr. Nichols to his patrol car. He runs his name, so that's clear. No warrants, that's clear. He searched the white car. He's already located the shake. He's also located the cigarette marijuana on the passenger side of the ground. He's picked up that cigarette marijuana on the passenger side. He's put it in an evidence bag.
Before that, he opened up the center console, and what did he find?
Before that, he opens up the center console and he sees the key.
Okay, all right.
That's a whole separate investigation. That has to do with the Instagram post. That has nothing to do with smelling marijuana there on the scene. What I'm saying is my argument is twofold, is that Instagram is one situation. Coming on the scene and smelling marijuana is another one. The
dog comes on and you agree alerts not on the white car, alerts on the gray car.
And that's what's so important. What's so important is that Mr. Nichols
was in the car earlier, if you believe the Instagram post, and he was rolling what purported to be was marijuana, right? So the dog alerts on that.
So, Your Honor, that's what I'm saying. You have two investigations going on. The first one is the Instagram post. Our argument there is that because the amount of time, so then that's over with. So what I am saying is the officer had no right to detain Mr. Nichols and work the gray car.
If I find that too much time is...
If you find it's too much time, the officer was not in his official duties. He should not have been investigating the gray car and Mr. Nichols because too much time had passed by for him to have seen that video and then come to the location. That's one argument with the gray car only. My next argument is with the white car. And my argument there is at best, the state at best, the investigation was done for almost 9 minutes before the K-9 arrived because every single individual in that white car, identification had already been run and it had come back. The evidence, the vehicle, the search was complete. The evidence was bagged. The officer is just waiting around on the K-9 and Rodriguez tells him, you can't do that. He is waiting on the K-9 for the investigation of the gray Chevrolet. He can't do that. That's why he's having casual conversation with the female officer about her liking Christmas gifts. He's just waiting. So, Your Honor, prolonged detention not allowed for separate investigations. See Rodriguez v. State, 295, Georgia, 362, 2014, which says a detention that is prolonged beyond the conclusion of that investigation, of the investigation that warranted the detention in the first place. So, white car, if that warranted the detention in the first place, that's the investigation that you have to stick with. And Rodriguez said in those cases, the courts have generally concluded that such a prolonged, even a short one, is unreasonable. Your Honor, in Florida v. Royer, 460 U.S. 491, or 103 Supreme Court 1319 is probably a better way to cite it. The court held investigative methods should be least intrusive in a short period of time. It's the state's burden. It has to be limited in scope. And the court goes on to, because the court's ready for this exact type of scenario, the court goes on and states, prolonged detention, unreasonable prolonged detention of two of sorts. A detention is prolonged beyond the conclusion of the investigation that warranted the detention in the first place. Even a short one is unreasonable.
But wouldn't the officer have reasonable suspicion based on the smell of marijuana
So, and Your Honor, if he did, let's just say, if the officer had reasonable suspicion for the smell of marijuana, his investigation was over. He found the marijuana, he found the shake, he found the marijuana cigarette, he bagged it up, he had everybody's IDs, he knew they didn't have...
But he brought the dog in to make sure that, because he smelled it, so that gave him reasonable suspicion to continue his investigation.
Well, actually, Your Honor, he the officer said that he actually smelled the strong odor of marijuana coming out of the white car. That's why I kind of asked him. I was a little bit surprised. I said, hey, you called the dog to go around which car?
No, but he said he couldn't do that because the dog comes on scene and the dog goes where the dog goes. And you see the dog first come near the building and then come around the cars and then he alerts on the gray car at that point in time.
And I understand that, Your Honor. His problem is that the officer waited on it.
I'm sorry?
I said the problem is the officer waited on it. And to allow the dog to sniff around the neighborhood or the whole vicinity, that is a different investigation again. Whether it's the gray car that the officer is investigating or the whole neighborhood he's investigating.
Even under Rodriguez versus, United States versus Rodriguez, or Rodriguez versus United States, I should say, officers may briefly prolong traffic stops or to conduct these types of inquiries so long as the officer performs his task in an amount of time reasonably needed to effectuate a law enforcement purpose. So what's the law enforcement purpose is that 9 minutes later he brings the dog out.
Your Honor, what is not a law enforcement purpose, and give me a moment, I'll find you another case that says this, is that an officer is stepping outside of his official duties if he starts stepping into another investigation. Your Honor, the Rodriguez explains the two different type of ways that an officer can prolong a traffic stop for this exact purpose. One, prolonging a traffic stop is, for example, like waiting on a canine. That's one way of prolonging a traffic stop. And the second way of prolonging a traffic stop is investigating another matter. That's exactly the two scenarios that Rodriguez explains, and in both of them explain that you can't do it. The officers simply cannot do it. They cannot prolong the stop when the stop can be wrapped up, which it could have here. The officer is not actively closing out the matter that the marijuana in the white car. He's not actively doing that. He's sitting around waiting, and he can't do that with Nichols. He can't sit around and wait with Nichols detained. That's the whole point. And he definitely can't start investigating another matter with Nichols detained. That's the second whole point. And that's why the court in Royer and in Rodriguez explains these exact two type of scenarios, is because this is when it happens. When the officer is part of one investigation and kind of gets deterred and starts doing something else, and this is exactly what he did here.
But he came out there to begin with based upon the Instagram posts of your client purportedly having some type of drug. That was his purpose to begin with.
Understood. And so I don't know if you want me to argue that again, but
no, I'm good. I just want to make sure. All right.
Mm-hmm. That was his initial reason, and we've already argued because of the time that's not reasonable suspicion or probable cause. But as soon as the officer arrived, regardless, none of that was going on. And so when he gets there, Nichols is no longer in that car. He doesn't see Nichols with a bag of marijuana in his hand or anything else that he saw in the video, for that matter. He didn't see the red bag that he had saw before. The car's locked, the car's parked. So the officer gets there and none of that, is going on. So then the officer shifts to, I smell marijuana, and then he takes a few minutes and he closes that out because he actually locates it.
That was the first thing he said when he came to the scene.
Right, no.
No marijuana. I mean, which one of y'all smoking? That's what he says when he walks up originally.
Agreed. And when he couldn't find, after that disappointment of only finding Shake in the white car and not finding what he thought he saw on that video, he stopped dealing with the white car, and instead of processing Nichols and the young ladies that's what he was going to say, he didn't even bother bagging the Shake. Because when he didn't find what he saw in that video, he aborted that investigation, that mission, and basically had Nichols in handcuffs saying, stay put, while I go back to what I wanted to do, and which is a different investigation. That's the problem.
All right. Okay.
Thank you, Your Honor.
You're welcome, madam. All right. Ms. Hilton?
Yes, Your Honor. At an appropriate time, can I just run to the bathroom for about 30 seconds?
Yeah, do you want to go now or what?
Sure. Thank you.
Money's in that drawer.
You got money in here?
Yeah, $14.
All right, let's go, folks. Come on.
Your Honor, don't worry. This is literally... Oh.
resume argument at this one time, so. Yes, ma'am.
Your Honor, we did stipulate to the certification of the dog, but I was very, we're not going to stipulate to the reliability of the dog. And so, and this is what I was saying a little bit earlier, that the reliability is the burdens of the government. And so we're challenging the reliability of the dog, which is a serious issue. That's it, Your Honor. Thank you.
Are you going to need to provide some evidence about the reliability of the dog?
I think I have the argument, Your Honor.
Say again?
I don't think so, because the reliability is that he found the drugs. He sniffed and he hit on the car, and then when he hit on the car, there were drugs in the car and guns in the car that he hit on. So that is what we will argue is the reliability of the dog, which is the fact that they found the drugs in the car. Your Honor, just very briefly, just a little bit more about the facts, I think. It's kind of needs to be addressed. So Sergeant Ross testified, I believe he said he worked the 4 to midnight shift at this point in time. So when he got to work, it would have to be between 4 and midnight. And so what he said is he saw the video while he was at work. So we can infer that it was after 4 o'clock p.m. Your Honor, this is around October 2018. When we see the Instagram video, as the court has already noticed, it is still dark outside. And when they get to 2612 Steele Avenue, it's still dark outside. So you know that this happened between 4 and midnight. What we know also is that he said the staging location was literally right across the street. He may have said the Piggly Wiggly, but if not, it was right across the street from 2612 Steele Avenue. So it's not like the staging location was very far away from where they entered into it. So first things first, Your Honor, when Sergeant Ross sees the video, he sees Mr. Nichols, and you see it, Your Honor, as well in the video, Your Honor, bagging up what he knows, or it appears to be from his knowledge, training, experience, marijuana, in the fashion that people who are selling marijuana bag up the marijuana. He then stages it, goes over, and is investigating it. As soon as he gets out of the vehicle, he smells marijuana and begins his investigation. We had this conversation about it being a prolonged stop. This is not a traffic stop. This is him going to an apartment complex, seeing...
What is his probable cause of reasonable articulable suspicion?
His reasonable articulable suspicion is the smell of burnt marijuana. When he gets out, he immediately says, I smell marijuana out here. He walks over to the vehicle and says, who's smoking? I smell the burnt marijuana. So he goes over to investigate because he sees what he knows to be 2612 Steele. He sees Mr. Nichols bagging up the marijuana, so he goes over to investigate whether it's Mr. Nichols with the marijuana, what's going on over here. Once he gets there, he smells burning marijuana. Like, he walks up and he smells it. He asks what's going on. The door to the Solera is open. Mr. Nichols is now sitting kind of like in the doorway of the Solera, and he says, I smell the marijuana. And that's when he begins detaining everyone. As he detains everyone, he goes over to the side. He sees the marijuana cigarette on the ground. He identifies it. He says, all right, I'm going to search the vehicle. Does the search, sees a shake. At that point, he's allowed to go and get a canine, which is exactly what he did. And here's where the case law is important. The odor of marijuana alone may provide probable cause for a warrantless search of an automobile. And we're going to get there because he didn't even do a warrantless search of it. State of the gray vehicle, which is the vehicle in contention. The dispositive issue is whether the officer smelled marijuana prior to completing his investigation to the traffic violation. Again, most of the prolonged cases are all about a traffic violation. So, for example, in our 2017 case, do they stop the car for a traffic violation that end up doing something else? Here, when the officer goes over there, it is for the purpose of investigating whether or not there's marijuana. So that is why he goes over there. He smells the marijuana and goes and does an open air sniff. Here it says, we observed, Officer Ross not only observed Mr. Nichols in possession of marijuana, while watching the video, he smelled both burning and raw marijuana emanating from the area of both the white Toyota as well as in the close vicinity to the gray Sonic in which he had previously saw Mr. Nichols in. Also, and I can't recall if this testimony came out, so I'll defer to the court if it did not, but he may have testified, and it might be from the police report, that he smelled a masking agent, like perfume in which, okay, he didn't testify to that, okay. So, at that point, once the K-9 does the open air sniff and hits on the hits on the gray vehicle, he then gets a search warrant. Here, conducting an open air dog sniff around a vehicle during a traffic stop, again, does not violate the Fourth Amendment. The K-9 unit, it possibly alerted on the gray Chevrolet. At that point in time, the officer didn't just go into the vehicle, they obtained the search warrant. Once obtaining the search warrant that has the probable cause listed in there, a magistrate heard evidence, the magistrate was able to make a determination, he comes back, and there is a search of the vehicle only at that point in time. So they didn't even have the K-9 hit and they immediately go into the vehicle. Although they had the keys and opened up the door, they said, no, we're going to take a step back. We're going to go get a search warrant. And they came back, searched the vehicle, and found the drugs that were contained in the vehicle, as well as the 2 stolen guns and the 3rd gun, Your Honor. Again, everything else, Your Honor, that the state is going to say, we'll rest on our motion, but we would ask that you deny Mr. Nichols' motion. This was not a prolonged stop. It took from the time the officers got there and he began speaking with Mr. Nichols to the time that the K-9 came out, and then they searched the vehicle. It was not a prolonged stop. Specifically, something. Your Honor, again, we would just contend that this motion should be denied.
Okay, in considering the 2018 case involving the particularized motion to suppress evidence and or other review filed on the 8th of November of this year, involving a stop that occurred on the 23rd of October 2018. The defense asked this court to suppress evidence that was seized in violation of Mr. Nichols' rights under the 4th and 14th Amendments, the Constitution of the United States, and Article 1, Section 1, Paragraph 13 of the Georgia Constitution of the State of Georgia, 1983, in that they asked this court to allege that the arresting police officers constituted unreasonable unlawful search and seizure. The factual predicate that the court's taken into consideration is as follows. The court's taken consideration of Officer Now, Sergeant Ross's activities on October the 23rd. He was in fact out working the evening shift. He observed an Instagram page, saw a video, social media platform where he allegedly observed Mr. Nichols sitting inside a gray Chevrolet side, and he, Instagram video alleges or shows that Mr. Nichols is tying a bag of what appears to be marijuana in a small sandwich bag. At some point in time, as a result of this, Officer Ross knew where the location where Mr. Nichols was in the local area. He'd been there before, he was familiar with that area, and went to that location at 2612 Steel Avenue. He went ahead and staged, got officers there at the location, and observed the gray Chevrolet Sonic in a parking spot, which he observed an Instagram video. This, however, were multiple individuals sitting on the trunk of the vehicle, not Mr. Nichols. As officers drove up inside the parking lot, the gray sign was allegedly locked remotely, causing the front headlights to flash the horn sound. Upon driving out, also was noticed a white Toyota Solera. Officer Ross exited his police vehicle and noticed, as is evidence from his body cam video, the smell of burned marijuana coming from the area. Him asking who's smoking marijuana. Mr. Nichols was found at that point in time in the driver's side door frame with a white Solera along with two females. All of these particular individuals were detained for Officer Ross to conduct an investigation, and at some point in time, the owner of the vehicle, Jessica Lindley, did not advise, she did not know who the keys in the center console belonged to or how they got into her vehicle. While at the scene from smelling marijuana, and it looks like from looking at states, the court's also considered for purposes of motion. The video, Instagram video, as well as Officer Ross's body cam video. And from looking at that video, that body cam video, Officer Ross arrives on scene. About 2 minutes and 37 seconds in, he detains Mr. Nichols at about 3:07, and these are rough estimates as to time. He removes the other occupants. About 4 minutes in, he observes the blunt and the shake, small granules of marijuana. About 5:07, he opens the center console and sees the car keys to the other vehicle. About 5:40 or thereabouts, because he smelled marijuana, he calls for a canine. About 7:24, he takes Mr. Nichols to the patrol car. At 16 minutes or thereabouts, the dog is on scene. The dog walks throughout the area where the parties are located that have been detained. The white Toyota Solero, and the gray Chevy Sonic, and the dog alerts on the gray Chevy Sonic. As a result, the testimony is that then Officer Ross went ahead and got a search warrant based on the open air sniff of the dog, which the defense has agreed that stipulate as to certification. They did not stipulate as to reliability. The court finds it from looking at the video as well as the dog's alerting on the calling of the dog from the facts and circumstances is reliable. The defense also I do find that Mr. Nichols has standing. I do find he is not a human being. I do find that the Officer Ross does have a probable cause for reasonable suspicion, particular suspicion, based upon his watching of the Instagram video. And then coming to the location where at 16 12 still acting, which he knows from being a patrol officer in that particular area. The court does not find that the time period of delay is excessive. It's based upon his investigation. The court does not find that the detention is prolonged, and that as a result of those findings, the court will deny the defendant Nichols' motion to suppress as it pertains to the October 23rd, 2018 stop, or I should say, or incident. So, ladies, that is Ms. Silverman and Ms. Love. You would have a suitable order for the court's consideration on both the stops, the 2017, July 3rd, 2017, as well as this October 23rd, 2018. You can have it done by Monday, if that's sufficient. Monday the 27th?
Yes, it will.
Make sure you send that to Ms. her perusal and comment. Okay. Folks, we'll pick up, I think we have some other just ancillary business we can take up tomorrow morning, starting at 9:30. So we'll go ahead and I'll run the list of things that are outstanding at that point in time, and we can take those up starting at 9:30.
Judge, I'm sorry, can you cut your microphone on and repeat that for me, please?
No, you're not getting a bathroom break. Did you hear that?
I heard that.
Okay, all right. 9:30 tomorrow morning is when we will reconvene, and I'll take up the small list of things that we have to cover at that point in time.
Thank you.
That's all I said.
Thank you.
Okay, no problem. I'll run the list tomorrow morning, and we'll take up those things accordingly. So any other questions or any other ministerial from me? Did you have a question, Mr. Shard?
I do. It was stated, I believe last week, that we would have a witness list, pared down witness list.
I told you we'd take that up tomorrow morning.
Okay, I didn't know if that was on the
Yeah,
list.
that's on the list. Oh, yes, it'll be on the list of things to do tomorrow.
Okay.
Okay? All right. I'll run the list first thing tomorrow morning, are the things that I want to talk about. But yes, that was one of the things we were supposed to talk. That was one of the things we were supposed to talk about today. Sorry for my turn my back on you all. And we'll cover that we'll cover that tomorrow morning. Okay? Anything else? All right. I'll see you all tomorrow morning at 9:30, and we'll cover the witness list, the GCIC issue. I think there's a motion to redact the indictment and some 418 stuff, and I need to actually go back to a couple of things about Dr. Dunbar and Mr. Steele. So that's the list I have for tomorrow. So we'll see each other at 9:30 in the morning, 1C, okay? All right, see you then.
Thank you, Your Honor.
All right.
Thank you, Ms. Weaver.